Good afternoon, friends. Yeah, right. So, as part of our current affairs discussion, in this session, we will discuss about the polity and international relation topics of these 2 months, right? October and November of 2022, right? So, the first topic is Supreme Court's split verdict on Karnataka hijab ban, right? We have already discussed one important issue with respect to this hijab ban related content, right? What kind of discussion we have this? What kind of topic we have discussed with respect to hijab ban? இதுக்கு முன்னாடி என்ன பார்த்தோம்? Any idea? One principle is associated with that, right? I think in our first class of current affairs, we have discussed about it. Principle of reasonable accommodation. Do you remember what we have discussed? What does that principle of reasonable accommodation mean? எதை பேஸ் பண்ணி சொல்லியிருந்தாங்க? Right. Okay. So one of the judges of Karnataka High Court have referred that, or one of the petitioners, advocates or petitioners from the petitioners, they have said that in South Africa, the same kind of hijab issues was addressed through that principle of reasonable accommodation. If any religious practices is to be considered as part of their religious aspects, means that can be practiced, or that can be the hijab can be weared in the public institutions itself. So on the basis of the principle of reasonable accommodation, in South Africa, the judgment was given in favor of wearing hijab in the educational institutions, but that was not accepted by our court, right? In this case, we are also talking about another important concept called as split verdict. This is a simple concept, right? So normally, whenever a case is referred to a bench of judges apart from a single judges, especially in the cases of High Court and Supreme Court, if that bench consists of even number of judges, means 4 judges irukangana, when the judgment is given by all the 4 members in an equal proportion, and whether 2 persons judgment is for the case or against the case, you cannot conclude at anything, right? So only if you take the case of any even odd number of judges irukkudiya bench la you can arrive at majority based judgment. Even if you take the case of Sabrimala case or some other cases in the recent times, everything has consisted of odd number of judges in its bench. So on the basis of majority, you can arrive at a conclusion. But there are certain benches which have even number of judges. In that case, when the judgment is equally divided between 2 sections of the benches, means that could be called a split verdict. Okay, the split verdict, right? So in the recent hijab case also in the Karnataka High Court, the judgment was given by equal number of judges for and against. Then if what will happen if a judgment of High Court would result in split verdict, means definitely it should be referred to a larger bench, or it should be referred to the Chief Justice of India. That is the case whenever a split verdict has been announced. Okay, wow. So the Supreme Court delivered a split verdict in the Karnataka hijab ban case, directing the matter to be placed before the Chief Justice of India for appropriate directions, right? So split verdict na idhan therinjuma. A split verdict is passed when the bench cannot decide one way or the another in the case by a majority verdict. So split verdict can only happen when the bench has even number of judges. What to do when the split verdict, what to do after the split verdict, means it should be referred to a larger bench, or it should be referred to the Chief Justice of India, right? In this case or in any other case, if a case is to be addressed by a bench of judges, means the allocation of judges for those specific cases is automatically, or has to be mandatorily done by Chief Justice of India. Appadi and the role our pannarna, that is called as master of roster. So for the case of India, who is considered to be master of roster na? Chief Justice of India alone. ஓகேவா? அதுல ரோஸ்டர் அப்படின்னா ரோஸ்டர் means the allocation of task for different peoples based upon their efficiency. So it is the capability of allocation of division of labor தான். ஓகேவா? So அந்த மாதிரி master of roster is the term which refers to the allocation of judges for any benches, right? And it has to be done only by Chief Justice of India, not by the decision of a majority or not by the decision of the collection of Supreme Court judges. அப்படின்ற போது here Chief Justice of India has the discretionary power. அதுதான் இங்க நீங்க கவனிக்க வேண்டிய விஷயம். So chief master of roster யாருன்னா was none other than Chief Justice of India. ரைட்டா? So அந்த மாதிரி இதுக்கு கேஸ் போயிட்டு then after that our Chief Justice have delivered the judgment in favorable of banning of hijab. அது வேற கணக்கு. பட் அதுல நம்ம பிரின்சிபல் ஆஃப் ரீசனபிள் அகாமடேஷன் பார்த்தோம். இந்த முறை ஸ்பிளிட் வேர்டிக்ட்னா என்னன்றதுக்கான கான்டெக்ட் அண்ட் மாஸ்டர் ஆஃப் ரோஸ்டர் அப்படின்னா who it is referred to and what is the meaning behind the context called as master of roster. ஓகேவா? ஸோ அதை தான் பார்த்துக்கணும். அதுல இன்னொன்று ஒன்று என்னன்னா the provisions, இதுக்கான provisions, right? I mean it is not with respect to the split verdict, it is with respect to the decision making authority regarding the allocation of persons with respect to different benches. ஓகேவா? அந்த மாஸ்டர் ஆஃப் ரோஸ்டரா சிஜேஐ தான் இருக்கணும்ன்றதுக்கான ப்ரொவிஷன் it was not directly given in the constitution, right? But that power is derived from the article of a constitution, right? Which article is talking about means it is article 145. Do you understand what I'm saying? Right. On the basis of article 145, the constitution specifically empower the chief justice to nominate benches for hearing cases or appeal. Apo what does it signify? It is chief justice of India's responsibility and it is the capacity of Chief Justice of India alone to allocate the persons regarding the benches for any kind of appeal or any kind of cases with respect to that, right? அந்த ஆர்டிக்கலுக்காக கொண்டு வரப்பட்டது தான் சுப்ரீம் கோர்ட் ரூல்ஸ் 2013. So the provisions of Supreme Court rules 2013 empowers Chief Justice of India to allocate cases exercising his discretionary power. This discretionary power is derived from Article 145 of our Constitution. So the function of Chief Justice as Master of Roster has derived or the powers to function as Master of Roster has derived from both Constitution of India as well as rules of Supreme Court. இது ரெண்டுல இருந்துமே அவர் derive பண்ணிருக்கார். But it is not directly been defined in the Constitution. அதனால தெரிஞ்சுக்கணும். ஓகேவா? That kind of statements will always been put in the preliminary question papers, right? அதை புரிஞ்சுக்கணும். Right. இதுல we have talked about the allocation of judges with respect to any cases with respect to the interpretation of constitution in our previous class, right? ஒரு constitutional judicial review base பண்ணி if a bench has to be allocated that deals with any of the amendment with respect to constitutions or any of the cases which is affecting the base, which is related to the basic structure of our constitution, na minimum number of judges constitution bench nu allocate pandromna what is the minimum number of judges has to be there? 5 judges has to be there, right? And the 5 judges yaarundradha allocate pandradum CJI through the role of master of roster. But it is not the case for other I mean it is not compulsory for other cases to have minimum 5 judges, but for constitution 5 and more 9 வரைக்கும் போனா 9 judge bench வரைக்கும் இருப்பாங்க. ஓகேவா? minimum 5 judges இருக்கு. Out of that 5, based upon the majority verdict, the interpretation of the constitutions will be decided. These are all the important things you have to note with respect to this particular topic. ஓகேவா? அதுல இன்னொன்னு என்னன்னா the function, I mean the Supreme Court also held that Chief Justice is in his individual capacity is the master of roster and it cannot be read as collegium. So the responsibility of Chief Justice of India as a part of collegium is completely different from master of roster. Collegium adula vandu paathomna it is not the discretionary power of CJI. Collegium consists of CJI along with the other senior most judges of the Supreme Court, and by the collective decision making it is like the Council of Ministers. by collective decision making based பண்ணி மட்டும்தான் appointment of judges will be there. Appointment of judges will not be done on the basis of CJI functioning as a master of roster. Appointment, transfer அல்லது promotions இது எல்லாமே based upon the decisions of collegium. But allocation of judges with respect to different benches is done by Chief Justice of India alone. These are the two important points you need to know with respect to this particular topic. Okay, va? Then, while discussing about the hijab issue in the previous class, I have told about one particular doctrine. Any idea about that doctrine? Doctrine of essentiality, right? So that doctrine of what does the doctrine of essentiality mean with respect to religion has been clearly defined through an important case called as Shirur Mat case of 1954. Okay, va? So Shirur Mat case of 1954. So, doctrine of essentiality was invented by a 7-judge bench of the Supreme Court in Shirur Mat case. Adil enna sollirukanga, because we know that any practices, everyone has the right to freedom of religion. Everyone has the fundamental right to practice, profess and propagate, right? Practice wearing hijab or wearing a traditional, religious based dresses is part of their fundamental right. But in the public places or in public institutions, to what extent you can hold up that fundamental right of freedom to religion and rather define பண்றது தான் doctrine of essentiality, right? So if a practices or if a rituals or if any kind of thing which is with respect to religion is considered to be essential practices அப்படின்றத, it is based upon the religious law or religious code பண்ணி decide பண்றதா doctrine of essentiality. புரியுதுங்களா? இப்போ இதுல என்ன சொல்லிருக்காங்கன்னா, wearing hijab on the basis of Quran is not to be considered as a essential practice. Puridhingala, it is not directly mentioned in the Sharia law or in the Quran, so it could not be considered as the essential practices of the religion, so that the state or the judiciary has the right to put a ban on wearing hijab in the public education institutions, because it is not comes under the doctrine of essentiality ன்றதா இதுல சொல்லி இருக்கக்கூடிய judgment. புரியுது என்ன சொல்றேன்றது? Right. That doctrine of essentiality என்னன்றத define பண்ண case தான் Shirur Mat case of 1954, right? It is a contentious doctrine evolved by the court to protect only such religious practices which are essential and integral to the religion, right? The court held the term religion will cover all the rituals and practices integral to a religion and took upon itself the responsibility. Itself, na court took upon the responsibility of deciding what practices of the religion should be considered under doctrine of essentiality. That too, they cannot decide on their own discretion. They will follow the principles and procedures of the private affairs or private law of the religion. அந்த ரிலீஜனை பேஸ் பண்ணி இருக்கக்கூடிய கோட்ஸ் அண்ட் லாஸை பேஸ் பண்ணி தான் they will define what is called as they will propose that what is called as essential practice or not. அது பிரகாரம் பார்க்க போகும்போது wearing hijab is not comes under the doctrine of essentiality, so that government has the power to put a ban on it அப்படின்றது தான் finally Supreme Court has given its verdict. அப்ப இதெல்லாம் தான் you have to note out from the examination point of view. ஓகேவா? doctrine of proportional representation, principle of reasonable accommodation, split verdict, doctrine of essentiality. இதெல்லாம் தான் இம்பார்ட்டன்டான பாயிண்ட்ஸ், ரைட்டா? தென் இதுக்கு எகெயின்ஸ்டா இன்னொரு ஒரு விஷயம் இருக்கு. In the judgment, during the judgment, one of the judges who have favored the practices of hijab, they have quoted in their judgment one of the important famous case called as Bijo Emmanuel case. So what does that Bijo Emmanuel case intrada for the examination point of view we have to know. இது அப்படியே opposite to the hijab result. ஓகேவா? என்ன சொல்லிருக்காங்கன்னா, 1986 Supreme Court bench had in Bijo Emmanuel's others versus State of Kerala granted protection to 3 children of Jehovah Witness sect. It is a sect of Christianity. ஓகேவா? Especially they are not completely considered to be the part of Christianity. This sect has been considered in between Jews and Christianity. ஓகேவா? ஜூஸ்ன்றவங்க கிறிஸ்டியன்ஸா இருக்க மாட்டாங்க. கிறிஸ்டியன்ஸ்ன்றவங்க ஜீசஸ் கிரைஸ்ட தன்னுடைய கடவுளை எடுத்துக்கிட்டவங்க. பட் ஜூஸ்ன்றவங்க அதுக்கு முன்னாடி இருந்தவங்க. ஓகேவா? ஈவன் ஜீசஸ் கிரைஸ்ட் இஸ் அ ஜூ. பட் இந்த ரெண்டுக்கும் மிடில் இருக்கவங்க இவங்க என்னன்னா they consider the holy nature of Jesus Christ, but they did not regard him as the God. Jesus Christ has a father, and that father is called as Jehovah. அதை ஃபாலோ பண்ணக்கூடிய தனி செக்ட் இவங்க. அப்ப இந்த செக்டோடைய பேசிக் ரைட்ஸ் படி அவங்களுக்கு என்ன சொல்லியிருந்தாங்கன்னா, ஸ்கூல்ல நேஷனல் ஆந்தம் பாட சொல்ல போகும்போது they never, the national anthem வந்து it is a kind of prayer song, right? It has certain religious elements within itself, so they restrict themselves not to sing the national anthem in the common prayer. அதுக்கு எகெயின்ஸ்டா ஸ்கூல் அவங்களுக்கு எகெயின்ஸ்டா டெசிஷன் எடுக்க போகும்போது their fathers, 3 children, அவங்க 3 பேர் அண்ணன் தங்கச்சி 3 பேர் இருப்பாங்க. அவங்களுடைய ஃபாதர் வந்து they have put a case on high court. அது சுப்ரீம் கோர்ட்டுக்கு போயிட்டு பெரிய கேசஸா ஃபைனலா வந்துச்சு. அதுல என்ன சொன்னாங்கன்னா, it is against the 2 fundamental rights. அதுல என்ன சொல்லியிருக்காங்க, சுப்ரீம் கோர்ட் என்ன சொல்லியிருக்காங்கன்னா, yes, not to sing a prayer song on the basis of their right to religion is part of their fundamental right, but they have to respect it. They can stand and be attentive to the national anthem, but they have the right not to sing the national anthem ன்றது சுப்ரீம் கோர்ட்டே சொல்லியிருந்துச்சு. அப்படி ஆப்போசிட்டா அப்ப சொல்லியிருந்து இப்ப இப்படி ஆப்போசிட்டா சொல்லுது. ஓகேவா? அந்த கேஸ் தான் பிஜோ இமானுவல் கேஸ் புரியுதா என்ன விஷயம்ன்றது? ரைட். Who didn't join in the singing of the national anthem at their school, the court held that forcing the children to sing the anthem violated their fundamental right to religion. அது மட்டும் கிடையாது, it is also the violation of Article 19. They have said that it is a violation of both Article 19 as well as Article 25, because on the basis of Article 25 they can practice, profess and propagate இருக்குல்ல, அதுல practicesல prayers is a form of practice. அந்த prayerன்றது on what basis they believe to themselves as the God, they can pray for them, but it is not necessary to pray for some other religion based elements. அப்போ right to practice கீழ fundamental right under Article 25 கீழயும் protect பண்ணப்பட்டிருக்கு. Freedom of speech and expression is a way of expressing things. அந்த இடத்துல not to sing is part, right to be silent is also part of the right to freedom of speech and expression, right? Article 19 pragaram it has been protected. So on the basis of 2 fundamental rights, Bijoy Emmanuel case has provided the judgment in favor of the religious sect. Okay va? So therefore Emmanuel case has made other pertinent remarks on the freedom of speech and expression and the right to practice and propagate one's religion. So therefore find the fundamental rights of appellants under Article 19(1) subclass A and 25 subclass 1 have been infringed and they are entitled to be protected. Okay, idhula first 19(1) subclass A is the freedom of speech and expression, then 25 la first the right to practice and propagate. Okay, இது ரெண்டுமே protect பண்ணிக்கிறதுக்காக they have delivered a judgment. இதுக்கு அப்படியே against ஆன opposite ஆன ஒரு விஷயம் தான். ஈவன் இந்த இடத்துல they have not talked about the doctrine of essentiality. இந்த இடத்துல பிராக்டிஸ் பண்றதுன்றதை எடுத்திருக்காங்க, பட் ஹிஜாப் கேஸ்ல டாக்டரின் ஆஃப் எசென்ஷியாலிட்டி எடுத்திருக்காங்க. இந்த மாதிரி சுப்ரீம் கோர்ட்டோட ஜட்ஜ்மெண்ட்ஸே கேஸ் பை கேஸ் மாறிக்கிட்டே இருக்கும். ஓகேவா? ஸோ திஸ் திங் யூ ஹாவ் டு நோட் வித் ரெஸ்பெக்ட் டு தி பிஜோ இமானுவல் கேஸ். தென் அடுத்தது ஹேட் ஸ்பீச். யூ வுட் ஹவ் ஹியர்ட் அபவுட் திஸ் கான்டெக்ஸ்ட் நியூமரஸ் ஆர்டிகல்ஸ் அண்ட் நியூஸஸ் சோஷியல் மீடியால எல்லாத்துலயும் வந்திருக்கும். பிரின்சிபல் ஆஃப் ரீசனபிள் அகாமடேஷன்னா without considering any other rules and regulations, if that practice has to be accommodated in the public spaces, right? Because they give primacy to their right to religion. So அப்போ அகாமடேஷன் என்னது ஏத்துக்கொள்றது, சில முக்கியமான ரீசன்ஸ் அடிப்படையா வச்சு அவங்களோட பிராக்டிசஸ் பப்ளிக் பிளேசஸ்ல ஏத்துக்கிட்டோம்னா that will be called as principle of reasonable accommodation. To some extent that can be said on the basis of பிரின்சிபல் ஆஃப் நேச்சுரல் ஜஸ்டிஸ் கீழே வரலாம். இப்போ ரூல் ஆஃப் லாக்கு கீழே நம்ம வரோம்னா ஸ்ட்ரிக்ட் ரெப்ரசன்டேஷன் ஆஃப் ரூல் ஆஃப் லா இருக்கும். பட் பிரின்சிபல் ஆஃப் நேச்சுரல் ஜஸ்டிஸ் அல்லது டியூ ப்ராசஸ் ஆஃப் லான்றது என்னது, சில இடத்துல லா கேன் பி மாடிஃபைட் பேஸ்ட் அப்பான் தி பிரின்சிபல் ஆஃப் நேச்சுரல் ஜஸ்டிஸ்ன்ற மாதிரி. அந்த மாதிரி தான் பிரின்சிபல் ஆஃப் ரீசனபிள் அகாமடேஷன்ன்றது Yes, wearing hijab is part of their belief, and their belief is part of their right to religion. So that can be accommodated in the public spaces. அப்படின்னு ஒரு பிரின்சிபலை எடுத்து ஜட்மெண்ட் வாஸ் given. ஸோ அதே பிரின்சிபலை ஃபாலோ பண்ணி நம்ம இங்கேயும் அதுக்கு அலோவ் பண்ணலாமேன்ட்டு ஜட்ஜஸும் அல்லது அந்த அட்வொகேட்ஸும் சொன்னதுனால அந்த டேர்மை பத்தி என்ன நம்ம தெரிஞ்சுக்கணும். ஓகே, ரைட். ஹேட் ஸ்பீச். ஸோ த சுப்ரீம் கோர்ட் ஈவன் our Chief Justice of India directly said that you have to take certain important measures with respect to hate speeches, especially from the politicians and other peoples who are involved in the politics. Okay, wow. Supreme Court directed the police and authorities to immediately and suo motu register cases against the hate speech makers without a complaint to be filed என்றத சொல்லியிருக்காங்க. அப்போ இந்த இடத்துல in general what is hate speech, and is there any definition with respect to hate speech in our constitution, and if there is some definition means where it has been given and what are all the penal provisions for hate speech. இதெல்லாம் தான் நம்ம examination point of view ல பார்ப்போம். ஓகேவா? In general, what do you understand by hate speech? It refers to the words whose intent is to create hatred towards a particular group. That group may be a community, or that may be against a particular person, group, religion, community, or races. The speech may or may not have meaning, but it is likely to result in violence. அதுக்கு மீனிங் இல்லைனாலுமே the intention of that speech maybe it do not have any direct representation of the religion or direct representation of the community, but that speech would result in the incitement of violence means that could not be regarded as the part of right to freedom of speech and expression. அதனோட கான்சிக்வன்ஸ் வயலன்ஸோட ரிசல்ட் பண்றதா இருந்துச்சுன்னா that can be considered as hate speech. In general, it is the meaning of hate speech. But in principle, நம்மளுக்கு இதனோட டெஃபினிஷன் எங்கெங்கெல்லாம் கொடுத்திருக்காங்கன்றது பார்ப்போம். ரைட்? In constitution we do not have any direct definition for hate speech, but according to law commission, hate speech generally is an incitement to hatred primarily against a group of persons defined in terms of race, ethnicity, gender, sexual orientation, religious belief and the like. அப்போ இந்த ரெஃபர் பண்ணி if any speech is pointing to those peoples, then that could be called as hate speech, right? But on the basis of these references, no one could be identified in a differentiated manner என்றதுக்காக கொடுக்கப்பட்டது right to equality, right? A prohibition of discrimination on the basis of religion, race, sex, place of birth or caste என்றது எல்லாமே அந்த பேசிஸ்ல அவங்களை இன்ஸ்டிகேட் பண்ற மாதிரி சொன்னோம்னா that could be called as hate speech என்றது law commission சொல்லியிருக்கு. அப்போ through this definition you can refer it to the right to equality. புரியுது என்ன சொல்றேன்றது? அந்த மாதிரி தான் நம்ம எடுத்துக்கணும். ஓகேவா? So this hate speech is any word written or spoken, signs, visible representations within the group or sight of a person with the intention to cause fear or alarm or incitement to violence. Incitement to violence என்றது it is directly been put as a reasonable restriction on article 19(1) subclass A. கொஞ்ச நேரத்துக்கு முன்னாடி பார்த்தோமா freedom of speech and expressionல reasonable restrictionல if that speech would result in the incitement toward violence means that is considered to be a reasonable restriction. அத பத்தி இருக்கக்கூடாது. அப்ப அதை தூண்டக்கூடிய வகையில ஒரு ஸ்பீச் இருந்துச்சு that could be called as hate speech. ஓகேவா? இதே அதுக்கான பெனால்ட்டியை டிஃபைன் பண்றதுக்கு பியூரோ ஆஃப் போலீஸ் ரிசர்ச் அண்ட் டெவலப்மெண்ட்லயும் அதுக்கு ஒரு டெஃபினிஷன் கொடுத்துருக்காங்க. என்ன? a hate speech as a language that denigrates, insults, threatens or targets an individual based on their identity and other traits, right? Sexual orientation, even LGBTQ community is also been considered as their fundamental rights. அப்போ அது disability, religion இது பிரகாரம் எதுவா இருந்தாலுமே that could be called as hate speech. ஓகேவா? அப்ப hate speechக்கான டெஃபினிஷன் கான்ஸ்டிடியூஷன்ல டைரக்டா கிடையாது, but through other means it has a definition, right? அப்ப இது கூட இன்டைரக்டா நம்ம எது கூட ஃபண்டமெண்டல் ரைட்டோட கனெக்ட் பண்ணோம்? ஆர்டிகல் 19 of our constitution, especially 19(1) subclass 1. Reasonable restrictions in the interest of sovereignty, integrity of India, security of the state, friendly relations with foreign states, public order, decency or morality, or in relation to contempt of court, defamation or incitement to offense. இது டைரக்டாவே ஆர்டிகல் 19ல சொல்லப்பட்டிருக்கக்கூடிய reasonable restrictions. அப்ப hate speech ஓட resultant you can directly connect it to the component of reasonable restriction of article 19. அப்போ on the basis of fundamental violation of fundamental rights, you can directly arrest a person who had involved in the hate speech. ஓகேவா, அதுதான் நம்ம பார்த்துக்கணும். இதுக்காக we have two provisions in our IPC also. Section 295A defines and prescribes a punishment for deliberate and malicious acts intended to outrage religious feelings of any class by insulting its religion. ஓகேவா, அதுக்கப்புறம் section 153A of IPC, promotion of enmity between different groups on grounds of religion, race, place of birth, residence, language, etc., and doing acts prejudicial to maintenance of harmony is a punishable offense. ஓகேவா, ஸோ இப்போ ஹேட் ஸ்பீச்சுக்கான டெஃபினேஷன் எங்க இருக்கு, என்ன இருக்கு, அதோட ரிலேட்டா இருக்கக்கூடிய ஃபண்டமெண்டல் ரைட் என்ன, அதுக்கான பீனல் ப்ரொவிஷன்ஸ் என்னென்ன, இந்த அளவுக்கு மட்டும் எக்ஸாமினேஷன் பாயிண்ட் ஆஃப் வியூல பார்த்துக்கணும். ஓகேவா, தென் யூசிங் தீஸ் ப்ரொவிஷன்ஸ் யூ கேன் make it useful for the mains related aspects. Right. Then sealed cover jurisprudence, idu news la irundittu irundhathu, right? Even as I said, Chief Justice of India is also against this concept of sealed cover jurisprudence. Appadina enna, any idea about that? Some of the facts and informations which could be covered under the seal, which could not be revealed to anyone or public or even to the advocate who was part of that cases, it could be accessed only by the judges of that case. அப்படி இருக்க அப்ப அந்த இடத்துல என்ன வருது, ஆட்டோமேட்டிக்கலி lack of transparency, ரைட்டா? ஸோ அப்போ ஒரு கேசஸ்ல ஏதாவது ஜட்ஜ்மெண்ட் கொடுக்கறதுக்கு முன்னாடி அது ரிலேட்டடான ஏதாவது ஒரு சீக்ரெட்டான இன்ஃபர்மேஷன் ஜட்ஜஸ் மட்டும் தான் பாக்குற மாதிரி இருந்துச்சுன்னா, how far we can believe in the analysis of the judge in delivering the judgment. While delivering the judgment, the judge has to give clear explanation about on what basis he or she had decided for that case என்றத சொல்லணும்ல. அந்த இடத்துல இந்த facts and figures பேஸ் பண்ணி சொல்லலன்னா that could be against the transparent functioning of the judiciary. But it is existing in அதுதான் sealed cover jurisprudence ன்னு சொல்றோம், right? So it is a practice used by the Supreme Court and sometimes lower courts of asking for or accepting information from government agencies in a sealed envelopes that can only be accessed by judges. Even the advocates could also could not be allowed to go for the informations unless it is been allowed by the judges. Judges அதுக்கான permission கொடுத்தா மட்டும் தான் அதை access பண்ண முடியும். ஓகேவா, இதுக்காகன்ட்டு sealed cover jurisprudence-ன்றத practice பண்றதுக்குன்னு we could not have any specific law. ஓகேவா, so while a specific law does not define the doctrine of sealed cover, நான் ஏற்கனவே சொன்ன மாதிரி the power to the power to have this practice of sealed cover jurisprudence is taken from the Supreme Court rules itself. ஓகேவா, Supreme Court derives its power from the Supreme Court rules and section 123 of the Indian Evidence Act. Indian Evidence Actல ஒரு provision இருக்கு. அந்த provision படி, for example, if any information is considered as an evidence which is not published by the government, if any information is taken by the advocate or common people to submit it as an evidence which is not published by the government or the associated authority, means that cannot be taken as a evidence-ன்றது தான் இந்தியன் எவிடன்ஸ் ஆக்ட்ல அந்த ப்ரொவிஷன் சொல்லிருக்காங்க. என்ன சொல்றேன்னு புரியுதுங்களா? இப்போ ஒரு விசில் ப்ளோவர்ஸ் ஆக்ட் எல்லாம் இருக்குல்ல, விசில் ப்ளோவர்ஸ் மாதிரி ஒரு இன்ஃபர்மேஷனை கவர்மெண்ட் பப்ளிஷ் பண்ணாத, பப்ளிக்ல போடாத ஏதாவது ஒரு இன்ஃபர்மேஷன் எடுத்து அதை ஒரு எவிடன்ஸா நீங்க கேசஸ்க்கு சப்மிட் பண்ணீங்கன்னா தட் இஸ் எகெயின்ஸ்ட் தி பிரின்சிபல் ஆஃப் எவிடன்ஸ் ஆக்ட். அப்படி பண்ணக்கூடாது. அப்படி பண்ணா அது கிரைம். unless it is published by the government or it is being given by that authority that you can use it as an evidence in sollada varaikkum you cannot take any information from the government side as a component of evidence for any case. That is against the principle of Indian Evidence Act. In the section la mattum appa Indian Evidence Act base panniyum Supreme Court rules base panniyum ipo that information can be accessed by judges but that could not be accessed by the common people. So the provision of practicing sealed cover jurisprudence has taken its role or taken its power from both Supreme Court rules as well as Indian Evidence Act. Statutory based provisions எடுத்துக்கிறாங்க. அதுதான் இதுல சொல்லியிருக்காங்க. ஓகேவா? So it is stated that the said rule, if the Chief Justice or the court directs certain information to be kept under sealed cover or considers it of confidential nature, no party would be allowed access to the contents of such information, except if the Chief Justice himself orders that opposite party be allowed to access it. But in the principle இருக்கக்கூடாதுன்றத CJA சொல்லிட்டு இருந்தார். This principle or this practices of sealed cover jurisprudence should not be continued further because it is against the transparent functioning of the judges. Okay, even the question of the problems with respect to collegium system, National Judicial Appointment Commission, அதெல்லாமே ஒரு பக்கம் there could not be any proper mechanism to deal with the problems with respect to judiciaryன்றத பத்தி பேசிட்டு இருக்க போகும்போது இதுவும் one of the issues நம்ம எடுத்துக்கலாம், ரைட்டா? எஸ்பெஷலி when we are talking about the doctrine of separation of powers. அந்த இடத்துல ஜுடிஷியரியோடைய ஹோல்ட லெஜிஸ்லேச்சருக்கும் எக்ஸிக்யூட்டிவ்க்கும் பெரிய லெவல்ல இல்ல. பட் ஜுடிஷியரி ஹாஸ் அ ஹையர் ரோல் வித் ரெஸ்பெக்ட் டு தி ஃபங்க்ஷனிங் ஆஃப் லெஜிஸ்லேச்சர் அண்ட் எக்ஸிக்யூட்டிவ். பட் ஜுடிஷியரியோடைய ஃபங்க்ஷனாலிட்டி அட்லீஸ்ட் இவங்க கிட்ட இல்லைனாலுமே டிரான்ஸ்பரண்டா இருந்தா இவங்களோட தேவை இருக்காது. அந்த டிரான்ஸ்பரன்சி ஒபேக்னஸ் தான் இப்ப இருக்கக்கூடிய பெரிய பிரச்சனை. ஈவன் இஃப் யூ டேக் தி கேசஸ் ஆஃப் கொலிஜியம், இந்த மாதிரியான சீல்டு கவர் ஜூரிஸ்ப்ரூடன்ஸ், அப்போ டு பிரிங் அவுட் தி கான்ஃபிடன்ஸ் இன் தி காமன் பப்ளிக் அபவுட் தி டிரான்ஸ்பரண்ட் நேச்சர் ஆஃப் தி ஜுடிஷியரி, தி ஆக்டிவிட்டிஸ் டேக்கன் பை சீஃப் ஜஸ்டிஸ் ஆஃப் இந்தியா இஸ் டு பி கன்சிடர்ட் இன் அ ரைட் வே. ஓகேவா? ஸோ இந்த மாதிரி விஷயங்களை நம்ம பார்த்துக்கலாம். ஈவன் இன்னைக்கு நியூஸ் பேப்பர்ல கூட ஒன் ஆஃப் தி 6 கவர்னர்ஸ் அப்பாயிண்டட்ல சுப்ரீம் கோர்ட் ஜட்ஜ் வேற இருந்தார். சுப்ரீம் கோர்ட் சீஃப் ஜஸ்டிஸா இருந்தவரே கவர்னரா வந்திருக்காரு. சுப்ரீம் கோர்ட் சீஃப் ஜஸ்டிஸா இருந்தவர் எம்பியா இருந்திருக்காரு. அட்லீஸ்ட் இதையாச்சும் பார் பண்ணணும். ஓகேவா? ஸோ தட் தே கேன் நாட் இன்வால்வ் இன் எனி கைண்ட் ஆஃப் ரிலேஷன்ஸ் வித் தி கரண்ட் கவர்மெண்ட் டியூரிங் தேர் ரோல் இன் தி ஜுடிஷியரி. இப்போ லேட்டர்டா அவங்க எந்த விதமான ப்ராக்டிசஸும் பண்ணக்கூடாது, எதுலையுமே கவர்மெண்டோடைய அப்பாயிண்டே இருக்கக்கூடாதுன்னு ஒரு ரூலை போட்டா அட்லீஸ்ட் தே கேன் ஃபங்க்ஷன் இன் அ டிரான்ஸ்பரண்ட் வே இல்ல. பட் இதெல்லாமே நீங்க எப்படி யூஸ் பண்ணணும் அப்படிதான் யூஸ் பண்ணணும், டைரக்டா சொல்லிடக்கூடாது எக்ஸாம்ல. ஓகேவா? ஓகே ஓகே. So one of the important issues with respect to economically weaker sections quota, right? You would have heard about in the news, right? A constitution bench, as I said before, 5 members has to be minimum if it is a case with related to interpretation of the constitution or amendment of the constitution. So 3:2 majority decision upheld the 103rd constitutional amendment, which provides 10% reservation in government jobs and educational institutions to the economically weaker sections of the society. You all know that under Article 14, that is under Article, under right to equality, it has been clearly mentioned that the provisions will be provided only on the basis of socially and educationally backward communities. Economical backward communities based reservations or positive kind of discrimination should not be provided, or it is not directly mentioned in the constitution or directly mentioned in the fundamental rights. But this amendment, 103rd constitutional amendment, has provided this extra part in the fundamental right, article right to equality. They have added another provision by giving 10% additional reservation for economically weaker sections, right? Supreme Court has also upheld the EWS quota, right? They have what does this constitutional amendment have added? They have added 2 important provisions with respect to the existing Article 15 and 16. Article 15 is related to prohibition with respect to discrimination on the basis of religion, race, caste, sex, or place of birth. And Article 16 is related to provision of employment or provision of seats in the educational institutions on the basis of all of the existing criteria which has been mentioned in the Article 15, right? So both of these articles have added a new provision of 6th subclass, which is also taking into consideration economically weaker sections along with the social and educationally weaker sections, which was already there in the fundamental right. to provide up to 10% reservation to EWS other than backward classes, scheduled caste and scheduled tribes. What does it mean? This economically weaker sections is considered to be only for general sections. This economical level, economic based criteria should not be applicable for already socially and educationally backward communities like BCs, SCs and STs. This is based on social and educational backwardness. And for other people who may not belong to these reserved categories, they can claim through the economic reservations, economic based reservations. That is what the provision with respect to this constitutional amendment. The amendment empowered even the state governments to provide reservation on the basis of economic backwardness, right? Even state can also take this component as the provision of providing reservation apart from already existing socially and educationally backward classes. What is the important problem with respect to this existing provision now? That is, it 10% additional reservation was there already, through which case the ceiling of 50% has been provided. Indira Sani case of 1992, the reservation could not go beyond 50%, right, in any form. That is not with respect to social and educationally reservation. If a concept of reservation is being provided, that should not breach the limit of 50%. But this additional 10% is breaching that 50% limit. So this is the existing news with respect to that. But we have, this is one of the important issue. So you have to note what was the background behind that and what are all the associated committees with respect to these issues for the examination point of view, right? Right. So the because in the recent times in the prelims, prelims is focusing, UPSC is focusing on asking questions with respect to committees, especially with respect to any of the important issues. So this economical based reservation is recommended by a committee, right? Already it was been there in the UPA period itself. The name of that committee is SR Sinha committee, right? So economically weaker sections reservation was granted based on the recommendation of a committee headed by the Major General retired SR Sinha. The commission, which was constituted in 2005, submitted its report in 2010. But the recommendation of committee was different. But this committee has taken the responsibility of providing reservation on the basis of economic. Before, until that, or till now, government was providing reservation only on the basis of social and educational. But economic based criteria committee was appointed. That committee is called as SR Sinha committee. The recommendation is completely different from what the government has been provided in the present scenario. What was the recommendation of SR Sinha committee means? They have recommended that all below poverty line families within the general category. But the current economic weaker sections criteria have set 8 lakhs of annual income as the limit for considering as economic backwardness. But it has numerous criticism with respect to that application of reservation. But here they have clearly mentioned that those who are belonging to the general category, if they comes under the BPL category, means then they will be provided reservation, right? That's one of the important criteria. Then after that, as notified from time to time, and all families whose annual income from all sources, because nowadays for the other cases, the income from the agriculture could not be taken into account. For example, if you take the case of OBC criteria, income from agriculture is not taken as a income at all. But for this case of economical weaker sections, you have to consider income from all the sources. This was the recommendation of SR Sinha, right? So all families, irrespective of any category, all families whose annual income from all the sources is below the taxable limit, should be identified as economically backward classes. So they have given 2 criteria. One for all the common people. When all of their sources of income is below the taxable limit, we can provide reservation on the basis of economic backwardness. And for the general category, who are not already been covered under social and educational backwardness, if those people or those people who are belonging to the BPL category, then they have to be provided with reservation of economic backwardness. These are the two provisions which was recommended by this committee, right? But these recommendations are not taken into considerations. But economic based reservation was provided by its own judgment, the present government, right? But you should know a committee which is with respect to the economic based reservation recommendation, right? Then another important committee, the first backward class committees, that is Kaka Kalelkar Commission. It was the first backward class commission in the year of 1953, accordance with the Article 340 of the Constitution, because Article 340 clearly mentions that it is the responsibility of the president or the government to identify the reasons behind the problems associated with the social and economic backwardness, and you should take certain measures by appointing a commission to address the issues faced by them. So it is the direction which was given in the Constitution itself through Article 340. On the basis of Article 340, this commission was appointed in the year of 1953, right? This commission was the first backward class commission. But that particular point of time, they have been considered only the social and educationally backward classes. Backwardness, they were not considering economic backwardness as a criteria for reservation or any of the activities, right? So to investigate the conditions of backward class and have submitted their report in 1958, but its recommendations was not taken into consideration. But another most important, after that, in the year of 1979, during the Janata Dal government by the Prime Minister Morarji Desai, Mandal Commission, one of the important commission with respect to backward classes, was appointed. It is the second backward class commission, and it submitted its report in 1980. And it has given so many recommendations, and majority of its recommendations were taken by the government. And they have recommendations of how to advance the social and economic backwardness, because it is the responsibility of the government under the Article 340. They have to take certain measures to identify the issues faced by the peoples who have been under social or economic backwardness. So to fulfill the promise of Article 340, government has to appoint a commission. That commission will give a recommendation. That recommendation has to be followed in provision of reservation. That reservation, provision of providing reservation, is under the enforcement of fundamental right of Article 14, 15 and 16. புரியுதா? இப்படிதான் லிங்க் பண்ணணும். புரியுதுங்களா? The responsibility was given in some other article. To fulfill the responsibility of Article 340, government has appointed, because it is the responsibility of the president. President is the head of the state or government, and they have appointed a commission. That commission gives a reliable data and recommendations. On the basis of that recommendations, they have facilitated or they have enforced the rules which on the basis of fundamental right to equality. Purida? Right. In addition to that, in addition to the already existing 22% reservation for SCs and STs, before the recommendation of Mandal Commission, reservation was only available for scheduled caste and scheduled tribes. How many percentage? 22% reservation. In addition to that, this report has recommended that you have to identify the backward classes apart from scheduled caste and scheduled tribes, and they have to be provided with the 27% reservation. So while combining both of these, it could sum up to 49%, 49.5% of reservations, right? So existing or the current reservations on the basis of Mandal Commission report was followed till the enactment of 103rd constitutional amendment. Okay, wow. So these are all important things with respect to Mandal Commission. So after the I mean, it was appointed by Janata Party, but later Narasimha Rao government has implemented with certain modifications of the Mandal Commission report. The Mandal Commission report was put into practice in the year of 1991 with few modifications. Even in that period itself, the criteria of economic I mean, the criteria of economic consideration was also taken. I mean, provision of economical based reservation was also been recommended by Mandal Commission, but it was not taken into force. It was recommended by Mandal Commission, but it was not implemented by the government. But 27% reservation for OBCs were implemented. They have recommended certain provisions for economic based reservations for other people, that is for the general people, but that was not considered by the government. Okay, wow. So already existing scheduled caste, scheduled tribes and backward classes reservations were came into force on the basis of Mandal Commission report, right? So in granting reservations by giving the preference to poorer sections of the socially, educationally and backward, socially educational backward classes within the proposed 27%. But within the provision of these reservation, they have taken economical criteria. In what form? One recommendation of taking directly the economic based reservation for the general community was not taken into consideration, but economic based criteria within the backward classes in the form of creamy layer, that was taken into consideration, right? So proposed 27% and further 10% grant to the economically challenged sections of the population not benefiting from any reservation schemes, but this was not taken into consideration. But economic criteria within that OBC was considered, and they have to be neglected from the provision of reservation. They have been called as creamy layer. Okay, wow. So other on the Mandal Commission report base panni vandadha, it was challenged in the Supreme Court, and the famous judgment of Indira Sani case was given by 9-judge panel. Okay, 9-judge panel through 6-3 majority on 1992. They have said that the caste system, not merely the economy, can be linked to the backwardness, right? What on, because on the basis of Article 16, that is providing employment in public institutions or providing education in public educational institutions, means you should not consider about the economical based criteria. Caste based criteria has to be considered. Strict provision of socially backwardness has to be taken into account. It is one of the important provisions of Indira Sani judgment by the Supreme Court. What they said, that the Article 16 subclass 4, it can be divided into backward and most backward classes. Within the socially backward classes, right, you have to divide backward classes and most backward classes. What is the difference between these backward and most backward classes? Means these backward classes are economically well-off people. So 27% of OBC reservation, within that, these backward classes should not be considered as a basis, or should not be considered on the basis of socially backward alone. They have to be neglected on the basis of higher economic status. Okay, on the creamy layer kind of concept. Most backward classes என்றது scheduled caste, scheduled tribes and other backward sections of the OBC communities. Okay, va? The idhula innoru or mukkiyamaana judgment. What was the another important component of this judgment? Means the promotion does not include any reservations. Initial level of appointment should be provided through reservations. It was provided as a reasonable restriction under right to equality, but promotion in case of, reservation in case of promotion should not be given as per the judgment of the Indira Sani case. Then they have set the maximum limit of 50%, right? Then they have given a statement, right? Article 16 subclass 4 does not provide an exemption to the general rule of subclass 1. This subclass 1 of Article 16. Article 16 subclass 4 defined socially and educationally backward classes differently than Article 15 subclass 4, which defines socially and educationally backward classes. So what do you understand from this statement? Means the meaning behind the provision of social and educationally backward classes in Article 15 and Article 16 is completely different to each other. What is the basis of Article 15? Prohibition of discrimination on the basis of there they are talking in a negative sense. Okay, wow. So you should not prohibit, I mean, you should not discriminate anyone on the basis of religion, race. That is comes under the definition of socially and educationally backward classes. So what is Article 16 talk about? It is providing, or it is enabling, or it is a kind of empowerment. It is a positive sense of discrimination. So the context behind the definition of social and educationally backward in Article 15 and Article 16 has a different meaning. So it should not be considered in equal proportion. So providing reservation on the basis of social and educationally backwardness while giving an employment in the government institutions is not a violation of Article 16 subclass 1. Is not a violation of Article 16 subclass 1. What does that Article 16 subclass 1 talk about? There shall be an equality of opportunity for all citizens. There should be an equality of opportunity for all citizens in matters relating to employment or appointment of any office under the state. So everyone should be treated in equal part, and no one has to be considered. No one should be considered in different way. Okay, but everyone has to be provided with equal opportunity. That is what the provision of 16 subclass 1. But do the society, or do the current economic system, or do the existing political systems allows every sections of the people to participate with the right kind of opportunity? That is what the question. If equal opportunity, equality of opportunity is not being there, means it is the responsibility of the government to empower the people who are on the back seat. So adanala, by providing an additional form of empowerment to the most backward sections of the community should not be considered as a provision against the form of positive discrimination. Okay, va? So nothing in this article shall prevent the state from making any provisions for the reservation of appointments or posts in favor of any backward classes of citizens, which in the opinion of the state is not adequately represented in the services under the state. Because if you take the proportion of the employees, but this communities, the people belonging to these sections were not adequately represented. In order to fulfill that seats, that people has to be provided with some kind of positive discrimination. Positive discrimination is the context behind the provision of reservation. Because if literally saying provision of reservation is itself is a violation of right to equality. Right? So right to equality kana or opposite concept da provision of reservation. But we have been given in the article itself, provision of reservation is a reasonable restriction to the right to equality. In that sense, providing equality of opportunity is a component of Article 16 subclass 1. But if any job is given on the basis of social backwardness by Article 16 subclass 4, it should not be considered as a violation of 16 subclass 1. It should not be considered as a violation of Article 16 subclass 4 does not provide an exception to the general rule of 16.1. Right? Even apart from that, you should understand the differences between the meaning which was mentioned in 15 and 16 itself. So this provision of reservation for backward classes has its justification, which was clearly defined in the Indrasani judgment. These are all the important points with respect to that particular case. Apart from that, as I said before, a concept of economic level criteria within the backward classes were also being introduced, but that concept were not allowed in the cases of scheduled caste and scheduled tribes. It is being only allowed for backward classes alone. The backward classes must not include the creamy layer, right? The permanent, and they have also given a direction to the government that there should be a permanent statutory body charged with investigating allegations of over inclusion and under inclusion. Establishment of this permanent statutory body is the responsibility of the government to fulfill the provisions of which article? 340. புரிஞ்சுக்க முடியுதா? அதை டைரக்ட் பண்ணுச்சு யாரு? சுப்ரீம் கோர்ட்டே டைரக்ட் பண்ணுச்சு. If any disagreements or if any problem arising with respect to any of these provisions of reservations, that case has to be handled only by the Supreme Court, because it deals with the most important components of our fundamental functioning of the society, because our society has been clearly stratified on the basis of caste system. It has huge implications on any other issues. It is for this purpose this case was directly dealt by Supreme Court, even the provision of economically weaker sections for 10%. These are all the provisions of Indira Sawhney case. Okay, right. Then after that, on the directions of the Indira Sawhney case, in the year of 1993, Mandal Commission, Indira Sawhney case judgment. On the directions of Indira Sawhney case judgment, government has established a National Commission for Backward Classes, because a new provision of backward classes has been introduced through Mandal Commission. 1991 தான் அது ஃபங்க்ஷனிங்கே வருது. அப்ப அவங்களுக்கு ஒரு கமிஷன் தேவைப்படும்ல, National Commission for Backward Classes in the year of 1993. Initially it was a statutory body. Then through 102nd Constitutional Amendment Act of 2008, it has been given constitutional status. Initially article 338 la pathina National Commission for SCs and ST mattum da irundhuchu. Then after that ST has been bifurcated, National Commission for Scheduled Tribes with article 338A. ipo idhum pudusa vandircha, and it has been accorded constitutional status. So another article has to be there, that is nothing but article 338B. 338, 338A, 338B. National Commission for Scheduled Caste, Scheduled Tribes, Backward Class. All of these three commissions were constitutional bodies, or they have been accorded with the constitutional status. Whereas National Commission for Women is a statutory body. You should compare these elements, right? So article 338 and article 342A, right? Article 338B provides authority to NCBC to examine complaints and welfare measures regarding socially and educationally backward classes. Now, maybe another additional responsibility of economically weaker section has to be included in the functioning of this commission, because it was part of the current reservation system, right? Who has to take that responsibility? National Commission for Backward Classes. But backward classes innale and the context marubadum, because economical weaker sections is been provided for general category, it is not for NCBC. So maybe that function cannot be added to the existing function of NCBC. You may expect a new body to function for the to function with respect to the economical weaker sections. What does article 342A say? It empowers the president to specify socially and educationally backward classes in various states and union territories, who are all being considered under the category of scheduled caste and scheduled tribes. Who has that responsibility? It is the president who should define who are all belonging to the, even we have already discussed, right, that status of providing scheduled caste and scheduled tribes is belonging to that state only. That community could not be considered as scheduled caste outside of that state, because it all belonging to the provisions of that particular state alone. But it is being accorded by president. It could not be decided by the state government. It could not be decided by governor. It should be decided by president. Okay, va? Because he is responsible for schedule 5 and 6. Correct? Backward areas, scheduled and backward areas. So these are all the important points with respect to NCBC. Then after that, another important, in the Indira Sawhney judgment, what they have said, reservation in promotion should not be there. But later that in order to provide reservation in promotion for scheduled caste, government has introduced an amendment. That amendment is 77th Constitutional Amendment Act of 1995. In that, they have added another provision with respect to Article 16 subclass 4A. Okay, 16 subclass 4 the provision of employment with respect to backwardness. But on that backwardness, reservation in promotion will be provided through subclass 4A. Provides that the state can make any provision for reservation in matters of promotion in favorable of scheduled caste and scheduled tribes if they are not adequately represented in these services under the state. And another provision 16(4)(b) also been there. What is that provision? It is been added through 81st Constitutional Amendment Act of 2020. Any backlog vacancies, because they were not adequately represented, right? Any backlog vacancies or unfilled scheduled caste and scheduled tribe quota of a particular year to be carried forward to the next year. Okay, because that was not been fulfilled. That vacancies should be taken as an additional vacancy for the next year, but it is not applicable for other communities. It is only applicable for SCs and STs. These two provisions has given some of the additional way of empowerment to the scheduled caste and scheduled communities, scheduled tribes under 77th and 81st Constitutional Amendments. Then after that case that was questioned under Nagaraj case, because through the Indira Sani judgment, reservation in promotion for scheduled caste should not be provided. Reservation in promotion is itself been banned under Indira Sani judgment. But government has introduced a constitutional amendment. It was challenged in the M. Nagaraj case. Supreme Court upheld the provision of providing reservation for scheduled caste through this case, right? The Supreme Court upheld the constitutional amendments by which Articles 14(4)(a) and 14(4)(b) were inserted, saying that they flow from Article 16 subclass 4 and do not alter its structure. Right? This is an additional enabling provision, it doesn't affect the existing provisions of Article 16 subclass 4. So you can allow them to get promoted on the basis of reservations. But they have given 3 important conditions for reservation in promotions. What are those conditions? SC/ST community should be socially and educationally backward. Those who have been accorded with the reservation in promotion, they should be clearly socially and educationally backward. Then that communities are not adequately represented in public employment. If already the representations were completed, means you should not consider those people for promotion. Right? And the mari no condition. Then such a reservation shall not affect the overall efficiency in the administration, because the meritocracy or the capacity or efficiency of the people should also be considered when he or she should be promoted for the upper level hierarchies. So when all of these 3 conditions will be fulfilled by a candidate, then that candidate will be provided reservation in promotion. These 3 criteria has been given through Nagaraj case 2006. Okay, then after that, even in the recent time, another important issue with respect to reservation. Reservation, already I have said that reservation is a kind of reasonable restriction to the fundamental right. It is not a fundamental right itself. That was clearly defined by Supreme Court in this particular case, that is Mukesh Kumar and another versus State of Uttarakhand case. In that particular case, they have clearly said that there is no fundamental right to reservation or promotion. Even reservation is itself a restriction to the right to equality. It cannot be regarded as a fundamental right. If a person should not be provided with reservation, means he cannot go to the court and claim that I have been affected through the violation of fundamental rights, because it is not given as a fundamental right. It itself is a reasonable restriction to the fundamental right. So reservation is not a fundamental right. Right to reservation and right to reservation in promotion is not a fundamental right, which was clearly said by Supreme Court in this particular case. Right? So reservation promotion under 16 subclass 4 and 4A of the constitution, rather they are enabling provisions for providing reservation if the circumstances warrant. 15ல ரிசர்வேஷனே வராது. ரிசர்வேஷன் என்ற கான்செப்ட் 16ல வரும்போது தானே வரும். ஓகேவா? எதுல? எம்ப்ளாய்மெண்ட்டுக்கு 16ல வரும், எஜுகேஷன் இன்ஸ்டிடியூஷன்ஸ்க்கு 15ல வரும். ரெண்டுக்குமே அப்ளிகபிள் ஆகாது ஆக்சுவலா பார்த்தோம்னா. அதுலயும் வந்து எஜுகேஷனல் இன்ஸ்டிடியூஷன், பட் அது இன்னும் எதுவும் கிளாரிஃபை பண்ணல. இதுல வந்து கிளியரா எம்ப்ளாய்மெண்ட்டுக்கு மட்டும் தான் கிளாரிஃபை பண்ணிருக்காங்க. பட் ஈவன் 15க்கு எடுத்துக்கிட்டாலுமே தட் திஸ் ஐடியா ஷுட் ரெப்ளிகேட். ஓகேவா? எஜுகேஷன் இன்ஸ்டிடியூட், பிகாஸ் reservation itself is not a fundamental right na. In educational institutions it's adliyum pathomnalume it could not be claimed as a fundamental right. Okay va? So these are all the important points with respect to the reservation. Okay va? Because it was a hot topic, you may expect other areas, or definitely you should know about all of these elements while you are going for mains examinations, right? Then adoda relate ana another issue is also been there. புரியல. இல்ல இந்த 342A is part of 103rd கான்ஸ்டிடியூஷன் அமெண்ட்மெண்ட் தானே தவிர 338B ஓட சம்பந்தப்பட்டது கிடையாது. அது என்னன்னா, who are all been considered as scheduled caste and scheduled tribes ன்றதை டிஃபைன் பண்றது மட்டும் தான் பிரசிடென்ட் இருக்கு. எந்தெந்த கம்யூனிட்டிக்கு எக்கனாமிக் பேஸ்டு பேக்வர்ட்னஸ் கொடுக்கலான்றத ஸ்டேட் முடிவு பண்ணிக்கலாம். ஸோ அப்போ ஸ்டேட்டுக்கு வந்து அடிஷ்னலான ஒரு ரோலை கொடுத்துருக்காங்க, அல்லது ஸ்டேட்டுக்கான அடிஷ்னல் ப்ரொவிஷனிங் கொடுத்துருக்காங்க. இட் இஸ் நாட் ஓன்லி தி சென்டர் who can decide on the basis of economic backwardness. State also decide for their policies of reservations by taking economical criteria as the basis என்றது 105ல இருக்கு. ஓகேவா? பட் சோஷியலி அண்ட் எஜுகேஷனலி பேக்வர்டுன்னு சொல்லக்கூடிய ஸ்கெடியூல் காஸ்ட் அண்ட் ஸ்கெடியூல் ட்ரைப்ஸ் யாருன்றதை டிஃபைன் பண்றதுல ஸ்டேட்டுக்கு பவர் கிடையாது, பிரசிடென்ட்டுக்கு மட்டும் தான் பவர்.
சோஷியலி அண்ட் எஜுகேஷனலி பேக்வர்ட் கிளாஸஸ் யாரு அப்படின்னு நோட்டிஃபை பண்ணலாம். இதுக்கு தான் அவர் சொன்னாங்க.
பட் அதுவும் வந்து ஐ திங்க் தட் பவர் இஸ் ரீஸ்டோர்ட் ஒன்லி ஃபார் பேக்வர்ட் கிளாஸஸ் மட்டும்தான். ஓபிசி, அதாவது சென்ட்ரல் கவர்மெண்ட்ல வரக்கூடிய ஓபிசி லிஸ்ட்டுக்கு ஸ்டேட்டும் கொடுத்துக்கலான்றது தான் சொல்லியிருக்காங்க. பட் இங்க நம்ம பார்த்திருக்கிறது ஸ்கெடியூல் காஸ்ட் அண்ட் ஸ்கெடியூல் ட்ரைப்ஸ் மட்டும் தானே. ஓகே ஓகே, அதுல வரத ரீஸ்டோர் பண்ணிருக்காங்க. ஓகே ஓகே, பட் நல்லா கிளியரா புரிஞ்சுக்கணும், ஸ்டேட் வந்து ஓபிசிக்கு மட்டும்தான் டிஃபைன் பண்ணலாம். ஓகேவா? அதோட ரிலேட் ஆன இன்னொரு இஷ்யூ தான் சுப்ரீம் கோர்ட், ஐ மீன் எஸ்சி கோட்டா ஃபார் தலித் முஸ்லிம்ஸ் அண்ட் கிறிஸ்டியன்ஸ். இதுவும் நியூஸ்ல இருந்துச்சு. சுப்ரீம் கோர்ட்டுக்குல நிறைய பெட்டிஷன்ஸ் வந்துச்சு அகெயின்ஸ்ட் தி ஆர்டர் ஆஃப் தி கவர்மெண்ட். அதுக்கு பின்னாடி இருக்கக்கூடிய விஷயங்கள் என்னன்னு பார்ப்போம். ஸோ அட் பிரசன்ட் திஸ் reservation or quota with respect to scheduled caste can be claimed by a community only if they belong to 3 religions, that is Hindu, Muslims and Sikhism. If the same scheduled caste has been converted to Islamism or Christianity, then they cannot claim the reservation. வருஷம் UPSC ரிசல்ட்லயுமே இது ரிஃப்ளெக்ட் ஆகும். ஓகேவா? ஒருத்தர் 2 கேண்டிடேட்டுக்கு கேண்டிடேட்ஸ் கடைசியில கேன்சல் பண்ணிடுவாங்க. பிகாஸ் they are practicing Christianity but they belonging to SCR தான், they cannot claim the quota on the basis of scheduled caste. It is applicable only for 3 communities. அதுக்கு against petitions வந்ததுனால Supreme Court have asked the details about the role played by, I mean the details behind the data with respect to the provisioning of this கான்செப்ட் என்றதை கேட்டிருக்காங்க. அப்ப அதை பத்தி என்னென்ன, வாட் ஆர் ஆல் தி டீடைல்ஸ் பிஹைண்ட் தட்ன்றதை பார்ப்போம். The Supreme Court of India has sought the most recent position of the union government on a batch of petitions challenging the constitution scheduled caste order of 1950, right? This constitution order was initially been available only for Hindu communities, because at that particular time, which allows only to members of Hindu, Sikh and Buddhist. Initially, it was available only for Hindu, but later Sikhism and Buddhism were added by amendments to that particular order on the basis of untouchability, because the practice of untouchability was prevalent only in the Hindu religion. So, on the basis of providing the on the basis of providing provisions to the people who are considered as untouchables under Hindu religion, they have been categorized as scheduled caste, right? If that practice was not there in some other religion, then there is no role, I mean, there is no need for providing scheduled caste status in the order odia context. Okay, because abolition of untouchability is also part of our fundamental right, because the practice of untouchability was prevalent only in the Hindu religion, right? So Article 341 of the Constitution, the President may specify the caste, races or tribes or parts of a groups within the caste, races or tribes which shall be deemed to be scheduled caste. As per Article 342 A Mariye, idiliyume President is being provided with the responsibility of specifying or defining who are all been considered as scheduled caste, right? That order, Constitutional Scheduled Caste Order of 1950, initially provided for recognizing only Hindus as scheduled caste to address the practice of untouchability. But later, even the Sikhism was having a relationship with Hinduism, and Buddhism is also having a high relationship with Hinduism. The people, even though they have been converted to another religion, but they have been neglected by the practices of untouchability. So it is definitely necessary for extending that provision of scheduled caste to these two religion also. Now the scheduled caste quota that can be claimed only those people who belonging to these three religions alone: Hindu, Sikhism and Buddhism. So the order was amended in 1956 to include Dalits who had converted to Sikhism also, and in 1990 to include Dalits who had converted to Buddhism also, right? But it is not available to Christianity and Islamism or any other religion. So this is the issue. This related a government, Supreme Court has asked the details. So this related a commissions that has to be read. So Ranganath Mishra Committee, the first, it is a National Commission for Religious and Linguistic Minorities, which was appointed in the year of 2004 and submitted its report in 2007. It recommended that the scheduled caste status should be completely de-linked from the religion. So you should definitely know that scheduled tribes status is not at all been associated with the religion. Even the scheduled tribes of Christianity can also use that quota. Scheduled tribes of some other religion can also use that quota, because irrespective of religion, they have been provided that status of scheduled tribes. On the same lines, irrespective of religion, scheduled caste should also be given quota for any people who belong into that community. This was the recommendation of Ranganath Mishra Commission. Scheduled caste status should be completely de-linked from religion, and scheduled caste should be made fully religion neutral like scheduled tribes. So scheduled caste related on a recommendation, a government appointed committee called as Ranganath Mishra Committee have already given recommendation. Along with that, they have also proposed another form of reservation, that is providing reservation for minorities, religious based minorities, right? 10% reservation for Muslims, but these are the recommendation of this commission alone. This provision is not been existing there. 10% reservation for Muslims and 5% reservation for other communities in the government jobs. This was the recommendation of Ranganath Mishra Committee, right? So even if you take up the case of DOPT, the Department of Personnel and Training, website clearly says that the rights of person belonging to scheduled tribe are independent of his or her religious faith. But this status is not been allocated for scheduled caste. So question has been raised and numerous petitions has been filed for claiming that scheduled caste status even though they belonging to any religion. ரைட்டா, இது ரிலேட்டடா அப்பாயிண்ட் பண்ணப்பட்ட ஒரு கமிட்டியோட ரெக்கமெண்டேஷனே இதுதான். ஓகேவா? As like that, another committee is also there, right? Another committee is Sachar committee. A 7-member committee, high-level committee by former Chief Justice of Delhi High Court, Sachar, to study social, economic, and educational conditions of Muslims in 2005. This was a committee which was appointed to identify the backwardness of the most important minority community of India, that is Muslims. This community is also have identified even Muslims as a minority have been backward in so many criteria. Among the Muslims, those converted from those people who belong to the scheduled caste who have converted to Muslims are more vulnerable than the Muslims itself. This was the recommendation of this committee itself, right? They recommended that the socio and economic situation of Dalit Muslims and Dalit Christians did not improve after conversion. So even their religion, they have the right to convert to another religion, but they cannot have the right to convert to another caste. This itself being the reason behind the strong, rigid nature of our Indian society. No one can convert to another caste, but anyone can be converted to any other religion, right? அதுதான் இங்க சொல்லிருக்காங்க. So the concept of untouchability, the concept of not the concept of untouchability, but the concept of backwardness is still there in the society even when they have been converted to another religion. So this committee is also giving recommendation that you should provide some kind of reservation or some kind of provisions for those SCs who have been converted to other religions like Muslims and the Christians. So 2 committees have given reports with respect to providing scheduled caste status for people who have been converted to another religion, right? But Ranganath Mishra committee have recommended that directly you have to provide reservation for Muslims. But already based upon the Mandal Commission report, Muslims have been given reservation on the basis of under the criteria of OBC, right? So for after the Mandal Commission report, several Christians and Muslim communities have been placed in the list of OBCs. They have been provided with reservation, but not like the reservation exclusively being provided for scheduled caste and scheduled tribes. So these are all the important points with respect to the reservation of scheduled caste. With respect to their identification with religion, you should know about that. So in the when the questions have raised, when numerous petitions have been filed in the Supreme Court, government have replied to the Supreme Court that in the present scenario, we have appointed a commission in the year of 2000. Last year in the month of October, they have appointed a commission under the head KG Balakrishnan, Justice KG Balakrishnan Keela. They have appointed a committee, and their responsibility is to examine whether SC status can be accorded to Dalits who have converted to religions other than Sikhism or Buddhism. And they have been given the time frame of 2 years. Within 2 years, they have to submit the report. But whether even after they submitted the report, government will take up that or not is another question. But to normalize the present agitation, to answer the Supreme Court, they have appointed a commission. Because it is not necessary for the government to follow the recommendation of the commission, right? So you have to know about the cases or commissions with respect to the scheduled caste, right? Then after that, Lok Adalat. Last class we have discussed about Lokpal and Lokayukta, and this class we will discuss about Lok Adalat. So Chhattisgarh government has launched Lok Adalat in the jails for speedy disposal of cases for prisoners of the state. In that, Lok Adalat is an extrajudicial process nu sollala, okay va? So it is commonly called as people's court. Is one of the alternate dispute redressal mechanisms It is a forum where disputes or cases pending in the court of law or at pre-litigation stages are settled, compromised amicably. Okay, so even because we know that the judiciary has already been burdened with so much of cases, and so much of cases has been there for years and years. So in order to have a speedy redressal mechanism, these are considered to be an alternative to the existing judicial mechanisms. That is the Lok Adalat. So this Lok Adalat has a statutory provision. The functioning of Lok Adalat has been given statutory status under Legal Services Authorities Act of 1987. This act is also have established another authority called as National Legal Services Authority. So the National Legal Services Authority has been constituted under the Legal Services Authorities Act to provide free legal service to those who are belonging to the weaker sections of the society. And the weaker sections and the society, and it also has the responsibility to organize the Lok Adalats. Lok Adalatiyum free legal services kudukkakudiya responsibility is coming under the NALSA. NALSA is a statutory body functioning under Legislative Legal Services Authorities Act. Right? Even Lok Adalat is also been provided statutory status on this particular act. Okay, so the base panni NALSA is an authority in the establishment of Lok Adalats. Even you have 3 kinds of Lok Adalats. National level Lok Adalats is also there, which was there in every High Courts and Supreme Court building itself. And permanent Lok Adalats are also there, which has been there for any specific functions. Then there is another kind of Lok Adalats called as mobile Lok Adalats that can be formed at any place at any time based upon the requirements. But this is an extra judicial or supplementary component of providing justice to the common people whenever a petty cases like normal civil cases or some other cases are where there is a possibility of dealing with the settlement in an amicable manner, right? So what are all the functions of this Lok Adalat? So you should know about some of the important points with respect to NALSA. So NALSA it is an authority under Legal Services Act, and it has a chief. Who is the chief? It is the Chief Justice of India or Patron in Chief. Chief Justice of India is an ex officio Patron in Chief for National Legal Services Authority, and second senior most judge of the Supreme Court is the executive chairman of the authority. Right? And the establishment of NALSA and the establishment of Legal Services Authorities Act is itself on the basis of a provision of a directive principles of state policy. Which article? Article 39A. Article 39A of the Constitution provides that state, that is government, has to provide free legal aid to poor and weaker sections of the society to promote justice on the basis of equal opportunity. So to fulfill the provisions of a directive principles of state policy, this act was enacted by the Parliament. And to function and to have provide the elements of this act, it should have an executing authority, right? For that, they have established a National Legal Services Authority, and through which arms they can function those elements through the establishment of Lok Adalats. Okay, va? Idu mattum kadayadu. Article 14 and Article 22 subclass 1 obligate state to ensure equality before law, right? Because Article 22 is dealing with the persons with respect protection in respect of detention, right? If that person, even a person who is detained under Preventive Detention Act, should also be provided with the legal service provider. It is the responsibility of the government to provide any legal person to argue in favor of him, right? So அந்த மாதிரி Article 14 right to equality base பண்ணியும், because no person should be neglected by accessing to the justice, so that it is the responsibility of the government to provide the path of accessibility to the justice. These are all the provisions through which NALSA is functioning, right? Then some of the important points with respect to, as I said, NALSA is the national level authority, and then in every state and district levels also you have certain legal services authorities, state and district legal services authority and Supreme Court and High Court legal services committee may organize lok adalats at such intervals and places for exercising such jurisdiction and for such areas as it thinks fit. எப்ப வேணாலும் எந்த இடத்துல வேணாலும் வச்சுக்கலாம். In the name of that, I have said about different kinds of lok adalats are there. Every lok adalat organized for an area shall consist of such number of serving or retired judicial officers. National Legal Services Authority has Chief Justice of India as its component and the senior most judge of the Supreme Court as its components. But lok adalat is also have the composition of lok adalat is consist of judicial officer as well as from the common people. Or common people mean who are belonging to a NGO or any social worker, right? The composition of lok adalat, it should have definitely a judicial officer and other persons of the areas as may be specified by the agency organizing. Other bank related disputes are property related disputes are marriage related disputes are and the particular field related expert has to be the member of that lok adalat along with the judicial persons, right? Generally a lok adalat consists of a judicial officer as its chairman, a lawyer or advocate and social worker. The social worker is decided based upon the areas or the themes through which that lok adalat has been established as its members, right? So a lok adalat is also having judicial members as its component. Legal Services Authority is completely consisted of judicial persons, okay va? So these are all the way through which lok adalats is functioning as per the provisions of Legal Services Authority Act. Who is responsible for its functioning? It is NALSA at the national level, State Legal Services Authority and other legal services authorities of Supreme Court as well as High Court. Then you have to know some of the important points with respect to lok adalat also. What kind of powers it has and what kind of consequences with respect to its judgment. Lok adalat is deemed to be decree of a civil court and whatever been judgment given by the lok adalat is final and binding on all parties, okay va? And no appeal against such an award lies before any court of law. Whatever been settled under lok adalat should not be appealed in the judiciary. It is binding and it is final, right? So as it is a component of provision of free legal services, it should not connect any court fee. There would not be any court fee if you file a case or if you file a petition in the lok adalat. There should not be any court fee applicable when a matter is filed in the lok adalat. If a case is pending in the court, you can also take that case and file it on the lok adalat. If you take that, if you place that case on the lok adalat, then the court fee which you have been already paid for that case will be reimbursed, okay va? So if a matter pending in the court of law is referred to lok adalat and is settled subsequently, the court fee originally paid in the court is refunded back to the parties, right? But you should know that the award given by lok adalat is not subject to appeal, but you can file a fresh case in the court itself. புது கேஸா நீங்க ஃபைல் பண்ணி அதே விஷயத்தை புது கேஸா நீங்க ஃபைல் பண்ணி போகலாம், பட் அந்த டெசிஷனுக்கு அகைன்ஸ்டா தான் அப்பீல் போக முடியாது. Because it is an element of speedy justice as well as providing free justice, free legal services, right? And the persons deciding the cases in lok adalats are members of the lok adalats. They have the role of statutory conciliators only and not having any judicial role, right? The components are the members who are taking part in the lok adalats apart from the judicial officers, right? So it is functioning like a civil court. These are all the important points you should know with respect to the lok adalats, okay va? Right. Then after that, the persons deciding the case in the lok adalats are called members of the lok adalats. In the sense means, even though the judicial officer is component of lok adalat, advocate is a component of lok adalat, and any social worker is a part of lok adalat, the judgment or the award given by the judicial officer as a part of lok adalat cannot be taken as a judgment given by the court. In equivalent to that, you should not take. He is functioning as a statutory conciliator. He is not functioning like a judge in the same court. அதனால அவருடைய function in Lok Adalat is only statutory role தவிர it has not been equivalent to the judiciary role. அததான் இங்க சொல்லியிருப்பாங்க. ஓகேவா? So amendments in the electoral bonds. Recently, an amendment has been introduced. What they have been amended because and the additionally, additional period of 15 days shall be specified by the central government in the year of general elections to the legislative assembly of states and union territories with the legislature. If a year, if a election is to be conducted for a legislative assembly for a state, then for that particular year, the periods of electoral bonds, the usage of electoral bonds has been extended to another 15 days. அதுதான் அடிஷனலா ஒரு 15 நாளைக்கு இந்த பாண்டை யூஸ் பண்ணிக்கலாம். தட் இஸ் வாட் பீன் given in this particular recent amendments. So existing என்னது, when in the 2018 when the electoral bond scheme was introduced, these bonds were made available for a period of 10 days each in January, April, July and October. In these 4 months, the availability of electoral bonds will be there for 10 days of each month. Suppose totally 40 days it will be there. Now 55 days it will be there. It will be available for another additional 15 days if that election is conducted for state assembly elections. Legislative assembly ka irundha 15 days additional. Ade Lok Sabha election irundha 30 days will be there. 40 plus 30. 40 is the present available validity அப்படின்னு சொல்லலாம், அல்லது available period, available for purchase. It has been available in the State Bank of India for purchasing by any anonymous party. யாருதான்றது தேவை கிடையாது, ரைட்டா? அது அவங்களுக்கு மட்டும் தெரிஞ்சா போதும். பட் அந்த அவைலபிலிட்டி டைம் எக்ஸ்டெண்ட் பண்ணிருக்காங்க. if it is an year of Lok Sabha election, it will be available for additional 30 days. If it is an year of any state assembly, in that particular state alone it will be available for additional 15 days. அதுதான் பார்த்துக்கணும் அந்த ஸ்டேட் அசம்பிளில. ஓகேவா? So these are all the new amendments which has been brought with respect to electoral bond scheme. And what are the some important points with respect to electoral bond? You know that State Bank of India is authorized to issue and encash these bonds, and these can be purchased anonymously by donors. It is not been necessary to reveal the identity of the persons or the companies or corporations. Anyone can buy that bond, and the validity, once he bought that bond, its validity will be there only for 15 days from the date of issue. Within that 15 days, the political party should encash them. What is the condition for that political party? That political party has to have an account in the State Bank of India, and the value of that bond will be directly converted to the, value of that bond will be converted in the form of money to the designated account of that political party. இது எங்க மட்டும் தான் இருக்கணும்? State Bank of India மட்டும் தான் அந்த அக்கவுண்ட் இருக்கணும். ஓகேவா? As a debt instrument, this can be bought by the donors from a bank, and political party can encash them, and this can be redeemed only by an eligible party by depositing the same in its designated account maintained with the bank. It cannot be used in some other bank, or it cannot be used by any other party to whom it has been created. They only can encash them, and they should have a account with the State Bank of India. Okay, இதெல்லாம் the conditions, and this been available in terms of denominations: thousands, 10,000s, 1 lakh, 10 lakh and 1 crore. Thousands and thousand crores of electoral bonds has been purchased in the recent years. If you follow the data of Association of Democratic Republic, majority of the cases against the government will be filed by that NGOs. That it has been categorized as NGO or pressure group. ரெண்டு கேட்டகரியிலுமே வைக்கலாம். Association for Democratic Republics, ரைட்டா? ஸோ இதுதான் இதுல உள்ள இம்பார்ட்டன்டான பாயிண்ட்ஸ். பட் as I said before, it has not been availed by any political party. There has to be a condition or eligibility for a political party. What is that eligibility? Only the political parties registered under Section 29A of the Representation of People's Act of 1951 and secured not less than 1% of votes polled in the last general election to the House of People or legislative assemblies. It cannot be encashed by all the registered political parties, right? Only those political parties who have secured more than 1% of vote are eligible to get that bond or avail that bond, and it has been provided in the Representation Act of 1951. And in our previous class, we have discussed about the differences between RPA 1950 and 51. What is the major difference? Qualifications. Adala vandu 1950 qualifications for the voters. 51 is majorly dealing with conduction of elections. Delimitation commissions idellame part of 1950. But qualification for the political parties and the candidates been dealt under 1951. Okay, in that the qualification of a political party to receive the electoral bond has been mentioned under RP Act of 1951. Right? So, through an amendment to the Finance Act, the Union government has exempted political parties from disclosing donations received through the electoral bonds. It is not mandatory for political parties to reveal the amount. Government, right? And you know that political parties is also exempted from the Right to Information Act because they were not being considered as public authority. அதனால அந்த ஆர்டிஐ கீழே வராது, எலக்டோரல் பாண்டு கீழே எவ்வளவு பணம் வந்துச்சுன்றது ரிவீல் பண்ணணுன்ற அவசியம் கிடையாது. So these are all the some important points with respect to electoral bonds, right? யார் வேணாலும் வாங்கிக்கலாம், யார் வேணாலும் வாங்கிக்கலாம். அதாவது அந்த என்கேஷ் பண்றவங்களுக்கு தான் எலிஜிபிலிட்டி இருக்குதே தவிர வாங்குறவங்களுக்கு எந்த இண்டிவிஜுவல் வந்து கார்பரேஷன்ல இருந்து யாரும் வேணாலும். So another important conference, I mean, no money for terror conference was held in New Delhi recently. It is the third conference. It is the third ministerial conference on what basis to counter terrorism financing was held in New Delhi, right? So it is a conference which is not related to any universal organization or any important organization. It is an initiative by the French government, right? So a conference was started in 2018 as an initiative of France to specifically focus on cooperation between countries to choke terror financing. It is not being related to FATF. Financial Action Task Force or associate ஆனது கிடையாது, even though the objective behind these two is similar. அதனால தான் இதை கொடுத்திருக்கு. So it is a separate conference conducted by the initiative of French government, right? Previously in the 2019 it was held in Australia, and the third conference was held in India in the year of 2022. And there are four important themes of this conference, that is global trends in terrorism and terrorist financing, the use of formal and informal channels of funds for terrorism, emerging technologies and terrorist financing, then international cooperation to address challenges in combating terrorism financing. So these are all some of the important themes. So only important thing you should know about, it is not associated with FATF. Then we need to, and FATF is also been in the news for so many reasons, and we will see some of the important provisions of FATF also. Financial Action Task Force, right? So FATF, it is an intergovernmental organization founded in the year of 1989. It is an initiative of G7 countries. Initially, it was founded with the objective of combating money laundering alone in the year of 1989. It is an initiative of G7 countries, right? But later in the year of 2001, an additional component is also been added to its objective. Apart from money laundering, it also includes terrorism financing. So combating money laundering and terrorism financing are the two important objectives of the functioning of FATF, right? And it is a kind of policy making body, policy making, monitoring, and regulating body, right? So it sets the standards and promote effective implementation of legal, regulatory, and operational measures that related threats to the integrity of the international financial system. If some of the issues which may have which may not be directly been defined under money laundering or terrorism financing illanalume, that provision will be regarded as a threat to integrity of the international financial system ன்றதை எடுத்துட்டு FATF can provide any of the sanctions against those countries or any of the institutions who have involved in these two money laundering and terrorism financings. முக்கியமான பாயிண்ட் என்ன, it is an initiative of G7 and it is an intergovernmental body, right? Then its secretariats and headquarters is, its secretariat is located in the Paris, which is the headquarters of Organization for Economic Cooperation and Development. OECD உடைய secretariat தான் இதனுடைய secretariat, right? Which is headquarters in Paris. Okay va? Then the two important components of FATF is blacklist and grey list. So what do you understand by blacklist? It is the strict regulation or strict enforcement by FATF. It is officially called as high risk jurisdiction subject to a call for action. Those countries who have been involved in the who have highly involved in money laundering as well as terrorism financing activities or any of the issues with this which is affecting the terrorism related financial structures means, then they will be highlighted under blacklist. Okay va? It sets out the countries that are considered deficit in their anti-money laundering and counter-financing of terrorism regulatory regimes. As of the recent timeline, 3 countries are being placed under blacklist. What are those 3 countries? North Korea, Iran, and Myanmar. Only these 3 countries are still under the blacklist. And another important category is what? Grey list. Okay, wow. What is the status of Pakistan? It has been now been removed from the grey list. It is officially referred to as jurisdictions under increased monitoring. That's call for action, but it is under high monitoring. Okay, wow. Under increased monitoring. It is not been direct. It is not to have a formal sanctions against the activities of the countries which are mentioned in the grey list, but it is subjected to high level of monitoring. Legal sanctions irukadu, but it is highly monitored. But for the case of blacklist, it is legally been restricted or legally been regulated, right? It represents a much higher risk of money laundering and terrorism financing, but have formally committed to working with the FATF to develop action plans. They have been committed to FATF and they promised that we will make necessary regulations and we will make necessary changes to address those issues in our country. They promised to the government, promised to the FATF, and if they have followed those promises and they have taken certain measures means, then they will be removed from the grey list. Okay va? So it is not to develop action plans that will address the anti-money laundering and counter-financing deficiencies. Unlike the blacklist, grey listing carries no legal actions. Nalla purinjukku. It is subjected to monitoring alone and it is not subject to any official legal actions as like that of blacklist. But it attracts economic strictures and restricts a country's access to the international loans, especially the time at which Pakistan is suffering from huge economic crisis. So in the grey list and the velila vandadukku appuram the IMF is providing some kind of relief to the Pakistan's economy, right? That is another part of story which has been highly been countless debt trap diplomacy of China. Sri Lanka kaduthathu Pakistan maatittu. So as of June, the following 23 countries are on the FATF grey list. Recently, Pakistan has been removed, and one of the important major country still part of FATF grey list is UAE. UAE is still under grey list. Remaining all other countries are not major countries, but you should know that UAE is part of grey list. Okay, wow, apart from Pakistan, another important country. Okay, wow. So these are all the important points with respect to FATF, right? Then OPEC. In our previous class, we have discussed about Alliance for Asian Oil Palm, right? Adu vandu enadhu, it is an alliance of consumer-based countries, but OPEC is an alliance of production supplier-based countries. Adu palm oil, idu crude oil. Okay, wow. So the group of world's largest oil producing countries, that is Organization for Petroleum Exporting Countries and its allies. So OPEC and non-OPEC countries, both of them are clubbed together to called as OPEC plus. Okay, and its allies oda சேர்ந்தது தான் OPEC plus. OPEC தனி category, OPEC plus தனி category. Together known as OPEC plus, decided to cut oil production by 2 million barrels per day. Because these countries' economies are highly dependent upon their production and exports of oil. They will decide the price in the international market, and they have a coalition, right? They can make necessary changes in order to address their economy, right? So the organization was founded in Baghdad, Iraq, with the signing of an agreement in the year of 1960. And its headquarters, its secretariat and headquarters is in Vienna, Australia, capital Vienna, right? So its mission, as I said, its mission is to coordinate and unify the petroleum policies of its member countries and to ensure stabilization of the oil markets in order to secure an efficient economic and regular supply of petroleum to consumers, a steady income to producers, and a fair return on capital for those investing in the petroleum industry. So it is an alliance of petroleum production and the export based countries. But you should know about the members of OPEC as well as members of non-OPEC. I mean members of OPEC and members of additional members of OPEC plus also, because member based questions have always been asked in UPSC examinations. If you take up the case of OPEC countries, the significance of OPEC countries is 40% of world's crude oil is belonging to these countries, these organizations, and 80% of global oil reserves are belonging to this OPEC countries. So they have a higher say in the determination of price of crude oil. And crude oil is one of the important component of exports and imports of majority of the countries, especially if you take the case of India. That price will be reflected in any component, any products which has been part of the GDP of that country, economic activity of that country. So at present, OPEC is having 13 members. Okay, so 5 countries are its founding members. In the year of 1960, it has been founded by 5 major countries: Saudi Arabia, Iran, Iraq, Kuwait, and Venezuela. Right? These are the 5 countries who are founding members. Later, Libya, UAE, Algeria, Nigeria, Gabon, Angola are all been added. Equatorial Guinea and Republic of Congo were added. And some of the 3 important countries who are formerly part of OPEC, but now it has been quit away from the OPEC organizations. Ecuador, Indonesia, and the most important country, Qatar. The Gulf region liye, only country which was not part of OPEC is Qatar. Remaining Kuwait, Saudi Arabia, United Arab Emirates, all the major countries of the Gulf regions are belonging to OPEC except Qatar. Qatar is not part of OPEC. This important information you should know about that. It has resigned itself from the organization membership. And OPEC plus is an additional members of who are also being considered as an important oil producing countries. It is not as significant as OPEC members, but it also has certain huge reserves with themselves, right? Now, what are those countries? You should know the membership of this OPEC plus also: Azerbaijan, Bahrain, Brunei, Kazakhstan, Malaysia, Oman, Russia, South Sudan, and Sudan. So Russia, one of the important major country of OPEC plus, because no major developed countries were part of OPEC and OPEC plus apart from Russia, right? So made an agreement in 2016 to jointly cut productions for stabilization of prices. But you should know about the membership of both OPEC and OPEC plus. These are all the important points for the examination point of view. Okay, wow. And Russia's membership with OPEC plus and India's relationship with Russia, you should know about the dynamics, how far it is helpful for India or energy security of the world. And rather, you should use this knowledge in any of the topics which is related to bilateral or multilateral relations in higher topic of paper 2. OPEC in the countries சேர்ந்தது தான் OPEC plus. Okay, well, that is another name is Vienna. Okay, wow. So, final topic of today is Black Sea Grain Initiative. You all know about the issues or the most important problem arised out of the Russia-Ukraine conflict is export in the commodities like wheat, sunflower, then corn, maize. These are all because Ukraine and Russia are considered to be the major exporters of these commodities. Even the world has faced so much of deficit in wheat because majority of the European countries are dependent upon the wheat which was exported from Ukraine. So to address that deficiency, to address the supply related issues, in between the war, United Nations and Turkey have brokered in and created an initiative called as Black Sea Grain Initiative. So apart from the political issues with respect to war, the economical based exports should not be affected or should not be curtailed behind the war scenes என்றதுக்காக உருவாக்கப்பட்ட ஒரு important initiative தான் Black Sea Grain Initiative. So it is an initiative to grain export deal signed separately by Ukraine and Russia. Even during the course of war, this treaty or this initiative, this agreement was signed by Ukraine and Russia, which was mainly brokered by United Nations and Turkey, right? In the month of July 2022. So was set up to reintroduce vital food and fertilizer exports from Ukraine to the rest of the world. A joint coordination committee was established under the Black Sea Grain Initiative in the Istanbul. Then it was established to monitor or implementation of the deal. It comprises of senior representatives from all the 4 countries: Russia, Ukraine, Turkey, and the United Nations. So what is the important? So you should know about the partner countries and you should know about the objective of this initiative. And another important component with respect to map-based locations is 3 ports of Ukraine has been allotted from safe exports of these commodities. You should know about the name and location of those 3 ports, right? As per this initiative, 3 Ukrainian ports, that is Odessa, Kronomarks, and பேரே வாயில வர மாட்டேங்குது யூனி ஆர் பிவ்தெனி. இந்த 3 போர்ட்டும் தான் இது மாதிரி ஏதாவது கொடுத்துட்டு கேட்பாங்க வாட் இஸ் பீன் அசோசியேட்டட் வித்ன்றத ப்ரிலிம்ஸ்ல ரெகுலரா கேட்பாங்க. These are all nothing but the ports of Ukraine which were part of the Black Sea Grain Initiative. Okay, wow. So these ports should be monitored and safeguarded from the attacks of Russia, and they should be allowed to export the commodities so that the entire supply chain and the deficit in the other associated countries would be addressed through this initiative. All of these 3 ports are located in this particular region, right? Odessa, Kornobok, and இதனுடைய லொகேஷன் எங்க இருக்குன்னு பாத்தீங்கன்னா Black Sea இந்த பகுதியில இருக்கு. Okay, you just go through the map locations, but you should know about the names of these ports because sometimes the names கொடுத்துட்டே கண்ட்ரியோட மேட்ச் பண்ணி கேட்பாங்க யூபிஎஸ்சில, ரைட்டா? ஸோ அதுக்காக இதை தெரிஞ்சுக்கோங்க, ரைட்டா? ஸோ திஸ் ஆர் ஆல் தி இம்பார்ட்டன்ட் டாபிக்ஸ் விச் we need to know from these 2 months of October and November, right? With this we can conclude our discussion. So I will share the PPTs in the group as well as to the mail. Okay, any doubt? Thank you, friends.
Very good evening, friends. So today's current affairs session, we will focus on some important updates from the month of October, November, and December of last year. We'll begin our session with some important updates from the area of biotechnology. The first one in that is, okay. So what is something called as a list of health-threatening fungal species? So let's see some important aspects about this particular topic. As is the usual practice with our classes, you would have already received a PDF version of this slides. So you can have it as a ready reckoner. Probably you may observe the class and listen. Only the extra points which is not given in the slide, you can take down as a points. So you can have it also right now with you. It has already been in your mail. So you can check that out. So this is about a first ever list of health threatening fungi. So this list was released by World Health Organization. So when we talk about this health threatening fungal species, um, um, there are certain important aspects of fungal infections in humans, friends. பொதுவா பார்த்தீங்கன்னா நமக்கு usually bacteria usually is a very easily acquired disease. Same is true for virus. If someone is coughing, next 2 days we'll be having that cold also getting contracted to us. But that is not the case for fungi. Fungi is not an easy infectious agent that can infect humans particularly, that can infect animals particularly. But actually, since the outbreak of COVID, you would have gone through many cases where the patients have died because of secondary infections, not primarily due to COVID, but secondary infections. You know what is the major secondary infectious agent? Fungi. So since this outbreak of 2020, the importance of fungi, that's actually growing at the global level. And keeping that in mind, WHO has published the list of the most health threatening fungi has been released. And a similar list for bacteria was published in the year 2017. So there is also a list existing for bacteria, and in 2022 another list for fungi was released. Now in this list there are about 19 fungal species that poses greatest threat to the public health, has been recognized by the WHO and released to the public. Now in this 19 fungal species, it is divided into 3 groups. This is not given in the slide, so you can note it down. So this 19 fungal species under WHO report, it is divided into 3 groups. The first one is critical priority group. This is the biggest threat, critical priority group. The second is high priority group, critical priority group. The second is high priority group, and the third one is medium priority groups. The 19 fungal species are divided into these 3 groups: critical, high, and medium. Now in this critical, these are the most threatening. Sir, do I have to remember all the 19? No need for that. But what are these critical species of fungi that is most threatening to the public health? I've given it in a picture format in the next slide. You can note it down at that time. Now, what is the aim of this? Once WHO publishes a list like that, it becomes an awareness campaign about these fungal species. It also has an education role for the governments across the world to take necessary actions wherever these fungals are prominent. You understand? So the world governments are becoming aware. They take notice of these fungal infections more seriously. So the aim of this list is to focus and drive further research and policy interventions. As simple as that, to empower governments on this area. Now, there must be some reason, right? Without any reason, how they have identified only 19? Because according to scientific research, there are about 120,000 different fungal species. Out of that, they have identified only 19. On what basis? So these 19 species are identified on the basis of the pathogen's public health impact, or 2 reasons. There are 2 grounds on which they have been identified. One, it's public health impact, one, and second, do they exhibit any antifungal resistance? These are the 2 grounds. One, how much public health impact they make, and second, do they show any resistance? Now in this context, let us see this resistance. That's the last thing that we have talked about, right? Let's deal about that a little more now. When we talk about antimicrobial resistance, that also a part of our today's class agenda in the later slides, but let me very briefly deal about this antimicrobial resistance. See, since the last decade, doctors are usually advising, not only the doctors, but the government is also advising not to buy the antibiotics through OTC. OTC means over the counter format. We simply go to the pharmacy when you have a cold, you get the antibiotic and gulp it down without knowing what is the causative agent for that, how much it will respond to the drug you're taking. Without having any idea, we gulp it down. So this kind of indiscriminate use of antibiotics slowly results in the generation of resistance. What is that resistance? You're taking antibiotics for what? You want to kill the bacteria inside you. For example, if I keep on pinch you here, and after a point you will become insensitive, it doesn't feel pain anymore, something like that. When antibiotics are exposed to the bacteria more and more and more and more, bacteria will learn how to bypass it. So even when you take the drug, the bacteria won't die. It means it developed resistance for the drug. This can be done by bacteria, this can be done by fungi, even virus can do that, even malarial agents can do that. So many living organisms have the ability to develop this resistance. This is what broadly called as antimicrobial resistance. Now, this antimicrobial resistance, as I've said earlier, is present with bacteria, fungi, virus, amoeba, etc. But with respect to fungi, it is extremely important. Why? இப்போ ஒரு ரெசிஸ்டன்ஸ் வந்துடுச்சுன்னு வைங்களா, if say that you have a resistant fungi in your body, there are only 4 drugs you can use, otherwise you have to die. You just simply go to graveyard and lie down, because it's so dangerous that it's very lethal. That's the reason WHO published this list. So there are only 4 classes of antifungal medicines that are currently available. That is the significance. Probably as an extra point, I would like to say what are these 4 antifungal drugs that are currently effective, sir? Appadin kekkumbodhu, it includes polyenes, echinins, ECHNIN, echinins, azoles, AZOLE, azole, and flucytosine. ECHNIN. மோஸ்ட்லி டாக்டர் கிட்ட போனீங்கன்னா ஃபங்கல் இன்ஃபெக்ஷன் வந்ததுன்னா அசோல் இருக்கிற ட்ரக் தான் பொதுவா உங்களுக்கு தருவாங்களே, because that is the effective drug. Now you have only 4 drugs, so we have to ensure that no more resistance comes out again, right? Otherwise the 4 also will become ineffective. That is the significance of this list. 1. Second is, the second importance of this 19 fungal species identified is, these fungal infections also lack rapid and sensitive diagnostics and also mostly unaffordable. That's another problem with this. But in this context, let me add another kind of a tidbit. Usually when we say bacterial infection, it can be contracted by human contact. But fungi is very different. Fungal infection usually is not transmitted directly from human to human. It is transmitted in the form of spore bodies. Fungal usually transmits from human to human through spores. This is something very unique with the fungi. And the second point which I would like to add, if you're a healthy person, if your immune system is healthy and sane, usually you won't get this fungal infections. Normally you won't get these fungal infections. Why? Why a healthy individual won't contract fungal infections is because your body temperature 37 degrees Celsius, or in Fahrenheit, what is the temperature? 97.8. So this 37 degrees Celsius or 97.8 is warm enough for the fungi not to grow. It is kind of very hard for them to grow. But let me add one important point here. Normally, healthy humans are warm enough not to allow the fungi to grow. But due to the recent decades of global warming that we experience, it is believed that fungal species are gaining the ability to survive in warmer conditions. So when the fungals are gaining the ability to survive in warmer conditions, you are not safe anymore. You are safe because they can't grow in warmer conditions, but now they are getting that ability. So here I'm talking about the link between increasing vulnerability to fungal infections and climate change. Increasing vulnerability to fungal infections and climate change, that is also very crucial. So normally it doesn't infect healthy persons. So whom they affect, whom they usually infect? Fungal species are called as opportunistic pathogens. Opportunistic pathogens and infects usually who are ill or immune compromised. Those who are already ill, such as HIV positive persons, they are most vulnerable to fungal infections. HIV positive persons or organ transplantation patients, they are most vulnerable to fungi. Okay, so normally humans are not to fear about the fungi, but the recent days that we are living in, where days are getting warmer and warmer, fungi is gaining their ability to spread and also to infect healthy individuals. Okay, so that's a crux that I would like to say. Now finally, this is a list released by the WHO. What we need to know is the high priority fungal species given in the list. So that includes Candida. Okay, Candida. Candidaல இருந்து ரெண்டு representatives இருக்காங்க, அதனால 2 வந்துடுச்சு. The next is Cryptococcus. Three, Aspergillus. So these are the fungal species that are recognized as the most deadly in the WHO first ever list. Let's move to the next one. The next topic is also quite similar to what we discussed in the first one. Now this is about food animal farming and antimicrobial resistance. I have already told you about antimicrobial resistance, what it means. Antimicrobial resistance simply means that the organisms are gaining the ability to survive the drug exposure. The organisms are gaining the ability to survive the drug exposure is called as antimicrobial resistance. If I tell you as a if I generalize this, sir, yaar sir in antimicrobial resistance kondu vara mudiyumna? For example, this is commonly seen in drug addicts. Initially, a drug addict may take only a little amount of the drug to get that high that they feel. But over the course of time, probably down the line in about 10-20 days, if they're doing it and consuming it more, that amount will not give the high that they expect. They have to take more. You know what's happening? Your body is getting resistant to that. So what has to be done? They have to take more than what they have taken earlier. Understand? So ungalukku resistance develop agunga. Not only the bacteria that we are talking, but even we also develop the same kind. So antimicrobial resistance yarukku varuna, as a blanket point, I will say all living organisms have the ability to develop antimicrobial resistance. all living organisms. So that generalization I can draw. All living organisms can develop antimicrobial resistance. This also can be a questionable point. Which among the following can develop antimicrobial resistance? Normally we know bacteria. Now we may know fungi. But if they're giving some bizarre organisms, remember, as long as it is living, it can develop. Okay, so that's what I've given it here. As long as it is living, it can develop. So, according to WHO, this antimicrobial resistance, according to WHO, antimicrobial resistance is one of the top 10 public health priorities. This is one of the antimicrobial resistance, AMR, is one of the top 10 public health priorities according to WHO. Now, why we are talking about this antimicrobial resistance with the food animal farming? Like I said earlier, when this antimicrobial resistance develops, indiscriminate use of antibiotics, correct? Indiscriminate use of drugs. Indiscriminate use of antibiotics. In a very simple way, this is the basic reason. Indiscriminate use of antibiotics. அப்போ இந்த மாதிரியான விஷயம் எங்கெங்கெல்லாம் நடக்குது, the indiscriminate use of antibiotics, then immediately the picture that comes to our mind is animal farms. Because in the animal farms there is a huge numbers of animals that they grow, and they also started using these antibiotics. Okay, so that is where there is a high potential for AMR to develop, isn't it? Now let's see. So in animal farming, given the definition, food animal farming na enna appdin. So food animal farming is the intense and confined farming of animals such as pig, cow, birds, cattle, etc. in industrial facilities, mostly indoors, in conditions intended to maximize production at a minimal cost. So நிறைய விஷயத்தை சேர்த்து ஒரு டெஃபினேஷனை சொல்லியிருக்கோம். அனிமல் ஃபார்மிங்னா என்ன அப்படின்னு. In animal farming, okay, there are important ill practices, I would say, that has been practiced in them. Let's not worry about the hormonal injections that they use to overgrow the muscle mass. It is also very common that they induce certain muscular mass or lactation in the cattle by injecting hormones. That is very true. So in animal farms la nadiyo ill practices nadakudunga. And the ill practices enna appdi nama paathona, injection of growth hormones, steroids, and lactation hormones. Lactation hormones, particularly I'm talking about prolactin, and hormone called as prolactin. The next most common ill practice followed in this animal farm is abuse of antibiotics. So why this antibiotics is abused in these animal farms? For two reasons. One, for two reasons this antibiotics is abused in these animal farms. First, as a preventive measure. As a preventive measure against infectious diseases. Because these animals are so closely packed with each other, even if a single animal contracts a disease, it will spread to the whole farm in a matter of days. So they will take extreme caution so that these animals are regularly injected with antibiotics as a preventive measure. அதாவது அவங்களுக்கு யூஸ்வலா ஆன்டிபயோட்டிக்ஸ் எப்போ போனா when you are ill, But here they will just inject it regularly without any reason as a preventive measure. Second, but this is kind of a more like a side effect, to increase muscle mass. For these two reasons, to increase the muscle mass, the animals become more bulkier. For these two reasons, antibiotics are very indiscriminately, very abused in the animal farms. So, இதனுடைய consequences என்ன? Okay, what are the consequences of this? As I said earlier, two consequences. Two major consequences. One, what is the first consequence? Can you tell me? When these antibiotics are so abused, first consequences, yes, development of AMR, antimicrobial resistance, development of AMR among these animals. One. And I would like to qualify that, in the AMR வந்துடுச்சுன்னா அவங்களுக்கு மட்டும் அது இருக்கிறது கிடையாது. Please understand, this AMR will spread to the nearby animals. That will also spread to the animal handlers. And animal waste will be thrown out, through the animal waste it also reaches the ecosystem. So this antimicrobial resistance developed with the farm, it has both vertical and the horizontal transmission in the vicinity, in the region. It has both horizontal and the vertical transmission in the region. That's the first one. The second major problem with this is that these animal farms, they are also considered to be the breeding ground for recombination of pathogens. It is also considered to be the breeding ground for recombination of pathogens. A good example for that is bird flu and swine flu. The two influenza virus, the flu virus, that becomes deadlier when the pig is the host. When pig is the host, அது bird flu இருக்கட்டும், அது bird தான் affect பண்ணும். Swine flu இருக்கட்டும், அது it affects the swine pig. But if a pig has both the bird flu and the swine flu, they recombine, which can infect humans. And it is also more deadlier. In the recombination, எங்க mostly நடக்கும்னு சொல்றாங்கன்னா animal farmல நடக்கும்னு சொல்றாங்க. So that's a second danger with this animal farms. Okay, so in this context, is there any major measures that we have taken? I can say about two major initiatives that the Indian government has taken in this regard. The first one is AMR surveillance. Antimicrobial resistance na AMR nu solrom. AMR surveillance and research network. AMR surveillance and research network started in 2013. To what is the purpose? To generate evidence and patterns of, to generate evidence and patterns of spread of AMR in the country. எங்கெங்கெல்லாம் இது பரவுதுன்னு ஒரு பேட்டர்னை டெவலப் பண்ற ஒரு இன்ஸ்டிடியூஷனா, ஒரு இனிஷியேட்டிவா இது இருந்தது. The next major initiative is National Action Plan on AMR. National Action Plan on AMR. The uniqueness about this National Action Plan on AMR is that it adopts One Health approach. It adopts One Health approach. You know what is the One Health approach? See, it is not like plant health. It is not like your health. It is not like animal health or even the ecosystem health. Everything is so interconnected. Unless you manage animal health, your health is also critical, like the COVID. So combining all together and see it as a one perspective, one platform is what called as One Health approach. So let me say very briefly, what this One Health approach stands for. So One Health approach, it is a collaborative. One Health approach na enna, so ஒரே health தான், எல்லாருக்கும் காமனான ஒரு health, அதான் logic. Everyone has the same idea of a health. So One Health is a collaborative, multi-sectoral and a transdisciplinary approach. Collaborative, multi-sectoral and a transdisciplinary approach. Recognizing into the mukkiyam, recognizing the interconnection between the people, animals, plants, and the shared environment. Recognizing the interconnection between the people, animals, plants, and the shared environment. So that is what this National Action Plan on Antimicrobial Resistance deals with. Okay. So this cryptography explains about this resistance, how it can spread to the ecosystem, to the community as well. So you can use it for reference purpose. Okay. Let's talk about the next topic. Now this is called as base editing. This topic is called as base editing. This is kind of very innovative. Let me say a few points about this. See, whenever we talk about DNA, DNA can be imagined as a garland of pearls. Okay. So on the garland, imagine panikanga that you have, that's what DNA simply stands for. Now that in that garland, you have each pearl, right? That each pearl, okay, stands for what we call as nitrogenous bases. And the over pearl is something similar to what is called as nitrogenous bases. You might have heard about this already. Nitrogenous bases na yaar varuvanga na, it includes adenine, guanine, thymine, cytosine, uracil also. Uracil even uracil. And another one also called as inosine. These are commonly called as nitrogenous bases. Which one? What is called as? Protein? Protein base. Seems, where you came across? The protein base. Are you talking about titration? Because in titration of one protein with an acid, we may use something as a base and something as an acid. I think we're talking about titration. I think that's where we use the word base. Otherwise, it has to have a reference to the pH of that particular protein. That's what it stands. No. Please. I'm listening. Why are you talking? Okay. That's not protein, that's purine. Purine and pyrimidine. The name is purine and pyrimidine. Okay. That's too basic. That may be that's UPSC don't ask questions in that manner. Adanala I don't go there. But I think we're talking about purine, not protein. Because in the bases, broadly there are two family of bases, purine and pyrimidine. I think we're talking about that. Purine da solring and anical. That's not protein. No mind, forget it. You understand now, right? Okay, good. So these are commonly called as bases. Like you imagine in a garland of a pearl, that each pearl stands for one nitrogenous base. And your DNA is not simply like that. You have one garland and you have another garland linked together. That's what DNA simply is. Okay. Now usually you will have a pearl which is beautifully looking, and sometimes you may have a broken pearl or some other normal stone. I'm calling it as a mutation. Some changes here happening. That's what we call it as a mutation, right? This is what giving rise to genetic diseases. This is what giving rise to other problems of development, etc. We have developed what is called as genetic engineering, right? We developed the genetic engineering to correct these wrong sequences, to correct these wrong sequences. But usually what genetic engineering does is very simply, let me tell you that. I hope I have you guys on board till now. Okay. Usually, when we have a DNA like this, let's say this part of that DNA codes for a gene. In this gene, let's say this part is problematic. That's where we need to correct. We use many methods to correct this. Okay, we may use, as recent as we are talking about CRISPR, Cas9. We use these methods to correct these errors. But let me tell you how we correct it. Every correct பண்ணுவோம்னா, this is like this. Let's say this wall, there is some error in the wall. What can we do? We can take a minute calipers, we can do minute micro adjustments, we can do that. That is possible. Otherwise, what you can do? You mark it. You use a hammer and break down a small area. Then you rebuild it. When a second you break that area and rebuild it. That's what we usually do here. If this is a problem, if this is a problematic area, usually you know how we do. Okay. See, I couldn't do that adjustment. So how we usually do is, if this is a problematic area, we cut it down. And we offer a new copy, which is good enough. And we attach it there. You see the logic? It's like breaking the wall and constructing it back again. But this method is coming with its own errors. This is not a completely foolproof because you're talking about DNA, very small. Now we are trying to see, can we refine this method? Even CRISPR-Cas9 cannot help here. Even that also can make mistakes like this. Now we are trying to see, can we go more specific? If there is a small hole in the wall, why do we have to break a large area? Let's go and do the correction there itself. Let's say if this is a D, okay. Now in this context, let me talk about what is called as SNPs. Okay, what is called as SNP? SNP stands for single nucleotide polymorphisms. SNP it stands for single nucleotide polymorphisms. Single nucleotide polymorphism. So here, single nucleotide polymorphism generally means an error in a single base. I told you what single base is equal to one pearl. An error in the single base that leads to a genetic disease. A single error in the base leading to a genetic disease. For example, an example for that is cystic fibrosis. Cystic fibrosis is a major genetic disease. You know what's the reason for that? A single spelling mistake. A single spelling mistake has giving rise to cystic fibrosis. So cystic fibrosis SNP sollama, single nucleotide polymorphism sollama. Another example for a SNP, we can say hemophilia. Hemophilia is another example for SNP. Just one error, they have the genetic disease. இப்போ இதுக்கு better என்ன? இது மொத்தத்தையும் இது பண்றதை விட, what is that one single base? Can we identify that and we correct it? This is more specific, more advanced, that is what called as base editing. Here the word base stands for nitrogenous base. That's what the name stands for. Here the base stands for nitrogenous base editing. This is not genome editing. This is not even gene editing. This is base editing. Okay, very, very, very specific. So base editing. Let's talk about this now. So now I will go through this. I hope that you will understand now what is given here. So bases na yarena. Bases are nitrogenous hydrocarbons that forms the DNA and RNA. They are found in both the DNA and RNA. It includes adenine, guanine, thymine, cytosine, uracil, and inosine. What is a base editing? Let me tell you. The whole problem is how to go specifically to that position and change the base. No, that's very specific. Targeting that area. So for targeting, we use CRISPR-Cas9 technology, not CRISPR-Cas9 together. So we use the CRISPR-Cas9 technology, but more particularly, we use only Cas9. So for base editing, Cas9 of the CRISPR technology is utilized. What is the purpose? To target the particular base. Cas9 is used to target the particular base. And then targeting. Next, what has to be done? To change it. Okay. To change, we use two other editors. That two is one, cited in base editors. இவங்க என்ன பண்ணுவாங்கன்னா C will be changed to T. I told you, right? இது இருக்கு தெரியுமா? So they change C to T. Another editor is called as adenine base editor, where A is changed to G. So we use Cas9 plus என்ன சேஞ்ச் கொண்டு வரணும் அதுக்கு ஏத்த மாதிரி we use cited in base editor or adenine base editor. So these are the components of this called as base editing. But why we are talking, okay, now let's talk about what could be the potential uses of this technology. For what possibilities that we can use it means it's very, very huge. But remember, it is very good, it is very safer, because you are not going to deal with many gene areas, correct? It's very specific, correct? And a problem enna, the disease is caused by a single mutation, only you can help with this. Let's say there is a disease, you have 100 different mutations, you have to do this 100 times, which is waste. You understand? So this is more effective for single mutation diseases, for SNP diseases. You understand what I'm saying? This is more effective for those kind of genetic diseases. So now let's talk about its applications. For what uses that we can deploy this base editing? One, SNV corrections. SNV stands for single nucleotide variations. So SNVs can be corrected. Single nucleotide variations can be corrected. One. Second, gene regulations can be better studied. Gene regulations can be better studied. And three, it is also helps in alternative splicing of genes. If I try to explain, you will really go crazy. It's better not to touch it. Just note it down. Alternative splicing of genes, that's enough. Alternative splicing of genes. So these are the three potential applications of this base editing. Now, why we are talking about this? We are talking about this is because in UK, the base editing has been successfully done. This base editing has been successfully done for T-cell acute lymphoblastic leukemia. In a more simply words, blood cancer. So it has been successfully tested. The method of base editing for treating blood cancer in UK. And let me add another last point about this base editing technology. With that, we will move on to the next. This technology can be used for both DNA as well as RNA corrections. எங்க நீங்க பண்ணனும் நினைச்சாலும் இந்த base editing பண்ண முடியும். You can do it for DNA and you can also do it for RNA. It can be done for both DNA as well as RNA, right? So base editing. Let's move to the next one. Now, the next one is about what is called as anti-cancer mRNA vaccine. Anti-cancer mRNA vaccine. But if you want to understand this anti-cancer mRNA vaccine, let's see one simple basic process in life itself. So we have DNA. From the DNA, RNA is produced. From the RNA, proteins are produced. It is the proteins which is doing the works in your body, right? Now this DNA is produced into RNA by which process? The process is called as transcription. Thank you. Transcription. And proteins is produced from RNA by which process called as translation. And DNA can produce itself. It's called as replication. Yes, it's called as replication. But in some viruses, DNA only gives rise to RNA. In some viruses, example retrovirus, HIV, the reverse can happen. DNA can be produced from RNA. Now that is called as reverse transcription. This one is transcription. This is reverse transcription. So literally பார்த்தா என்னன்னா புரோட்டீன்ல இருக்கிற அந்த இன்ஃபர்மேஷன் தான் ஏதோ ஒரு வகையில ஆர்என்ஏல இருக்கு. The information in RNA is ultimately came from DNA. So they are all the same, but in different language. DNA is one language, RNA is another language, protein is another language. That's it. For vaccine, what do we commonly use? We take a bacteria, we take a virus, we kill it, we inject it. It's nothing but proteins, correct? But now what we are thinking, okay, why we are thinking about proteins alone? It is also sometimes giving adverse reactions. It is also becoming dangerous. And the protein should have came from some RNA, it should have came from some DNA, right? If they're thinking, okay, why we have to use only protein? Let's use its DNA, the DNA of that protein. Now that is more safer. This is what is called as DNA vaccine. This is what called as mRNA vaccine. So the protein is what we commonly use in vaccine production. But it is very possible to use its respective RNA or DNA also. The information is the same, right? This is what the basis of what is called as DNA vaccine or what is called as RNA vaccine. So an mRNA vaccine. An mRNA vaccine, an mRNA vaccine, it works. How? By introducing a piece of mRNA that corresponds to a particular protein. In the protein, mRNA is given. Now, if that mRNA goes inside your body, naturally it will be translated into protein. That protein is actually a viral protein or a bacterial protein. And what your immune system will do, it will immediately start its response mechanisms. It will produce antibodies, it will produce immune reactions. You getting protected. So that's what the mRNA vaccines works. It includes the introduction of mRNA mostly along with adjuvants. A molecule called as adjuvants. Adjuvants na yarana. Adjuvants are commonly used in vaccines. Adjuvants na yarana. Adjuvants are those macromolecules that are not immunogenic. They don't cause any disease or problem. They are not immunogenic. Means they are not reacted by the immune system. They are not immunogenic. But triggers the immune system for activation. But triggers the immune system for activation. இது எப்படின்னா நீங்க வேக்சின் எடுக்கிறீங்க, வெறும் வேக்சின் எடுத்து அவ்வளவு எஃபெக்டிவா இருக்காது. அப்ப என்ன பண்றாங்கன்னா they add adjuvants to that. Adjuvant என்ன பண்றாங்க? It activates the immune system. Now that is what adjuvants are commonly used. mRNA அந்த மாதிரி தான், அவங்க தனியா எதுவும் பண்ண முடியாது. So it is added with adjuvants. Right. Now why we are talking about this mRNA vaccine? This mRNA vaccine, recently an mRNA vaccine called as 4157 or V940. Either name can be used. V940 that was created by two pharmaceutical companies, private pharmaceutical companies called as Moderna and Merck. MSD stands for Merck, a company called as Merck. They use this mRNA along with an adjuvant called as Keytruda that are used for advanced melanoma. Melanoma stands for skin cancer. So for skin cancer, an mRNA vaccine was developed. இது வந்து fact. Okay. அப்போ இந்த இடத்துல ஒரு பேசிக் இன்ஃபர்மேஷன் என்ன நீங்க புரிஞ்சுக்கணும்னா, யூஸ்வலா யூபிஎஸ்சி வந்து டைரக்டா நியூஸ்ல இருந்து கேட்கறது கிடையாது. அதனுடைய பேசிக்ஸோ The application of that in a different format is what UPSC asks. What are the two things that we get here? The two things that we get here is mRNA vaccine. So we can use this mRNA vaccine on two different purposes. One, as immune activation against pathogens. Like பொதுவா நம்ம vaccine எதுக்கு எடுத்துக்கிறோமோ அதுக்கு எடுத்துக்கலாம். One, but not only that. இதுதான் என்னன்னா கொஞ்சம் கன்ஃபியூஸ் இருக்கிற மாதிரி இருக்கும், பட் I'll explain it. யூஸ்வலா வேக்சின் சொன்னாலே ப்ரிவென்டிவ் நேச்சர் தான் நம்ம நினைப்போம். Do you use vaccine for treatment? Have you ever thought about vaccine used as a treatment? But here we are using it for a skin cancer. We use a vaccine to treat. So mRNA, you understand what I'm saying? Vaccine usually நம்ம என்ன நினைக்கிறோம்னா it only prevents a disease from coming, but no, it can also be used to treat certain diseases. So the second point என்னன்னா can be used to treat infectious diseases and cancer as well. Melanoma correct? Cancer questions இப்படி தான் வரும். நம்ம படிச்சது என்னமோ இப்படி. Question they will ask generally, which among the following could be the potential uses of potential applications of mRNA vaccine? We usually think in terms of preventive nature, but it can also be used as a therapeutics. It can also be used as a treatment. You get it? So that's about this news. Let's move to the next major area, space technology. Okay, so in the space technology, let's first see about NAVIC, which stands for Navigation in Indian Constellation, which was earlier called as IRNSS, Indian Regional Navigation Satellite System, IRNSS, for which the first satellite was launched in 2013 and the last of its constellation was finished in 2018. In a span of about 5 years, they completed the entire constellation from launching. They completed the launching of this entire constellation. So what are the total numbers of constellation of the satellites? There are 7 satellites. But let me add another point. Actually, this NAVIC has 8 satellites in orbit, out of which only 7 are utilized. So there are 8 satellites in NAVIC, but out of that we use only 7. And what is the configuration of this NAVIC constellation is? Out of this, 3 are in geostationary orbit. I think I explained about the geostationary and geosynchronous in my first class, I think. So let's not go there and spend the time there. So 3 satellites will be in geostationary orbit and 4 in geosynchronous orbit. Right? So that is the configuration of this NAVIC. Already there was a question asked about NAVIC in 2016. So this is also kind of a repeated area. Okay. Now, what does it NAVIC provides? This navigation in the Indian constellation, it is a regional satellite system that can be applicable for Indian border, for Indian nation until up to 1000 kilometers away from its borders. அதாவது இந்த சேட்டலைட்டோட கான்ஃபிகரேஷன் எப்படி வச்சிருக்காங்கன்னா, the satellite can observe the Indian landmass, the entire Indian landmass and about 1000 kilometers from its borders. For example, if this is India, so imagine பண்ணிக்கோங்க சும்மா. Okay, so if this is India, you can, let's say this is 1000 kilometers. So this is the area that this constellation covers. The coverage of this NAVIC is Indian landmass plus 1000 kilometers away from its borders. Now what are we getting from this NAVIC? 2 services. One, civilian purposes, similar to GPS. civilian purposes similar to GPS. The second is strategic uses for military and law enforcement agencies. So there are two services that we get from NAVIC: civilian use and the military use. Now, once this India had completed in launching its entire gamut of constellation satellites in 2018, there are few recognitions that happened. First, about International Maritime Organization. According to IMO, International Maritime Organization, it recognized, this IMO, International Maritime Organization, recognized NAVIC as a part of worldwide radio navigation system. It was recognized as a part of worldwide radio navigation system in the Indian Ocean region. Worldwide radio navigation system in the Indian Ocean region. This global கிடையாதுங்க, regional நான் சொன்னேன், கரெக்ட்டா? So in the Indian Ocean region மட்டும்தான். In the Indian Ocean region in 2020. In 2020, this recognition was given by IMO. Also, this is very similar to GPS. Okay, but when we say the word GPS, actually we are talking about the constellation of satellites launched by US. Talking about US. அப்ப என்னன்னா, as long as we do not develop the equipments and the electronics that can receive this NAVIC and use it, nobody will know about NAVIC. Everybody will be keep on using GPS only, right? So இதுக்கு என்ன பண்றாங்கன்னா, in 2019, the government obligated the OEMs, original equipment manufacturers. It obligated the OEMs to install NAVIC-based vehicle tracers. NAVIC-based vehicle tracers in all commercial vehicles. In all commercial vehicles. In addition to that, one of the well-known chipset manufacturer, Qualcomm have also developed a chipset that supports NAVIC signals. So எல்லாமே இருக்கு. But இருந்தாலும் Indian manufacturers are not keen to use this NAVIC signal for our regional navigation. We still depend on GPS. நிறைய காரணம் இருக்கு, but that's out of the bound for this discussion. So why it was in the news? The news is there was a recent ideation among the government circles to expand the regional system of NAVIC. எதுக்காகனா, to increase its use. So what is it? Expansion of the use. So rather than the original use, now the government wishes to use NAVIC for more purposes. What are the more purposes? To increase its use in the civilian sector and ships, aircraft traveling far from the country's border. So two things. One, civilian and ship navigation. Civilian and ship navigation. And second, air traffic management. And second, air traffic management. In these two areas, that government is very keen to expand the use of NAVIC. But how this can be done? Let's see about that. But getting into this NAVIC is not an easy task. Okay, this satellites that was launched in 2013, and all the 7 satellites were completed by launching within 2018. Remember, this is not like a one-time launch. You have to constantly maintain the satellites in orbit, and if required, you need to launch new satellites to replace them. So in that context, replacement of the constellation, one point I would like to tell you is ISRO is having plan to replace the original NAVIC constellation with the L-band satellites. So L-band satellites may become part of NAVIC constellation. L-band satellites may become part of NAVIC constellations. let me say very briefly about this L band now. L band na enna? L band, இந்த பேண்ட்னு சொன்னாலே இட்ஸ் டாக்கிங் அபவுட் ஃப்ரீக்வன்சிஸ் கைஸ். ஃப்ரீக்வன்சியோட ரேஞ்ச் தான் பேண்ட் நம்ம சொல்லுவோம். ஸோ எல் பேண்ட் ஸ்டாண்ட்ஸ் ஃபார் 1 to 2 gigahertz. L band stands for 1 to 2 gigahertz, which is called as ultra high frequency spectrum, UHF, ultra high frequency spectrum. It is most commonly used in mobile services, GPS, amateur radio, and last and aircraft surveillance. நம்ம ஏர்போர்ட்லாம் ரேடார் வச்சிருக்காங்க தெரியுமா? ஏர்கிராஃப்ட் சர்வைலன்ஸ், ரேடார்ஸ், typically radars. So that L band is going to become part of the NAVIC satellites according to ISRO's plan. The second development is short code. Short code is simply the length of the signal. Currently, ISRO uses a short code. For example, how many mobile numbers are possible if your mobile number is only 8 digits? How much numbers are possible if it is 10 digits? You see the possibility, something similar to that, the strength of the signal. Okay, ISRO currently uses only short code signals in NAVIC, but it also plans to use long codes for strategic sector. That's the next development. The possibility of using long code for strategic sectors is also under the wraps, is also under the plan. Now coming to the last part of this discussion, sir, what about this navigation systems across the world? Is there any names? Of course, we discussed in the discussion, GPS is from US. Even earlier, there was also question in this area. Max of following my question. So let me say very briefly, the famous navigation systems and the origin countries. So GPS US, GLONASS from Russia, BeiDou from China, BEIDOU, BeiDou. Okay, I'll tell you. GPS from USA, GLONASS, GLONASS, GLONASS from Russia, BeiDou, BEIDOU from China, European Union, Galileo, GALILEO, Galileo from European Union. And remember, these four what I have told are global systems. Now, there are also regional systems, regional navigation systems. NAVIC from India. And there is also a regional navigation system held by China. It's called this QZSS. QZSS from Japan is another example of regional navigation system. Japan. QZSS. Okay. Let's move to the next topic. The next topic is about first private launch vehicle. In the last class, I have given you notes about SSLV. Remember, that is also a very important topic. SSLV பத்தி நான் notes தந்திருப்பேன், அதை பாருங்க. அதோடைய another kind of a trajectory development என்ன பார்க்கலாம்னா, first private launch vehicle. So what is the name of that private launch vehicle? Vikram S. Vikram S is the name of that first private launch vehicle developed in India through a mission called as Prarambh mission. So this private launch vehicle was developed by an agency called as Skyroot Aerospace, Bangalore. Skyroot Aerospace of Bangalore developed this Skyroot Hyderabad. Okay, I'll just verify that. Okay, so please don't write Bangalore, I'll verify that. Okay, so Skyroot Aerospace is a private firm that is known to have developed this first private vehicle. But This development of this Vikram S is in collaboration with ISRO. So it is not like they have developed the entirely on their own research. No, it was developed in collaboration with ISRO. That's very important point. So இதை வந்து நீங்க மெயின்ஸ்ல கூட எழுதலாம். How ISRO is now keen and showing readiness to handhold and support the private agencies to augment the Indian space sector. Because for long, Indian space sector is mostly public-led, ISRO-led ventures. But now is a time to move away from this. And it's also time to attract more investments in the space sector. So one such development is enabling the Skyroot Aerospace to develop the first launch vehicle, Vikram S. So this Vikram S, what is the configuration of this launch vehicle? That is also very important. Configuration is a single stage. It's a single stage, solid fuel. It's a single stage, solid fuel launch vehicle. What is its ability, sir? It cannot, இதுதான் முக்கியமான point. Launch vehicle சொல்லிட்டாலே we think about orbits. Which orbit that they will keep the satellites in. Vikram S is not having the ability to launch satellites. It is having the ability to reach the suborbital flight. It cannot place the satellites in the orbit, not so far, not so quick. It is having the ability only to be in suborbital flight. Suborbital flight na ennana, in a very simple way, if we have the Earth and if we launch a satellite, it has to have a certain momentum. Momentum in a very simple words, velocity, speed. To escape the Earth's gravity and to remain in the orbit, it needs a certain speed. But if you retain, if you do not provide such a momentum for the launch vehicle, what will happen is it will go. It's something like, throwing a stone. Obviously, the stone will come down, correct? But only distance is, this is a launch vehicle, so என்ன ஒரே ஒரு டிஃபரன்ஸ்னா usually when you throw a stone it may go and fall here, but this one you throw it here, you fall here. Only thing is in terms of coverage. So it goes to the limits of the space, but it eventually comes down. It will never have a complete orbit by itself. It will never have a complete orbit by itself. அதுதான் suborbital flight. It lacks the momentum needed to be in orbit. Suborbital flight means it does not have the momentum needed to remain in the orbit. That's what called a suborbital flight. So Vikram S is capable only of suborbital flight. And this Skyroot is aiming to develop 3 versions of this Vikram platform. There are 3 versions of the Vikram platform to be developed. Vikram 1, payload capacity 480 kilograms. Vikram 1 with a payload capacity of 480 kilograms. Vikram 2, 590 kilograms. And Vikram 3, 820 kilograms. இது 3 வெர்ஷனுமே is designed to launch in the low inclination orbit. இது வந்து demonstrationங்க Vikram S. But their ultimate aim is to place the satellites. Okay, அந்த வகையில பார்த்தா 3 வெர்ஷன் இருக்கு. These 3 versions are designed to place the satellites in which orbit na? In low inclination orbit. This may be a little distracting. என்ன சார் low inclination orbit என்ன சார் அப்படின்னா it's nothing but equatorial orbit. Low inclination orbit is nothing but a reference to equatorial orbit. For example, if this is the Earth, how the polar orbit usually functions? This way. And low inclination means it is more or less towards the equatorial plane. So that's called as low inclination. இதுக்கு இன்னொரு அர்த்தம் என்னன்னா அப்போ polar orbit is also called as high inclination orbit. So polar orbit is high inclination orbit, equatorial orbit is referred as low inclination orbit. So this is designed to launch satellites in low inclination orbit. Very simple is because this is a startup. Okay, it's a private agency. Launching a satellite on equatorial orbit is more easier. It doesn't require much of a fuel. It doesn't require much of the technology. You simply don't make much errors for the failure. But launching, other when the, for example, if Earth is rotating in this way and the satellite is launched there, it gives natural boost for the satellite to launch. Okay, if Earth is rotating in this way and you are about to launch a launch vehicle in this way, it's not easy. It's very technically difficult. So polar launch vehicles are not easy to master, at least for a new startup. So that's why the 3 versions of the Vikram platforms, they're designed to be keep in the equatorial orbit. That's easier for them to do initially, right? So that's the reason. Okay. Let's continue to the next topic. The next is about what is called as PSLV C54 mission. PSLV C54 mission. C54 அப்படின்னும் பொழுது the 54 stands for the missions that so far been completed. அதுதான் அதோட அர்த்தம் 54வதுன்னு. But there were 2 failures of PSLV earlier. So totally it becomes 56th flight. Because of the earlier 2 failures, it actually becomes into 56th flight of PSLV. Now what were the payloads? There were 3 payloads. In the 3 payload பார்க்கும்பொழுது what you understand is what is the capability of PSLV. One important capability of PSLV is multi-launch capabilities, which literally means in a single launch, in a single mission, it is having the ability to place multiple satellites in different orbits. It is like, like a bus, if it is traveling through a village, it is having lot of goods, lot of vegetables. In every village, they stop, they throw that baggage and move next. And they throw the baggage and move next. It's something similar to that. So when the launch vehicle is so extremely mastered and configured, in a single launch, like the bus, it can launch multiple satellites at multiple orbits. So that's what called as multi-launch capability. PSLV is very well known for multi-launch capability. And remember, GSLV don't have that. GSLV don't have this multi-launch. Only PSLV has it. So this PSLV C54 mission, what are the payload? What were the satellites carried? 5 satellites. இல்ல முக்கியமான satellite ரெண்டே தான், அதை மட்டும் பார்க்கலாம். The first one is INS-2B. INS means Indian satellite to Bhutan. The 2 means it stands for India to Bhutan. It's like Indian gift to the Bhutan, something like that. So this is a collaborative mission between India and the Bhutan with 2 payloads. What is the aim of this? It aims to provide high resolution images with a beneficiary. Bhutan is the beneficiary. It provides high resolution images to Bhutan for the natural resources management, like a forest, the water resources, etc., the glaciers. So that's the aim of this INS-2B satellite. It's a collaboration between India and Bhutan. That's what the name suggests. Sir, what about the others, sir? இதெல்லாம் ரொம்ப ஞாபகம் வச்சுக்கணும்னு அவசியம் கிடையாது. Okay. But probably in the astrocastly, in the name, in the unit மட்டும் என்ன நான் சொல்றேன். Nowadays in satellites, we use this terminology called as 3U or 2U, etc. Okay. And the context மட்டும் explain பண்றேன். This astrocast by itself is not very important. Okay. So 3U na என்ன சொல்லுதுன்னா, actually it is actually the 1U or 2U or 3U. These are actually different configurations. These are different configurations used for naming nano satellites. These are the different configurations used for naming nano satellites. But nano satellites are also called as cube satellites. They are also called as cube satellites. cube எப்படி இருக்கும் perfect shape இருக்குமா every side will have the equal measure correct அதானே cube. So cube satellites usually have a dimension of 10 into 10 into 10 centimeters. This is called as 1U. So this term 3U or 2U refers to the configuration of nanosatellites. Now you understand for 3U na enna artham 30 into 30 into 30. That's what it stands for. That's a configuration that we use for nanosatellites or CubeSats. So that's one important satellite. I told you earlier, INS-2B. So what is the next important payload? Na? EOS-6. EOS-6, which stands for Earth Observation Satellite 6. EOS stands for Earth Observation Satellite 6. So this Earth Observation Satellite 6 belongs to OceanSat series, which means it has its most application on monitoring oceans. It belongs to the OceanSat series. இந்த இடத்துல என்ன கன்ஃபியூஷன் வரலாம்னா we say Earth Observation Satellite but we include oceans. But ocean is a part of the Earth also, right? So OceanSat series. So what is the main utility of this EOS-6? அப்படின்னும் பொழுது it observes ocean color data. Ocean color data we can help to understand many measures. The extent of photosynthesis. What can we use out of this color data? Extent of photosynthesis. Second, the range of coastal pollutions. The range of coastal pollutions. And 3, algal bloom phenomenons. All this can be understood through this ocean color data. Second, sea surface temperatures. Sea surface temperature is mostly used for meteorological predictions. Sea surface temperature, wind vector data that are commonly used. Okay, இந்த மூணு விஷயத்தை தான் this EOS monitors. Color, sea temperature, and wind variable data. But in addition to that, it also monitors few things. Let me say about that. அதாவது இதெல்லாம் நம்ம பண்றோம்னு வைங்களா, இதோட பர்பஸ் என்ன அப்படின்னும் போது, ஃபார் எக்ஸாம்பிள் ஒரு இடத்துல ஆல்கல் ப்ளூம் நிறைய வருதுன்னு வைங்களா, அங்க ஃபிஷ் நிறைய போகுமா, they try to go there and eat that algal bloom, correct? So what are the applications அப்படின்னு பார்க்கும் பொழுது EOS-6 can help us to monitor the fishing zones, can help us to monitor the fishing zones, and also to predict meteorological phenomena, and also to predict meteorological phenomena like cyclones. Okay, let us move to the next topic. So next topic, let's first take up the Nobel Prize in medicine or physiology given in the year 2022. Let's talk about this first. So இதுல பாத்தீங்கன்னா நேம் ஞாபகம் வச்சுக்கிறதுல நிறைய பர்பஸ் கிடையாது. பட் ஏன் அப்படின்னா anyhow you are going to forget it. So if anything you are going to forget it, then what's the purpose to remember it? So அதனால நான் என்ன சொல்லுவேன்னா, see you have to know what's your strength and what's your weakness. Okay, don't try to improve your weakness. You have to do that, but in the meanwhile do not forget about your strength also. You should not forget that. You have to strengthen your strength more. Okay, time இருக்கும்போது weakness டீல் பண்ணுங்க. Okay, so இந்த இடத்துல முக்கியமா என்னன்னா இந்த நேம் வந்து ரொம்ப யோசிக்க வேணாம். Okay, but for what purpose the medicine Nobel Prize was given, that you should remember. Okay, we'll see about that now. So it was received by a Swedish geneticist called as Svante Pabo for this research. இது நிறைய கெஸ் கூட பண்ணலாம். So this is about the discovery of the human genealogy, okay, in the ancient times. அப்ப அது யாரு பண்ணிருக்க முடியும்? ஜெனடிசிஸ்ட் தான் பண்ணிருக்க முடியும். So that's a clue. So it is done by a Swedish geneticist. நீங்க என்ன ஏரியா பண்ணாதுன்னு தெரிஞ்சா அவர் என்னன்னு தெரிஞ்சுக்கலாம், இல்ல அவர் என்ன ஞாபகம் வச்சுட்டீங்கன்னா என்ன ஏரியால பண்ணிருப்பாங்கன்னு கெஸ் பண்ண முடியும். இட்ஸ் கைண்ட் ஆஃப் கோரிலேட்டட் டு ஈச் அதர். So Swedish geneticist Svante Paabo, எதுக்காகனா for his research in the field of genomes of extinct hominins and human evolution. So what is its contribution? Its contribution to understand the better of human evolution. அவர் என்ன கான்ட்ரிபியூஷன் பண்ணார் ஸ்வாந்தே பாபோ பாத்தீங்கன்னா he contributed so much so that it resulted in a new field to emerge. His contribution was so much, ஒரு புது ஃபீல்டே வந்திருக்கு. என்னன்னா பேலியோ ஜீனோமிக்ஸ். Paleo genomics actually emerged because of the researches this guy has done, Svante Paabo. So what he has done? What were his contributions for which Nobel Prize was granted? Let's see about his contribution. The first one, sequencing the genome of the Neanderthals. Neanderthals. So Neanderthal அப்படின்னு நம்ம யாரை சொல்றோம் அப்படின்னா, usually we knew that human evolution have originated in the southern tip of Africa நம்ம பொதுவா சொல்லுவோம். But that actually happened about 300,000 years ago. But meanwhile, இவங்க இல்லாம தனியா ஒரு பாக்கெட் ஆஃப் எவல்யூஷன் நடந்தது. நம்ம sometimes we usually think, ஒரு பழமொழி சொல்லுவோம் இல்லையா தமிழ்ல, பூனை கண்ணை மூடிக்கிச்சுன்னா உலகம் இருண்டுடுச்சு நினைப்புன்ற மாதிரி. It's not like human have evolved only there. It doesn't mean that nowhere else they have evolved. No. But actually in Eurasia, another small pocket of human-like organisms also evolved. Similarly, Africa evolve ஆன மாதிரி யூரேஷியாலயும் ஒரு தனி பாக்கெட் இவால்வ் ஆனாங்க. ஆனா என்ன தெரியுமா ஆச்சு? During the course of time, this one who evolved from Africa, correct, they were so able because of the cranial development. They can think better, they can think far ahead. இந்த யூரேஷியால இவால்வ் ஆனவங்க பாத்தீங்கன்னா they are outnumbered and they were dominated and ultimately they got extinct. அப்படி எக்ஸ்டிங்ட் ஆன அந்த பாப்புலேஷன், அந்த பாக்கெட் ஆஃப் த பாப்புலேஷனை தான் நம்ம நியாண்டர்தால்னு சொல்றோம். ஸோ நியாண்டர்தால் இஸ் ஆக்சுவலி another pocket of human evolution that doesn't exist anymore. So that Neanderthal was sequenced by this person. So you understand what Neanderthal now, right? Let me say a few points, important UPSC oriented points என்னன்றதை பார்க்கலாம். Neanderthals. So they have inhabited, Neanderthals have inhabited in the Eurasia. In the Eurasia, from the Atlantic until up to Central Asia. From the Atlantic to the Central Asia, they have that dominance in about 150,000 years ago. But when they had gone extinct, 20,000 years ago. 20,000 வருஷம் முன்னாடி they died. Completely they died. They got extinct. They got extinct 20,000 years ago. தோராயமா என்ன சொல்லலாம், ஒரு 130,000 வருஷம் வாழ்ந்திருக்காங்க. 130 years or something, so they have lived in this particular region. இவங்களோட யூனிக்னஸ் என்ன அப்படின்னா, they also showed the primitive features of a modern man. They show the primitive features of a modern man, including cranial development. Including cranial development, they showed the primitive features. அவங்களோட other uniqueness என்ன அப்படின்னா, they knew the knowledge of using tools. They knew the knowledge of using tools, fire. They made clothing. They wear clothing. They made clothing and also made ornaments. They are also known to have made ornaments. What was the reason for their extinction? Domination by the Homo sapiens. Pure domination. They just couldn't survive. So that Neanderthal sequence, genome sequence, because the last one survived 20,000 years ago, other sequence பண்ணிருக்காரு this person. Okay, that's a first contribution. So Neanderthal, that That topic is important, UPSC perspective. Second, discovery of a previously unknown hominin called as Denisova. இது உங்களுக்கு PPT-ல இருக்கு, but let me add a few more points into this. Okay. Here you may come across a word called as hominin. Even already we have this word hominin, right? What does this hominin stands for? Hominin na enna nama பேசுறோம்? Yeah. In a far off, correct, but not very specifically. Let's talk about this. Hominin, this word hominin can be better understood by another closely related word called as hominid. Hominid. So hominid na enna? Hominid, it includes all the modern and the extinct great apes. Hominid na yarana, it includes the now living, all the modern and the extinct great apes, which includes humans. The great ape abdin the category which comes humans also. Humans, chimpanzee, orangutan, etc. That group is called as hominid. Hominin, that includes the modern human lineage. That includes, hominin includes the modern human lineage, which includes the now only living species yare? Homo sapiens. Homo sapiens, Neanderthals, another one called as Australopithecus. Australopithecus. So these comes under hominin. So பொதுவாகவே ரொம்ப பழைய விஷயத்துல பார்க்கும்போது, because we were all from monkey, அவங்கள எல்லாம் சேர்த்து பார்க்கிறது ஹோமினிட். மனுஷங்களா நம்ம தனியா இவால்வ் ஆயிட்டோம் தெரியுமா, அவங்கள மட்டும் தனியா பார்க்கிறது ஹோமினின். So we are talking about hominin. So Denisova அப்படின்ற ஒரு hominin, it was discovered by this person, Denisova. So what is this Denisova அப்படின்னா, it is actually a fossil that was obtained from a cave called as Denisova. It's a name of a cave in Siberia. Denisova ஏன் அதுக்கு பேரு வச்சாங்கன்னா, because that fossil was obtained from a cave in Siberia. The cave name is Denisova. So we kept the same name here also. So that was discovered by this person. The third, that's something very important. The third, what he has discovered, he also discovered the gene transfer. நம்ம முன்னாடி ஹோமினின் யார் யாரு பார்த்தோம்? நியாண்டர்தல்ஸ் பார்த்தோம், ஆஸ்ட்ரோலோபித்திகஸ் பார்த்தோம், மாடர்ன் ஹியூமன்ஸ் எல்லாம் பார்த்தோம். Even though they were lived in separate geographical regions, there were gene transfers between them. Okay, so that was discovered by this person. In fact, it is believed that 2% of Neanderthal genome is in every one of our genes in சொல்றாங்க. 2% of Neanderthal genome is in our gene, which means it got transferred. இதை கண்டுபிடிச்சவதான் யாருன்னா this person. Okay, so gene transfer between the members of hominins. The third important contribution is gene transfer between the members of the hominins. So இந்த ஜீன் டிரான்ஸ்ஃபரை பத்தி படிக்கிறோம் கரெக்டா? the gene transfer among our past ancestors, இதனுடைய significance என்ன சார், இதோட relevance என்ன அப்படின்னு சொன்னோம்னா, two relevance is there. For the relevance of the gene transfer, there are two. The first relevance, the ability of our immune system to fight certain infections. We got it from them. The ability of our immune system to fight certain infections. We got it from them. The gene transfer pati pesala, we received the genes to fight infection from them. First significance. And second, it also helps. It also helps in understanding. It also helps in understanding the concept of phylogeny. Better. Phylogeny. Phylogeny, in a very simple way, called as family tree. phylogeny to simplification கேட்டிங்கன்னா family tree ன்னு சொல்லுவாங்க. To understand the phylogeny better, the gene transfer மூலமா we all can do that. Now moving to the next point. Why I am standing with this? Because of two reasons. One, it's Nobel Prize information, and second, it has lot of nuances within that information where question can be framed. That's the reason I'm staying here a little more longer. This you may not get only by reading any notes or even this PPT. So that's the reason I'm spending more time. Okay, and important also quite well. The next point which what I would like to share is how he has made this discovery, how it was made possible. Now he studied using mitochondrial DNA. How we made this discovery? He studied using mitochondrial DNA rather than nuclear DNA. Usually நாம என்ன பண்ணுவோம்னா, these are fossil samples, bonesல இருந்து எடுப்பாங்க, கரெக்டா? But these were so old that those nuclear DNA samples could not have survived the natural elements. The water, heat, everything would have destroyed it. So nuclear DNA would not offer him the health that he wants. அதுக்கு என்ன பண்ணாருன்னா, he started using mitochondrial DNA for this research analysis. அப்போ இதுல ரெண்டு விஷயம் அடங்கி இருக்கு. Mitochondria has its own DNA. That basic point is hidden here. நம்ம நியூக்ளியஸ்ல மட்டும் தான் DNA இருக்குன்னு பார்க்கறோம், கரெக்டா? இல்ல இன்னொரு இன்ஃபர்மேஷன் என்ன இருக்குன்னா, mitochondria has its own DNA. செகண்ட் பாயிண்ட், நம்ம டிஎன்ஏ சொல்றோம் தெரியுமா? உங்களோட ஒரு செல்லுல போனீங்கன்னா, ஒரே ஒரு செல்லுல எடுத்துட்டு அந்த ஒரு செல்லுல உள்ள நியூக்ளியஸ்குள்ள போனீங்கன்னா 46 குரோமோசோம் இருக்கும். ஒவ்வொரு குரோமோசோமும் அந்த அத்தனை காப்பீஸ் தான் இருக்கும். But if you go to mitochondria, there is only one DNA but presents in thousands of copies. ஒரே DNA thousands of copies இருக்கும். That is why. So there's a possibility of getting the DNA easier, no? Rather than nuclear DNA, if there are thousands of copies present, it's easy to discover. That's why you use mitochondrial DNA. Why? It occurs in thousands of copies. Because it occurs in thousands of copies, it's fairly easier to detect them. So he used mitochondrial DNA for his fossil genetic analysis. Okay. Let's go to the next Nobel Prize in chemistry. Nobel Prize in chemistry. Now, Nobel Prize in chemistry was shared between three scientists: Caroline Bertozzi, Morten Meldal, and the fourth one is K. Barry Sharpless. One unique point about the Sharpless is he received Nobel Prize second time. He already received it in the year 2001 for his discovery on chiral, for his work on chiral catalysis. I'm sorry, not chitral. I'm sorry. That was a spelling error. Chiral. Catalysts. In 2001, he received a Nobel Prize in chemistry for chiral catalysts. In 2022, he received a second Nobel Prize for his work on click chemistry, called as click chemistry. Okay. Now, what this basically click chemistry is, you may read this, but let me explain you in a way that you can understand it easier. Usually, nowadays we are requiring we need a lot of new drugs, new pharmaceutical products, new molecules for our various purposes, whether cleaning the pollution or treating the disorders. We need these molecules. There are two ways that we can get it. Either you have to go to nature and find it. Oh, whether this mushroom has it, or whether that bacteria has it, or whether this coral leaf has it. That is one way to do it. The second way, you synthesize on your own. கரெக்டா? இப்போ நம்மளுக்கு ஒரு மருந்து வேணும்னா என்ன பண்ணலாம்னா ரெண்டு வகை இருக்கு. ஒன்று போய் தேடணும், நேச்சர்ல யார்கிட்ட அது இருக்குன்னு தேடணும். That's called as bioprospecting. The second is chemical synthesis. You have to make it on your own. This chemical synthesis of this molecules is usually a long and winding process. It is not an easy task. Usually how it is done is, it is done more like a 3D printing. You have seen 3D printing by now, you all would have been aware. Atom by atoms are added to get the whole object of your design, of your interest. In the chemical synthesis, also called as de novo synthesis, it is called as de novo, from the scratch. De novo synthesis. How it is done is, let's say this is one, it is added with this is added with another, it goes step by step. It's a very complex. For example, இப்போ வந்து உங்களுக்கு ஒரு பெரிய மாலிகுல் வேணும்னு வைங்க, ஒரு எக்ஸாம்பிள் நான் சொல்றேன். இந்த மாதிரி ஒரு பிரான்ச்சிங்ஸ், இதுதான் உங்களோட பர்பஸ் தான் வேணும். எடுத்த உடனே அது சிந்தசைஸ் பண்ண முடியாது. You have to produce this, 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 then you have to link them all together. It's a very difficult task. It also consumes lot of energy. It also generates lot of waste as well. This is called as chemical waste. It also generates lot of chemical waste. This is the common problem with the chemical synthesis, de novo synthesis. What Sharpless has done is, he has identified that in nature, okay, your body is also doing the same thing, but your body is doing with a different way. I'll give you an example for that. There is one molecule called as glyceraldehyde. You wouldn't believe it. This glyceraldehyde is a common for fat, protein, and even for DNA. அப்போ ஒண்ணே எப்படி பல விஷயத்துக்கு branch ஆகும். So this is like, how can you use a parent molecule with a smaller changes, you can make anything else. He studies this aspect of nature, how nature is doing. Nature is having so many variety of molecules. How it does? He identified there are 29 class of parent compounds. There are 29 class of parent molecules, which is standard across the organisms. இந்த 29 permutation combination போட்டு ஆட் பண்ணி எடுத்து வேற காம்பினேஷன்ல போட்டு தான் அந்த so many different molecules are present in the nature. இதை இவர் கண்டுபிடிக்கிறார். அப்ப என்ன பண்றாருன்னா, you take one, he takes another. அத ஒவ்வொன்னா பில்ட் பண்றதை விட, not like a 3D printing. He takes his parent molecules and he optimized how that can be added. Like a click, ஒரு பூட்டு போட்ட ஒரு சத்தம் வந்துமா, it gets locked. So he takes one, he uses a specific chemical reaction. Let's not go there. He uses a specific chemical reaction to link them, to covalently link them. This is what called as click chemistry. So click chemistry deals with what? Click chemistry deals with synthesis of large molecules. Click chemistry உங்களுக்கு ஓரளவுக்கு புரிஞ்சிருக்கும்னு நான் நினைக்கிறேன். So click chemistry-யோட easy way how to understand it na, click chemistry என்னன்னா, it is a synthesis of large molecules. It is a synthesis of large molecules, essentially from a group of group of base systems, and the base oda combination da matta ellame use of base system. For example, na sonna therma glyceraldehyde is a base. இதை வச்சு fat create பண்ணலாம், இதை வச்சு sugar create பண்ணலாம், இதை வச்சு பண்ணலாம், அதுதான் base ன்னு சொல்றோம். So of base that can be linked using copper. Usually use what is called as copper. So this is called as, இதுதான் என்னன்னா building block ன்னு சொல்றது. This is what we use the word building blocks here. ஒண்ணா ஆட் பண்ணுவோம் தெரியுமா, that's what he referred as a building block. So this is called as click chemistry. That was his contribution. But what about the role of the others who also shared the Nobel Prize? The others were contributed for their role in bio-orthogonal chemistry. So ரெண்டு விஷயத்துக்காக Nobel Prize தந்திருக்காங்க. ஒன்னு click chemistry. Click chemistry is a building a large molecule essentially from a family of base. What is bio-orthogonal? இந்த click chemistry-ய living cell-க்குள்ள பண்ற ஒரு டெக்னாலஜி அவங்க டெவலப் பண்ணாங்க. So conducting of the click chemistry, okay, conducting the click chemistry within living cells constitutes bio-orthogonal chemistry. அதை அவங்க அச்சீவ் பண்ணாங்க. So that's what the contribution for which they were recognized for Nobel Prize in Chemistry in 2022. So this picture is self-explanatory. Click chemistry எப்படி add பண்றாங்க அப்படின்றது. So okay, let's not go there anymore. The third one, Nobel Prize in Physics. The third one, Nobel Prize in Physics for what? Let's see about this. Here also it is shared between 3 persons for what? For identification of quantum entanglement process. For the identification of quantum entanglement process. Quantum entanglement is a concept first developed by a scientist called as Erwin Schrödinger. In 1935. It was called by Albert Einstein as a spooky action in a distance. In the quantum entanglement, Albert Einstein என்ன சொல்றாருன்னா spooky action in a distance. You guys know what a quantum entanglement is? ரொம்ப சிம்பிளா என்ன சொல்லலாம் அப்படின்னா, let us take 2 photons. Okay, 2 photon எடுத்துக்கலாம். Photon ஒரு தனி ஒரு ஆளு மாதிரி பாருங்க. ஒரு imagine that as an individual, 2 photons. They have to behave differently, correct? அவங்க தனித்தனியா தான behave பண்ணனும். Their behavior has to differ. என்ன பண்றாங்கன்னா, they bring the photon closer in the same system. System means the conditions is the same. That's called a system. So they bring the 2 photons closer in the same system. It means they become entangled. Entangled means like this. They become entangled. Now once this entangled happens, you take the photons far away. ஒரு photon ஒரு மூலைக்கு இன்னொரு photon இன்னொரு மூலைக்கு கொண்டு போங்க. Imagine the universe is so vast, correct? You take, theoretically, you take one photon to the one end of the universe, you take the other photon to the other end of the universe. Even light will take trillions and trillions of years to pass. Isn't that logic? So you cannot give any information. It will take millions, as I said earlier, trillions of years to even go. In this photon, if you make a small change, okay, if you, let's for example, idhula charge onnu modify பண்றீங்க, immediately that photon will undergo the same change. Whatever the change this guy undergoes, that guy also undergoes. Once they are entangled, they behave like one entity. This cannot be understood. How they communicate what change they are undergoing to there? Even light cannot go beyond, even light cannot go that fast. In that moment, the change happens there. This is what called as quantum entanglement. This is what Albert Einstein called spooky action in a distance. So either first in the phenomenon of first explain pannavar Schrödinger by a thought experiment called as cat in a box. By a thought experiment called as cat in a box. It's a very interesting thought experiment. என்ன பண்றான்னா, ஒரு பாக்ஸ்ல வந்து the most potent ஒரு டாக்ஸினை வச்சிடுறாரு. அதுக்குள்ள ஒரு கேட்டை போட்டுறாரு, மூடிடுறாரு. இப்போ now the question is to you, whether the cat is alive or not. How do you know? Once you open, the cat can exist in multiple possibilities. It may be dead, it may be alive, it may be both alive and dead. But once you observe it, அதாவது once it is externally observed, all the possible states are lost. It can exist in only one state. You understand? So, but box moody irundhingana, it can remain in any possible number of state அப்படின்றாங்க. So this is kind of a very convoluted thinking. ரொம்ப சுத்தி விடுற மாதிரியான ஒரு thinking. It can exist in any form. The moment you open it, it can exist in only one form. It may be alive or it may be dead, but never the both. Right? So this is what called as cat in a box situation. First explained by Schrödinger for quantum entanglement. So that was proven by these 3 scientists, for which, see, I don't get your question. Yeah. See, the point is the existence of a multiple states is an aspect of a quantum principle. For example, when I'm a light, we say you are seeing the light now because it is behaving like a wave. It gets reflected, it gets refracted. இதெல்லாமே நடக்குது because light acts as a wave. But you keep a solar panel, நம்ம சோலார் ஜெனரேட் பண்றோம் இல்லையா, you keep a solar panel. Solar panel electricity is generated when the light falls, you know. But you know how the light can generate? The electrons in the solar panel are knocked. That knocked electrons has to run. That constitutes electricity. What is electricity? Nothing but the movement of electrons. The electrons has to be physically knocked. இப்போ பிசிக்கலா நாக் பண்றது பார்ட்டிகலா இருக்குமா வேவா இருக்குமா? ஒரு கல்லை இன்னொரு கல்லால் தானே அடிக்க முடியும். நீங்க ஒரு கல்லை வச்சுட்டு லைட் அடிச்சீங்கன்னா கல்லு கீழே போகுமா? So light behaves in some cases as a wave, in some cases as a particle. இப்போ இது வேவா பார்ட்டிகலா கிடையாது, சொல்ல முடியாது. கண்ணாடி வச்சீங்கன்னா வேவா மாறிடும், சோலார் பேனல் வச்சீங்கன்னா அது பார்ட்டிகலா மாறிடும். It exists in both states unless you observe. This is called as quantum principle. Quantum principle says the particle can exist in multiple states at the same time. இதனங்க qubit. What is qubit? நம்ம போன வருஷம் क्वेश्चन என்ன கேட்டாங்க? It's a unit of quantum computers. It's a unit of quantum computers where digital computers can compute only based on 1 and 0, either 1 or 0. But qubit is not like that. 1 0 1 0 0 1 all at the same time. adane kaithu in a box. Adunude one of the application is quantum entanglement. It is not the same, but it's application of that, right? Okay. So that's what the Nobel Prize in Physics. First level of understanding enna pananona, you don't worry about these concepts. First level for what they have received the Nobel Prize. Medicine for understanding the human evolution. Second, for chemistry, click chemistry and bioorthogonal chemistry. And third, physics, it's for quantum entanglement. The second level of understanding, if you're comfortable, you go to the details what I told you. Okay, if you're not comfortable with that, you don't have to. Let's move to the next one. The next topic is about Kudankulam nuclear power plant. Kudankulam nuclear power plant is a 6,000 gigawatt capacity power plant. 6,000. I'm sorry, 6,000 gigawatt. I'm sorry, that's a mistake. 6 gigawatts. It has 6 units, each with 1,000 megawatt. So I intended 6 gigawatts. So it is a 6 gigawatt capacity nuclear power plant operated by India, but technically supported by Russia. Aதாவது Indo-Russian collaboration in the nuclear energy is best exhibited in KKNPP. Okay. Where என்ன மாதிரியான reactor இங்க வச்சிருக்காங்கன்னா, there are 6 reactors that belongs to class called as VVER. The reactors is called as VVER 1000. This is their classification. This VVER 1000 is a Russian classification of the nuclear reactors. But ஒரு common parlance la பார்த்தோம் அப்படின்னா, this VVER 1000 belongs to pressurized water reactor, PWR. This VVER is nothing but PWR, pressurized water reactor. A pressurized water reactor la yaar moderator coolant ah irupanga theriyuma? The moderator is okay. What PWR stands for? Pressurized water. Idhula engiyavadhu heavy water and reference varudha? Here let's say for example PHWR. What PHWR stands for? Here it clearly says heavy water. Now you can say moderator is heavy water. Now once it is PWR, it's only the normal water but operated under pressure conditions. Avladha. So it's a light water, it's not heavy water. So in PWR, light water acts as a moderator and a coolant. Light water acts as a moderator and coolant. See, nuclear technology is adu sonnona romba neram aidum, adnala I'm simply saying moderator and coolant. I'm moving on. Okay, I hope you guys understand. Already read that. So light water acts as a moderator and a coolant, and low enriched uranium is used as a fuel. Low enriched uranium, also called as LEU. Low enriched uranium is used as a fuel. So இது என்ன சார் LEU அப்படின்னு சொல்றீங்கன்னா, LEU means an uranium enriched up to 20%. An uranium enriched up to 20% of U-235. When uranium-235 is enriched up to 20%, it is called as low enriched uranium. This low enriched uranium is the fuel. And for VVER 1000 that India uses in KKNPP, the fuel is supplied by Russia. It's not like we use our domestic fuel, our nuclear fuel. The fuel is completely sourced from Russia. So அவங்க என்ன குவாலிட்டி ஃபியூவல் தராங்களோ அதுக்கேற்ற ப்ரொடக்ஷன் தான் நம்ம கிட்ட நடக்கும். Now why it was in the news? Now recently we are about to receive advanced fuel from Rosatom. Rosatom is a nuclear company. So KKNPP is about to receive advanced fuel from Rosatom. Sir, in advanced fuel நால என்ன பர்பஸ் சார் அப்படின்னா, if you take one fuel complex na it's like a cylinder rod மாதிரி இருக்கும். You take one fuel complex, you load it into the reactor core, it can run for about 18 months. After 18 months, you have to remove the core, you have to load it with a fresh fuel, like a tank fill பண்ற மாதிரி. Advanced fuel na என்ன அர்த்தம்னா, it can run for up to 24 months. So advanced fuel option ஓட யூஸ் என்னன்னா, from the earlier 18 months, it can operate up to 24 months. That's the difference. From the earlier 18 months, it can operate up to 24 months. So in the 24 months, அது continuous operate ஆகும், கரெக்டா? அப்ப அதனால, for example, sir, அப்போ 18 months na எவ்வளவு 1.5 years. So you have to stop the production, you have to load the fresh fuel, you have to optimize the reactor again, it will take another 4-5 months. So in advanced fuel oda uses enna sollalana, it ensures more efficiency, additional power generation due to prolonged operation and savings of foreign exchange. ஒரு பொருள் வாங்குறீங்க 1.5 வருஷம் வருது, இன்னொரு 2 வருஷம் வருதுன்னா you save money also, right? It also saves foreign exchange that we spend on these fuel complexes. So this is about the update that happens recently related to KKNPP. I think, I don't know whether I told that or not, which is the largest nuclear power plant in India, na KKNPP. Na. So Kudankulam nuclear power plant is the largest nuclear facility in the world. Ah, thank you for that. In India, yes. So as of now, there are 22 nuclear reactors operating from India. Sir, KKNPP 6 gigawatt வந்துரும். ஆனா நம்மளோட total nuclear power generation 6780 சொல்றீங்களா, எப்படி சார் மேட்ச் ஆகுதுன்னா, the 6 units of KKNPP, right? Out of which 2 is operational and 4 more is under operationalization. It is yet to be constructed. That's Kudankulam protest was happening. They don't want the more units to get operated. As of now, 2 gigawatts வருது. It's completely functional. So அதனால கன்ஃபியூஸ் ஆயிடாதீங்க. ஏன்னா அதோட கெப்பாசிட்டியும் total nuclear capacity vary ஆகிற மாதிரி இருக்கும். So don't get carried over by that. So now I have given you the list of now operational nuclear facilities and the states. This can be a question also. So when we talk about Kudankulam nuclear power plant, it is a showmanship of collaboration between India and Russia. Similarly, there is also another collaboration about to come up, Jaitapur nuclear power plant, and that's a collaboration between India and the France. So similarly, the list that is in the project phase, that is not yet completed. Okay, so Jaitapur nuclear power plant. Also aims to have 6 units with a total capacity for 9.6 அப்போ ஒரு யூனிட்டோட கெப்பாசிட்டி எவ்வளவு சொல்லலாம்? 1600, கரெக்டா? 1600 megawatts. Totally 9.6 installed capacity with the technical cooperation from France. Okay, let's move. Yeah, Rajasthan. Let's go to the next one. The next one is about what is called as fusion energy breakthrough. So in the fusion energy breakthrough la rendu vishayam mukkiyama irukku. What is the two thing is what they have used for the nuclear fusion to happen, one, and second, just a minute, what is called as net gain result. I think I didn't give it in the slide. Net gain result. இந்த ரெண்டு விஷயம் தான் இந்த டாபிக்ல ரொம்ப முக்கியம். I hope you guys know what basically fusion energy stands for. Fusion energy stands for the fusion of lighter elements. The fusion of lighter elements of hydrogen isotopes, particularly deuterium and tritium. Protium usually use பண்ண மாட்டாங்க. Hydrogen can exist in 3 isotopes னு உங்களுக்கு தெரிஞ்சிருக்கும். ஹைட்ரோஜன்ல 3 ஐசோடோப் இருக்கு. புரோட்டியம், டியூட்டீரியம், ட்ரிட்டியம். இதுல நம்ம ஃபியூஷனுக்கு பொதுவா எதை யூஸ் பண்ணுவோம்னா டியூட்டீரியம் and tritium is what fused. Deuterium and tritium is usually fused, not protium. Even though hydrogen நம்ம பொதுவா சொல்லுவோம் hydrogen are fused, but specifically it's not hydrogen. Deuterium and tritium should be specifically said. So already we are seeing lot of developments in this area, in the area of a nuclear fusion. முக்கியமா என்ன சொல்லலாம்னா artificial sun of China called as yeast reactor, experimental advanced supercomputing tokamak, yeast, experimental advanced supercomputing tokamak, or ITER, which is located in France. ITER stands for International Thermonuclear Experimental Reactor. இவங்க எல்லாமே ஃபியூஷன்ல இன்வால்வ் ஆயிருக்கக்கூடிய முக்கியமான ரிசர்ச் சென்டர்ஸ். And another one in this whole is Livermore, Lawrence Livermore facility. Another important Lawrence Livermore facility. What is the main difference here? One of the difference, sir, இவங்க என்ன சார் பண்ணாங்கன்னா they attain the highest temperature of more than 100 million degrees. 100 million degrees they reached. Highest temperature அவங்க ரெக்கார்ட் பண்ணிட்டாங்க. This not a big deal so far, because it's still yet to be completed and operated and done things what it has to do. But the only thing is it is an international collaboration that you guys know of, which India is also a part. Now that is different. Now Livermore, Lawrence Livermore facility la uniqueness enna inda topic la enna na they have achieved net gain. They have achieved a net gain in their experiment. That is unique. Sir, appo east of China enna sir pannanga, they have not attained net gain, but this for the first time attained a net gain in the nuclear fusion. So what does this net gain means? ஒரு ஃபியூஷன் ஜெனரேட் பண்ணணும் அப்படின்னா it always requires an input energy. You have to give a huge amount of energy. இது எப்படின்னா this is like, you want to make a lot of profit, first you have to invest lot. Only out of that huge investment you get the profit, something like that. You have to spend energy to make more energy. ஆனா இது வரைக்கும் ஃபியூஷன் எப்படி இருந்திருக்குன்னா the energy that you give to make the fusion is always higher. ஃபியூஷன் நடக்கும், அதுல இருந்து எனர்ஜி வரும் தெரியுமா, அது எப்பவுமே கம்மியா இருக்கும். Which means it's uneconomical, it's uncommercial. You are always spending more but you get less. There is no profit. net gain na என்னன்னா when the energy produced from fusion reaction is more, when the energy produced from the fusion reaction is more than it is needed to create them, no, that is called as net gain, which means output is more than input in a very simple way. When output is more than input, this net gain is usually referred in the circles as Q factor. It is usually called as a Q factor. So what is the significance of a nuclear fusion? Nuclear fusion, nuclear fission is common. KKNPP pati pona slide la pathom. Because it can be commercialized, it produces more energy. அதே மாதிரி nuclear fusion எப்போ commercialize பண்ண முடியும்னா, we can commercialize fusion only when Q is more than 1. Only when Q is larger than 1, then it is possible to have the nuclear fusion to be commercialized. That for the first time they have attained. Okay, that's the first significance. So this is like a kind of a start. Anna, it is not a significant gain. It is not a significant energy they produce more, but it's still a gain. First. Second most important point we need to know is what is the difference with ITR with respect to this? Even ITR, they are doing nuclear fusion. In Lawrence Livermore of US, they are also doing fusion. What's the difference? In ITER, they use tokamaks for magnetic confinement. Magnetic confinement, which simply means they use magnets, very strong magnets called as tokamak. Tokamak is name of a magnet. Tokamak is actually a very strong magnet for containing the plasma. Okay. But here in Livermore, they have used about 192 lasers for the fusion to continue. That's a major difference. இவங்க ரெண்டு பேருக்கு இருக்கிற முக்கியமான difference இது சொல்லலாம். First, net gain that they have recorded for the first time, and second, the ITER used magnetic confinement using tokamaks. In fusion breakthrough that Livermore done, they use 192 strong lasers. So that's a difference. So as usual, we are almost we completed science and tech, but environment as usual ரொம்ப முக்கியமான டாபிக்ஸ் தான் சூஸ் பண்ணி தந்திருக்கேன் உங்களுக்கு. It has been shared with you, but the time is up, so I'm giving it for your reference. நீங்க யூஸ் பண்ணுங்க. இல்ல முக்கியமான பாயிண்ட்ஸ் தான், முக்கியமான டாபிக்ஸ் தான் வந்திருக்கும், but most often they are kind of not very complicated topics. One about biomass co-firing, the concept of a biomass co-firing, very simple. ஏன் கோலை மட்டும் எரிக்கிறீங்க, ஒரு 10% கோல் எடுத்துட்டு கூட பயோமாஸை சேர்த்து எரிக்கலாமே அப்படின்ற கான்செப்ட். But not every coal plants can do that. They have to have special equipments modified for that. So, and the targets is going to be missed. Adha patti irukkudiya oru topic, biomass co-firing. What are the types of biomass co-firing? I given it in the picture: direct, indirect, and parallel co-combustion. So, go through this. And also, what are the challenges with respect to the biomass co-firing in our country? Adha tandirken, it's self-explanatory now. Okay. And what is called as green steel, because in steel formation, in steel we use coal. Okay, we actually with steel enna pandrona, we fry, simply enna pandrona, we fry the iron with the coal in high temperature. Adha pandrom nama kadalaiya vadukra mari vadukrom. So you need coal, you need lot of heat to be produced. Adukku enna pandrona, fossil fuel use pandrom. Now what they are saying is, can we use alternative energy sources? And another uniqueness about the steel is, steel you need energy to make only once. But once you make the steel, it is perfectly recyclable. You can recycle for years and years to come. And on the model edukra process is romba adhigamana process, which even contributes to 18% of emissions. Steel industry across the world is known to contribute 18% of industrial emissions across the world. So it's a very significant contribution. So in that context, how can we make it greener? How can we make it cleaner? They are talking about green steel. So in the ideal நீங்க பாத்தீங்கன்னா this will be self explanatory புரிஞ்சிரும் உங்களுக்கு green steel பத்தி போட்டிருப்போம். So in the green steel with a focus on Pradhan Mantri Urja Ganga project is nothing but a gas pipeline, okay, to the eastern pockets of India. So in eastern pockets of India is where the steel industry is also very much concentrated. So government wanted to utilize this gas pipeline for promoting green steel in our country. Okay, so adanala Pradhan Mantri Urja Ganga project is also going to be utilized for this purpose. So adanala this scheme is also been enlisted in the list. So அப்படியே நீங்க பாத்தீங்கன்னா தெரியும் other important developments mangrove alliance for climate இது போயிட்டு இருக்கும். Okay, so it will be mostly self explanatory, not very complicated, and of course if there are any doubts you can always approach. Okay, so thank you friends, see you in the next session. Thank you.
So today's session we are going to start with the next 3 months of current affairs, most importantly from October, November and also December 2022. So the first person is with respect to Jayaprakash Narayan. We call him as JP. Jayaprakash Narayan was called JP. This Jayaprakash Narayan was so famous during the period of national emergency of 1975. But many of you don't know, or many of us don't know, his contribution was not only famous in post-independence, but also famous in pre-independence. He was initially a Gandhian. First, what you need to understand is he was initially a Gandhian. And later, he has become a socialist. And later, he was also sometimes during the time period of Quit India movement, he was acting as a revolutionary terrorist. So, இந்த மாதிரி பன்முகம் இருக்கு. பிறந்தது பீகார். Okay, but later he shifted to Uttar Pradesh. Yes, he was basically interested in. Actually, he quit his college, but he was influenced by Karl Marx. So he studied his education is with respect to Berkeley University. That is, it was in California. But later he quit his college, and he was the one who had a broad knowledge, or he was the one deeply rooted with the ideas of Karl Marx. Okay, so he was basically, though he was a Gandhian, he was a socialist Gandhian. Okay, that thing you need to understand. So this Jayaprakash Narayan, he associated with Gandhi in the year of 1929, that is in the civil disobedience movement. So during civil disobedience movement, Jawaharlal Nehru, okay, so he inspired by because we know civil disobedience movement also a subcontinent level movement. Non-cooperation movement was a subcontinent level. Likewise, civil disobedience also a subcontinent level where more social groups, especially women's active participation was there in civil disobedience. Active participation. It was a women-led movement also. Though we say it is a Gandhian movement, if you take the history of civil disobedience, women's participation was high. So it was during this time period, JP, he entered into this political scene, and he inspired by the speeches of, if you look into the Indian National Congress, you need to understand something. Congress is like a banyan tree. It has so much of branches. Okay, every branch don't look alike. In the name of Congress, some socialist people will be there. In the name of the Congress, some communist ideology peoples will be there. But they won't go outside Congress. Within the Congress, they will enjoy it actually. Or within the Congress, they will try to spread their ideology. Likewise, Jayaprakash Narayan, he was initially a Gandhian. He He was inspired by the ideas of Karl Marx, but in the year of 1933, what happened? This civil disobedience movement was withdrawn or terminated. Why terminated? Because சௌரி சோராவா அப்படியே பெண் வச்சு கண்ணில் குத்திடுவேன். ஓகே, 1922ல எங்கயா சௌரி சோரா, சாரி 1933ல சௌரி சோராலாம் கிடையாது, 1922ல தான் சௌரி சோரா. In the year of 1933, after this communal award, after this, okay, Gandhi, that is Ambedkar Pact, that is Pune Pact, Gandhi felt, he released from jail. He was in jail after returning from second round table conference. Gandhi was in jail. Okay, he was 15 months of jail. He was in 15 months of jail. He was imprisoned at Pune, Erravada. There only he went for fast unto death because of this communal award. So when he released, he felt that the so-called active participation for the civil disobedience movement was not there actually. So he collapsed. Morally, he collapsed because people's support was not there. So he terminated the civil disobedience movement. Because this is this time, why this particular year is important is, this is the year, okay, Subhash Chandra Bose openly said, Gandhi as a political leader, you are failed. So என்னையா நீ எல்லாம் வந்து ஒரு தலைவன் அப்படின்ற மாதிரி கேட்டார். Because we believed you in the year of 1922, you withdrawn the non-cooperation. We believed you in the year of 1933, you terminated the civil disobedience. So what is the base of supporting you? So Gandhi as a political leader, you are failed. This is a statement of Subhash, and in this agony, he went to Europe. He went to European tour. Okay, there only he got inspired by the ideas of, okay, ideas of Nazism, fascism, and he felt this during this time period from 1933 to 39. Subhash felt Gandhian way of Satyagraha, it will never fetch any result. It is outdated, obsolete. So this is the scene happening there. But JP, if you take it, he also felt despair. But he didn't go outside the Congress. What he did, you know, within the Congress, he tried to mobilize the socialist idealist groups. Within the Congress, he didn't went out actually. Within the Congress, he tried to mobilize the socialist ideological groups. And in the year of 1934, he founded a party called Congress Socialist Party. This is a previous year question. Got it? Now tell me whether this Congress Socialist Party, the name is socialism. This fellow is having a deep link with Karl Marx. Tell me whether this Congress Socialist Party, whether he is full-fledgedly he is supporting for, okay, Indian National Congress or Communist International. கேக்குறது புரியுதா? இவரு socialist, ardent follower of Karl Marx. He started a party called Indian, Socialist Congress or Congress Socialist Party. Tell me whether he was openly supporting for communism or Communist International, or he was having allegiance with INC. Yeah, very good. It was INC. This is a question asked. Though he was the follower of Karl Marx, though he supports for socialism, he was having his allegiance towards Indian National Congress. So this Congress Socialist Party only in the post-independence, how it has made. Okay, so Hind Mazdoor Sabha, Praja Socialist Party, and this JP in the year of 1973, he found that Indira Gandhi government was not like before. Indira Gandhi government, right from 1973-74 onwards, India was facing a lot of issues due to Arab crisis. Due to this Gulf crisis, Arab nationalism, inflation rise, railway strike, all these things, okay, seriously, it invited so much of youths into the nationalistic scene. So this youths now started to provoke another sleeping giant, Jayaprakash Narayan, 1945, this fellow was not in active politics. After independence, he was not in active politics. But in 1973, 74, Jayaprakash Narayan came to the picture, and he was the one who raised the first words called, total revolution or Sampurna Kranti. What is Sampurna Kranti? Total revolution. He was the one who has the army and the the army and also the air force or navy. He was asking the Indian army to take the control of the parliament. So for that revolutionary ideas, JP is famous. Okay, for Quit India movement, Jayaprakash Narayan only started. He escaped from, there is a jail called torture jail during British time period. Some 2 to 3 jails in India were called torture jails actually. One is at Andaman, Cellular, and another one is Hazaribagh jail. He escaped from the torture jail. He know many martial arts. Though he was a Gandhian, பார்க்கிறதுக்கு சாம்பார் மாதிரிலாம் இருக்க மாட்டார் இவர். He was a marshal. He was a valor, remembered for his martial arts. And this JP was the one when he asked for the total revolution. Okay, Indira Gandhi seriously felt the issue is going to be tough, and because of that only the proclamation of emergency was made in 1975. சொல்லப்போனா அவர் தான் அடுத்த பிரைம் மினிஸ்டர் ஆயிருக்கணும். 1977 he is about, he will be the next prime minister, but unfortunately he lost his life. So Morarji Desai has become the prime minister in 1977. So JP was one of the most important fellow in Indian national scene. So we are going to celebrate his Jayanti in the month of October. So however, after independence took out of Congress and formed the Socialist Party, which was merged with Jayaprakash. Very good. This is also a previous year question. JP is nothing but Kripalani. So this JP Kripalani's Kisan. This JP Kripalani was the president of Indian National Congress during independence. It is a previous year question. Who was the president of Indian National Congress during independence? It was Acharya, J. Kripalani, JP Kripalani. So these are all the areas. ஒரு இடத்துல பிடிச்சா அப்படியே அந்த நூலை பிடிச்சிட்டு அப்படியே போய்கிட்டே இருக்கும் நமக்கு. Okay, you see the previous year question. You see the question. Who among the following were the founders of the Hind Mazdoor Sabha? The question here is Hind Mazdoor Sabha. Don't confuse with the Congress Socialist Party. Congress Socialist Party formed in 1935 by Jayaprakash Narayan, Acharya Narendra Dev. That you know. Okay, தெரியலனாலும் தெரிஞ்சுக்கோங்க. But here the question, after independence, year of 1948, this Hind Mazdoor Sabha was founded. Who? The same Jayaprakash Narayan is coming. Here comes our Deen Dayal Upadhyaya and Yaman Roy. This is a previous year question. They try to confuse. The same Congress Hind Mazdoor Sabha, that is the same Congress Socialist Party has got EMS Namboodiripad. Do you know who was this fellow? யாருன்னு தெரியல சார்ன்றீங்களா? He was the first Chief Minister of Kerala. EMS Namboodiripad, the pioneer of communist ideology. Yaman Roy, the pioneer of communist ideology. So they were all the one responsible for forming the Socialist Party, Hind Mazdoor Sabha. So this was the previous year question. Okay. Enappa? Iduva? No, it is not communist. It is socialist. Same socialist state. Okay, fine. So the next question is, the same story. You see, the Congress Socialist Party's founder members were Dr. Sampur Anand. This type of names you need to memorize. ஏதோ காங்கிரஸ்னா காந்தி சுபாஷ் நேருன்னு மட்டும் வச்சிடக்கூடாது. ஸோ இவங்க பேர்லாம் தெரியணும். ஓகே, ஸோ திஸ் லீடர்ஸ், அதனால தான் சொல்லுவேன் நான், ஹிஸ்டரி ஹேஸ் டு பி ரீடிஸ்கவர்ட். ஓகே, don't memorize you have to memorize the known facts, but at the same time you have to memorize the unknown facts which others don't know. That is the art of rediscovering facts in history. So Congress Socialist Party, they will ask you who are all the founding members. Many know it was Jayaprakash Narayan and Narendra Dev. In addition to that, Meenu Masani, Dr. Sampur Anand, Acharya Narendra Dev, Meenu Masani. Joint secretaries were Meenu Masani, that is Mohanlal Gautam, ML Gautam, and NG Goy. NG Gore அப்படின்னு கொடுத்திருப்பாங்க. And EMS Namboodiripad நான் சொன்னேன்ல. When you study like this, you can categorize who is the leaders of Hind Mazdoor Sabha and who are all the leaders or the founding members of Congress Socialist Party. Okay, fine. So why? Now here I have mentioned what is the working program of Congress Socialist Party. They want to liberate India. Very good. Point number one. From external as well as internal enemies. External enemies is British. Internal enemies is the caste, the Varna system, or the social evils that are present in India. It declared that it would act under the aegis of, that is what I said, what the Congress Socialist Party said, it will work under the Congress, Indian National Congress. Its primary objective was to outroot British imperialism and the empowerment of the laborers, farmers, and also vulnerable class. Whenever you see, what is socialist pattern? The socialist pattern will support for the downtrodden. They will support for the common people. Capitalist will support for the what is the link with the capitalist with the laborers or farmers? Okay, socialism and communism, their policy itself will support for laborers and farmers. Okay, so it has a defined work program. Party members focused on the objective like abolition of capitalism. So they will ask you whether the Congress Socialist Party, supported for abolition of capitalism. Okay, they will give you among who are all the leaders supported for abolition of capitalism. In that leaders list, they will give you Rajagopalachari. What will you do? Meenu Masani. What will you do? Elimination, you have to go. Rajaji didn't support for this socialism and all. He supported for capitalism. So you should know who are all the leaders supported for socialism, who are all the leaders supported for capitalism within the Congress. Because Rajaji was the ardent supporter of capitalism. He said Rajaji, he was having a difference of opinion with respect to Jawaharlal Nehru in post-independence. Because when Nehru always tried himself to show like he was a pro-socialist, pro-secular. But Rajaji was not having that mindset. He said, okay, mixed economy and all not needed. We will go for the style of British. We'll go for US. We will inculcate the capitalist style of economy. But Nehru rejected it and he went for the USSR style. That is what we call it as the fire plants. So these are all the area you need to where UPSC focus, because ideology is the base. We grow, we born, we die. Ideology won't. So UPSC always will fix that ideology. Which ideology followed by whom? So that ideology is important. Okay. Next. So Congress Socialist Party had a specific vision for its working program to achieve their socialist goals. Abolition of class division in the society, that is Varna system, and they wanted to have an egalitarian society. Transfer of all powers to the masses, development of economy to be planned and controlled by the states. Okay, so this is what we call it as governmentless government, which means what is governmentless government abdina, where the power is with respect to the masses. In Switzerland, this is the kind of the style itself like this. The power, because population, a small population country, we can go for this without government itself, we can run the government. But that style won't suit for India. The government okay, so socialization of key industries such as railway, steel, cotton, jute, state monopoly of foreign trade, organization of cooperative societies for the production, distribution, and financing the unorganized sector. These are all the one demanded by the Congress Socialist Party in 1934 itself. And of course, after independence, the Nehru's government, they took some areas actually. So abolition of titles with compensation for the princes, landlords, and all other exploiters, redistribution of land among the peasants. These are all the one which we call it as the post-independence land reforms and the post-independence reforms, which was taken care by the Nehruvian government. So that is the reason we say we are not completely socialist, we are not completely capitalist, we follow the mixed economy. Okay, so this is the question, and this is a new term, Mangar massacre. This Mangar massacre, the word itself says Mangar. It was a place in Rajasthan. Okay, Mangar was the place in Rajasthan. There also, like Jallianwala Bagh, there was a tribal massacre happened in the year of 1930. Which tribal group? Bills. This is an important question. You need to understand about Bills. The Bills are the largest tribal section which presents in the Rajasthan and also in Madhya Pradesh region. The word bill come from the Tamil word will. They were all basically Dravidian tribal group. We call it as villain. No, it is not an English word actually. Villain. Villain means archer. In Tamil, villain means archer. Concept purida. Mallan means wrestler. That is the reason Ma Mallan. Likewise, this bill is the word originated from the word called will. Okay, so this word later, and they were all not Aryan tribes. They were all pre-Aryan tribes. Okay, so the Bills are the largest tribal community of Central and West India. Got it? So, fine. What happened? The Bills, a tribal community, faced great trouble at the hands of rulers of the princely states and the British. By the end of the 20th century, the Bills living in the Rajasthan and Gujarat become bonded labor. Bonded labor means indentured laborers. They will recruit you, telling a fact that we will be giving you employment. But later, employment will be given, but salary won't be given because you will be taken as an indentured laborer, which means open the tolalargal. After bond also, you will work. You will not be paid. You will be given food, but the food is also not a palatable food. சாப்பாடு கூட என்ன பண்ண மாட்டாங்க, தட்டுல எல்லாம் கொடுக்க மாட்டாங்க, தரையில தான் போடுவாங்க. So the tribals would have watched the movie called Pardeshi. This is exactly what it was happened actually. So this particular tribal groups, there was a fellow called Guru Govind Giri. He is also called as Govind Guru. This particular person, he mobilized the Bills. He mobilized the Bills tribal group and he engaged a armed struggle with the British. Okay, they were all demanding for what initially they were all, their struggle is not armed struggle. They were all demanding for revenue reforms. That is what I have mentioned. Okay, so primarily relating to the forced labor, high tax imposed on Bills, and harassment of the Guru's followers by the British and the rulers of the princely states. The Bills rejected the British attempt to placate them and refused to leave Mangar Hills because the styles of, this is the way, or this is the style how the British react when they felt that any area is a problematic area. When they felt, because already so much of tribal groups the British have faced actually, Santals rebellion, Indigo rebellion, okay, Munda rebellion. So likewise, the British, they don't want to have another tribal revolt, so they are asking them to leave that place. But this Mangar Hill was the place of, or the livelihood of Bills Association. They were not ready to move. So the British in the year of 1913, okay, what they did, okay, in the November 15, 1913, okay, or the 17th November 1913, the British Indian Army fired indiscriminately on the Bill protesters, and it is said over 1,500 people, including the women and children, died at that tragedy. Okay, but our NCERT books failed to cover this. That is the reason, again, I am saying rediscover history, study new facts. The tragedy, the killing, the massacre of 1,500 peoples, unnoticed. We know about Jallianwala Bagh. That is the problem. We study about mainstream history. Main branch we focus, but sub branches we don't focus. But you need to know sub branches also hold civilization. Sub branches also holds records. Okay, so always rediscover special facts. So this is what we call it as the Mangar massacre. So the Bill tribes, there are according to the 2011 census, okay, the Bills are the India's largest tribal group. Largest tribal groups is Bills. But in Northeast, many tribal groups were all present. As a single most tribal groups, the Bills are the largest tribal groups according to the 2011 census. Remember, tribal questions and also important, because 1 year they have asked openly who are all the primitive tribes, how many primitive tribes were all there, and how many, okay, PVGT tribes கேள்விப்பட்டிருப்பீங்க actually, particularly vulnerable tribal groups. So tribal areas அப்படின்னு வந்தாலே பார்த்துக்கோங்க. So central or pure Bills or eastern or Rajput Bills. The central Bills can be found in the mountain regions of Madhya Pradesh, Maharashtra, Gujarat, okay, and they also found in the Tripura's northwestern region. They were all considered as a scheduled tribes in Andhra Pradesh, Chhattisgarh, Gujarat, Karnataka, Madhya Pradesh, Maharashtra, and Rajasthan, Tripura. That is what I said. Bills are pre-Aryan race. The term Bill is derived from the word Villu or Billu. Villu is a Tamil word, a Dravidian, okay, which is known as bow in the Dravidian language. The name Bill is also mentioned in the ancient epics of Ramayana and also Mahabharata. So these bills are mentioned as the archer tribal groups. Archer tribal groups. Okay, their mentioning was there in Ramayana and also Mahabharata. And yeah, there was another interesting area of INC, because INC was formed in the year of 1885. Okay, December 28th, 1885 at Bombay, the Indian National Congress was found. So that is what maybe this year they will, every year actually in the Indian national movement, some questions will come from Congress. Okay, either extremist or revolutionary terrorism, or their ideology or their groups, which means their literature, contribution, poems, like that. So Congress, it was India's first all India political party. Congress was the nation's first all India political party. It was a pan-Indian political party. We can say like this, pan-India. Because before Congress, many organizations were all founded. Those organizations are regional organizations that spoke only regional issues. But Congress was a national organization. It spoke about the national issues. Okay. So that is the point. So Congress gave the identity of one national, which means identity of nationalism. Okay, Congress came. It was a gradual regeneration. Okay, konchama da vanduchu. Safety valve theory was put by Lala Lajpat Rai. What Lala Lajpat Rai said? What is safety valve theory? Could anyone tell me? Safety valve theory says, sir, 1857 a revolt was taken place. That revolt was feudal in nature. The revolt was not intellectual backup, it was a emotional backup. We can say like this, it was not an intellectual setup, it's a emotional outburst. But that revolt itself, one of the shaking point for the British history in India. So the British after 1857 felt that such kind of revolt should not taken place. So they thought that some unity among Hindus and Muslims is responsible for some of the success, some of the initial day success of the revolt. Because in the 1857 revolt, we know Hindu-Muslim unity was there. So British thought the unification factor or nationalistic factor should not happen in India at any cost. That is the reason they will go for divide and rule policy. But we know from 1870s to 1885, many unwanted events happened, especially during the period of Lord Lytton. Lord Lytton, okay, he started the Delhi Darbar. He didn't address the famine issues with respect to Bengal. He engaged with the second Anglo-Afghan war. Peoples were dying, but he engaged in war. Peoples are dying. He asked the princely state rulers to come to Delhi, and he asked, okay, and he said, hereafter the Empress of the England is the Empress of India. Our princely state rulers also accepted it. Vernacular Press Act, Arms Act, all the atrocious things done by Lord Lytton. That is the reason we call him as the most defamed Governor General or Viceroy. But after him, the Lord Ripon came. He was a benevolent Governor General. But the problem with the Ilbert Bill, it openly said what is the attitude of British with respect to Indian state. What is Ilbert Bill controversy? Yeah, so Justice Ilbert said even the Indian judges, they can have the power to trial European officers if they were all culprits. But the Europeans in India, it is not an act. This is the Ilbert Bill. It is Masoda. It is not a Sattam. The Ilbert Bill says even the Indian judges, they can trial European officers. But the whites who present in India and with the support of the British Parliament, okay, here the Lord Ripon, who is about to sign the Ilbert Bill, got transferred, and the Ilbert Bill remained as a bill. It was not passed as an act. It was lapsed. So this openly showed the racial attitude of British towards Indian state. Okay, so this activities and all, okay, culminated the people felt despair and they were about to, okay, outburst. So British thought, so what Lala Lajpat Rai says, a revolt is about to come. But what happened? Okay, it is the British. Congress is nothing but in the year of 1885, the Congress that was formed. The leadership of the Congress, the one who founded the Congress was not an Indian. He was a British. Who founded Congress? A.O. Hume. He was a British wala. Okay, so this Congress, the early leaders of the Congress or moderates, they were not showing their deep respect for their country. They were all showing affinity towards the British crown. Okay, so Congress British உடைய B team அப்படின்னு சொன்னார் அவர். A revolt is about to take place. When compared to 1857 revolt, this revolt was intellectual backup. A revolt is about to take place, but in the name of Congress, the British, they pacified the Indian masses. So Congress was acting as a safety valve. The Congress wallahs are acting like a safety valve. They were all acting like a lightning arresters. So this particular theory was propounded by Lala Lajpat Rai, and he says this is how the Congress works, because the early Congress followed triple P. What are all they? Prayers, petitions, and also protest. எதையுமே வந்து ரொம்ப தீவிரமா பண்ண மாட்டாங்க. நீ எங்கே போனாலும் நான் ப்ரே பண்ணுவேன்ற மாதிரி. பிரேயர்ஸ் மீன்ஸ், அதனாலதான் காங்கிரஸ் கட்சியை பீப்புள் வில் மாக். உங்களுக்குலாம் ஒரு பஜனை கோஷ்டி அப்படின்வாங்க. என்னையா நீங்கெல்லாம் பண்ணி வச்சிருக்கீங்க அப்படின்ற மாதிரி. So the early Congress moderate leadership was not accepted. It was not okay up to the level actually. So but Congress have a diverse participation. All the section Congress நாலே கோஷ்டி பூஷல் இருக்கும். ஏன்னா காங்கிரஸ்ல every section of the people will be there actually. Okay, and pan-Indian organization, but its early time period was not effective, and many said this Congress leaders working only 3 days in a year. எப்போ காங்கிரஸ் செஷன் அப்ப மட்டும்தான் வாயு தாண்டா வேலை செய்யுதுன்ற மாதிரி. Only at the Congress sessions the Congress leaders worked. This was a statement said by Aravind Ghosh. Like how the frog croaks in the rainy season. You people, you Congress moderate leaders, you are just croaks only annually the 3 days. The 3 days is nothing but Congress sessions. Every year, 3 days Congress session will take place. Aravind Ghosh said, you people just openly supporting for British crown. You were all inspired by Western ideology, Western political thought. You didn't speak about mass movement. உங்க வாயில இருந்து மாஸ்னே வர மாட்டேங்குது. Okay, but how the questions? The questions is with respect to sessions. Every session, Congress nale sila session famous. There is a basic facts you need to understand. Take a note. For my question, you just write an answer. Who was the founder of Congress? Write the answer. First question is founder. Who was the founder of Indian National Congress? What the answer? A.O. Hume. Tell me whether he was a British or Irish or Russian. British. Very good. Don't confuse with Irish. Irish means you have to remember anniversary. Okay, fine. Tell me. Another question is, who was the first president of Indian National Congress? W.C. Banerjee. First president. These are all the president list. The founder is A.O. Hume. The founder is a foreigner. That may be the curse for Congress. Even today also, Congress leaders were all, many of them were foreigners. Okay, understood. Very good. Okay, Umesh Chandra Banerjee or Banerjee. He was the first president. Okay, in this first president, in this first session, understand my dears, the first Congress session was about to take place at Pune. But unfortunately, due to plague or cholera or whatever may be the epidemic. It was later fixed to Bombay. 72 delegates all over the India, 30 plus delegates only from South India. But in this, you can see this particular facts in any of the North Indian authors. 72, among the 72 delegates, 35 plus delegates from South Madras Presidency. Because the Congress was a nationalist organization, it was the jointly formed with many of the regional organizations. Mukkiyama Pathina, Madras Mahajan Sabha. Okay, fine. The second, next question. Who was the oldest president of INC? Yeah, you see, the second session held at Calcutta. Okay, Dadabhai Nauroji, the grand old man of India, the Parsi leader. Okay, so he was the president. You see, 72 delegates. Okay, that is the reason when Congress was formed, in a press meet, the then Viceroy, Lord Dufferin, says, the Congress represents microscopic minority of the people. 72 பேர்லாம் வச்சு ஒரு கட்சி நடத்துறீங்க, உங்களுதான் ஒரு கட்சியாடா அப்படின்னு கேட்டாங்க. But the next year, 434. The next year, 800 plus. In 1889, almost 2,000 people were all there in Congress. Then only realizing the alarming situation, the same Viceroy says, Congress consists of seditious Brahmins. Congress is the factory of sedition. Because many Brahmins, why Brahmins, he said, means those time Brahmins were the one who had education. They were all the advocates, they were working in the government. So they shifted to Congress. Okay, the Congress, that is the reason he say the Congress consists of violent villains, disloyal babus. Okay, you need to understand. But along with Lord Dufferin, two other leaders or two other important personalities opposed to Congress. Number one is Syed Ahmad Khan. He started Patriotic Association of India. So Syed Ahmad Khan, and another one is Raja of Patiala. They were all, they didn't support for Congress. Okay. So next question, tell me, who was the first Muslim president of Indian National Congress? Enapa? Badruddin Tayabji. He was from Bombay. First session held at Bombay, second session held at Calcutta, third session at Madras. In the Madras session only Badruddin Tayabji was the president, but he was basically from Bombay, Maharashtra. He was responsible for the founding organization, Bombay Native Association. Okay, an appeal made to the Muslims to join hands with other national leaders. Okay, because by this time period and all, Syed Ahmad Khan was so popular. So he was asking, Badruddin Tayabji was asking Syed Ahmad Khan and other leaders to join with Indian National Congress. Next, this session is so important. 1896, like this only last year a question was asked with respect to Rabindranath Tagore. In the session 1896 only, under the leadership of Rahmatullah Sayani or M. Sayani, first time national song Vande Mataram. You need to understand what is national song and national anthem. Don't confuse with Vande Janagana Mana. So the national song of India, Vande Mataram, was sung for the first time. Also, the economic drain theory got a stamp of approval, and the Britain were held responsible for the drain of wealth from India, which led to the frequent famines and growing poverty in India. Two important things were all discussed. Economic drain theory. Okay, they have approved. Amma, nadakkudu, tappu. And next one is Vande Mataram song was sung. Further, the Congress passed a resolution blaming the British for the famine that was devastated many parts of India, and they condemned the provisions of the existing famine code as being inadequate. Okay, so this session 1896 is famous. Okay, this is the session remembered. Why the session was remembered, you know? This is the rise of revolutionary terrorism in Maharashtra, because only from 1896-97 and all in Maharashtra, okay, there was a plague occurred, but the British officers, they didn't taken care of the plague related activities. They ignored from the situation. There was no medicos was sent. So it is during this time period, okay, Nathu brothers, Chepekar brothers கேள்விப்பட்டிருக்கீங்களா? அவங்க தான். Okay, Chepekar. The Chepekar brothers, they were all the disciples of Balagangadhar Tilak. Number one is Damodar, and another fellow was Balakrishna. This both Damodar and Balakrishna, the devotees, that is the disciples of Bichi Tilak, they killed the unpopular British officials. And this is how the revolutionary terrorism was starting in Maharashtra. The British arrested them. Balagangadhar Tilak, he wrote an article, okay, justifying the fact that the killing of these two fellows has killed. These two fellows, they killed Rand and IAS. யோ இவங்களை கொன்னது கரெக்ட் தான்ப்பா அப்படின்னு சொல்லிட்டு அவர் எழுதினார். யாரு? Balagangadhar Tilak. He wrote justifying the fact that the killing of Rand and IAS is correct, and he compared Damodar and Balakrishna with Arjuna and also Krishna in Mahabharata, and Rand and IAS like Duryodhana and Duchadana. British what they did, உனக்கு அவ்வளவு தைரியம் வந்துச்சா அப்படின்னு சொல்லிட்டு என்ன பண்ணிட்டாங்க, செக்ஷன் 124A IPC. அதுக்கு முன்னாடி வரைக்கும் பாலகங்காதர் திலக்னா எவனுக்கும் தெரியாது. After arrest, 6 years of rigorous imprisonment, after coming from the jail, he has become, okay, like KGF Yash, he has become a pan-Indian hero. This is how the militant nationalism entered into the Indian scene. Okay, so this particular year is important. That is one Janahanamana, and that is one is called Amarsona Bangla. In 1906, it was called Amarsona Bangla. Amarsona Bangla was the national song of today's Bangladesh. Amarsona Bangla. That was wrote by Rabindranath Tagore. Got it? That was Amarsona Bangla. Okay, fine. 17th session, Calcutta session. Okay, we call him as Dinsha Vacha. In this Calcutta session only, you see, many people think that Gandhi entered India in 1915. Before that, he didn't enter into Congress. Wrong. In 1901, Calcutta session was the first time Mahatma Gandhi appeared on the Congress platform. Gandhiji urged the Congress to support the struggle against the racial discrimination and exploitation in this country. Okay, so it was in the 1901, which session? Calcutta session, Gandhiji has participated. You need to understand that fact. Gandhiji from 1893 to 1915, 2 or 3 times he arrived in India. One time to pick up his family, second time for mobilization of funds for his political party. Okay, maybe that time he would have come. So 21st session, Banaras, yeah, you see Banaras. Okay, Gopala Krishna Gokhale, the Servants of India Society founder. It's the first secular organization that supported for all the sections of the people. Okay, so resentment was shown against the partition of Bengal, because partition of Bengal happened October 16, 1905. Partition of Bengal officially came into effect. Before itself, the British has declared, but officially came into effect. So when the Congress first openly criticized means in 1905 session, what session it was? Banaras session. Okay, so link with Banaras, Uttar Pradesh, with a moderate leader, Gopala Krishna Gokhale. He has founded an organization called Servants of India Society. Who founded the Servants of People Society? Servants of People Society was founded by Lala Lajpat Rai. There is a small difference. Fine. So next session, the year 1906, Calcutta session. Okay, now itself the problem started, because resentment, criticism, the Indian National Congress, they showed a resentment. They didn't like this partition. That is true, but who has to be the next president? How we are going to handle with this issue? The problem starts from 1906 onwards, because by this time the militant nationalism was in force, extremism was in force. But in order to break the divide, they were asking Dadabhai Naoroji once again to come and to take up the leadership, because ஒரு பெரியவர் சொன்னா கேட்பாங்கன்றதுக்காக அவரை கூப்பிடுறாங்க. In the year of 1906, Dadabhai Naoroji, to counter the increasing influence of the extremists, the moderates invited Dadabhai Naoroji. What is the time now? 3:50 ஆயிடுச்சா? ஐயோ, சரி, ஓகே, பரவாயில்ல. So the moderates invited Dadabhai Naoroji to come from England to preside over the session. However, the vocabulary of the extremists trumped in a way, as Naoroji declared, Swaraj as one and chief remedy for the self-government. What is it? Swaraj. Do you know another fact? Who coined the term Swaraj? The word Swaraj was coined by அதெல்லாம் எனக்கு தெரியாது. Who coined the term Swaraj politically in the Indian national movement? The word Swaraj was first propounded by Chhatrapati Shivaji. Hindu Swaraj. Swaraj means nationalism, that is self-rule. The word Swa in Sanskrit means self, soul. That is the reason Satyagraha, that is Swaraj. This Swaraj politically, this word Swaraj politically coined by Dadabhai Naoroji only. Politically first coined by Dadabhai Naoroji. Swaraj politically first coined by Dadabhai Naoroji. But the Swaraj was later spoke by in a very great speech. Swaraj is my birthright, I shall have it. அப்படி சொன்னது பிஜி திலக். பட் அப்படி சொன்னதாலே அவர் தான் முதல்ல அந்த வார்த்தை யூஸ் பண்ணாருன்னு அர்த்தம் கிடையாது. And why you said Dayananda Saraswati? No, Dayananda Saraswati was basically a nationalist. He said India for Indians. So the later historians who wrote about Dayananda Saraswati, they say he was the one who loved Swaraj. Concept புரியுதா? ஸ்வராஜ்ன்ற வார்த்தையை அவர் சொல்லல, இந்தியா ஃபார் இந்தியன்ஸ் சொன்னாரு. கான்செப்ட் புரியுதா? அழகா இருக்கும் இதெல்லாம் படிக்கும்போது. ஆனா எக்ஸாம் ஹால்ல போய் உக்காந்தீங்கன்னா உங்களையே நீங்க அடிச்சுப்பீங்க. ஏன் இந்த ஃபீல்டுக்கு வந்த, இதெல்லாம் உனக்கு தேவையா, வேணுமா உனக்கு அப்படின்லாம் இருக்கும். பட் நீங்க ரிவிஷன் பண்ணிட்டே அதெல்லாம் ஒரு ப்ராப்ளம் கிடையாது. ஸோ 1906 லைக் திஸ். அண்ட் நெக்ஸ்ட் ஒன் இஸ், இதெல்லாம் உங்களுக்கு தெரியும். Many people think that 1907 was Surat split. Yes. 1916 Lucknow reunion. Yes. But many people think in the session of 1916, Annie Besant was the president. No. Ambika Charan Majumdar was the president. Annie Besant responsible for uniting moderates and extremists. But she was not the president of Congress in 1916, but she was the president of the Congress in 1917. மாட்டிருப்பீங்கல்ல? ஆமா. Okay, so அதனாலதான் these are all the simple facts, but people won't revise. கேட்டா UPSC is giving tough questions னுவாங்க. டோய், நீங்க முதல்ல படிக்கணும், இப்படிதான் படிக்கணும். ஒரு செஷன்ல என்னென்னலாம் ஸ்பெஷல் கம்பேர் பண்ணுங்க, பாருங்க. Unification of moderates and extremists, and this 1916 Lucknow session remembered for Congress League Pact. The Congress and Muslim League, they forgot their old difference and they now said, we will, based on the ideology, we will sit aside. We will join together and we will fight against the British. It is not Congress and Muslim League joined. It is not political merging. Ideology wise, they had difference. They set aside, and now their new ideology was to kick British out of the political scene. Got it? Next is Annie Besant, the first women president of Indian National Congress. The second women president of Indian National Congress is Sarojini Naidu. Okay, she was a Irish lady. Okay, the Congress got its first women president, Annie Besant. And in this session only, remember, Annie Besant was the first president in the Congress genealogy. She was the first who loved to talk about the linguistic basis of Congress. மொழிவாரியா மாநிலங்களை பிரிக்கணும்னு முதல்ல சொன்னாங்க இவங்க தான். காங்கிரஸ் கட்சியை லிங்குவிஸ்டிக் பேசிஸ்ல இருக்கணும்ன்றாங்க. காங்கிரஸ் ஆன் லிங்குவிஸ்டிக் பேசிஸ். Later only Gandhiji adopted this idea. Annie Besant itself, she was the one had the ideology of linguistic basis of Congress. And next one is 1918. You see, R.C. Dutt. He was a moderate leader, and also he was also remembered for, like Dadabhai Naoroji. His famous work was Economic History of India. Economic History, R.C. Dutt. His full name is Ramesh Chandra Chat. So, Economic History of India. The Economic History of India speaks about how the British manufacturers intentionally devastated Indian manufacturers. How the British policy of cotton intentionally devastated the Indian policy of cotton. Okay, so அதை பத்திலாம் பேசியிருப்பாரு. So Montagu Chelmsford reforms. The Congress at the special session in Bombay termed the Montagu Chelmsford reforms as disappointing. It demanded a declaration of rights of the people of India and asserted that the Indian legislature should have a same measure of the fiscal autonomy of the self-governing dominions of the empire. So they speaks about the fiscal autonomy. And next one is the another special session is 1919. Motilal Nehru. Motilal Nehru was the first time he was the president here. Okay. Second time in the year of 1928 also he was the president. But first time in 1919, Amritsar session. Okay, the Congress expressed their deep solidarity with the people killed in Jallianwala Bagh. Under the presidentship of Motilal Nehru, the Congress condemned the massacre in the strongest of the terms. So 1919 itself, Motilal Nehru was the president at Amritsar. No, Gandhi already entered politics actually. Actually, after Jallianwala Bagh, Gandhi, he started non-cooperation movement. I don't know exactly which session he declared, because I said no, 1901 Gandhi participated in Congress. 1916 Gandhi participated in Indian National Congress session. But this time and all, Gandhi was not a popular leader in India. 1917, 1918, after Champaran, Kedah, Ahmedabad mill strike, Gandhi now he is becoming a popular leader in India. In the year of 1920, after the death of Balagangadhar Tilak only, the Congress leaders they asked Gandhi to took up the leadership. It was in 1920 when he took up the session, when he took up the when he took up the control of Congress. 1920 only Gandhi took the control of Congress, which means he was not the president, but he took the control of Congress. He revamped Congress. I said, right, in many of the classes, I said Congress, when compared to the president, the working committees are also popular. Gandhi was the one who started the formation of Congress working committee. We call it as Congress Karya Committee. The working committee Congress is so powerful than the Congress presidentship. Gandhi, he was the one who controlled it. Why I'm saying here is Jallianwala Bagh happened in the year of April, right? April 13th, 16 now. April 13th, remember, April 13, 1919. May month, our beloved Rabindranath Tagore, he has renounced his knighthood. But Gandhi, in the year of 1920, February, is going to Punjab. First time in his life, he is going to Punjab, Amritsar. There, he said, I am renouncing my knighthood. In the year of Gandhi was given, I am renouncing my Kaiser. Gandhi was given a title called Kaiser Hind. Okay, why you are renouncing, sir? For the act of Jallianwala Bagh, British act of Jallianwala Bagh. But Gandhi, he renounced the knighthood, he renounced this Kaiser Hind not immediately after Jallianwala Bagh. There was a program in non-cooperation movement called giving up the titles. Based on that concept, Gandhi renounced his Kaiser Hind. Concept purida ungalku. So this is how it goes actually. Okay, but not immediately. Immediately, the one who renounced the title is his beloved Rabindranath Tagore. Okay, got it. So this is how the Congress sessions will go. In which year Gandhi was the president? 1924 Belcom session. You write it. 1924 Belcom session. Gandhi was the first time he was the president of Indian National Congress. 1929 Lahore session. remembered for Purna Swaraj resolution, Jawaharlal Nehru. In 1938, Subhash was the first time president. Haripura. 1938, Haripura. In the next year also, he also president. Tripuri. Haripura and Tripuri are the two important years. Haripura and Tripuri, Subhash. And the very only one session that the year of 1936, Faizpur session, the was first and the last session that held at village. Congress session that held at village. Faizpur. 1936. Faizpur, Maharashtra. Okay. So like this, the things will go on. Okay. So this particular Chhatrapati Shivaji was in news because he escaped from Agra during the time period of Aurangzeb. People will ask you what is so special about Shivaji. Shivaji was born at Pune. Okay, exactly. Which hill? Shivaner. He was born at Pune. Shivaner. Okay, his mother name was Jijabai. Father's name. அவங்க பர்சனல்லாம் நாங்க கேட்கறது இல்லைங்க சார். ஃபாதர்ஸ் நேம் என்ன? Shaji Bhonsle. Bhonsle was a Marathi group. There are 5 important Maratha system itself. A list of 5 confederacy. First one is, okay, 1, 2, 3, 4, 5. First one is Bhonsle, Scindia, Peshwa, Gaikwad, Holkars. The Holkars of Indur, Gaikwad of Baroda, Peshwa of Pune, Scindia of Gwalior, Bhonsle of Nagpur. Bhonsle, Shaji Bhonsle. Marathas are the 5 confederacy clan, 5 family group. Ivaruடைய குரு யாரு? Who was the guru? Guru is Dadaji Kondadev. He was the political guru, and the Guru Ramdas. Spiritual guru name was Guru Ramdas. Why Shivaji is famous, sir? Because of the ideology. His mother and his guru nurtured him right from childhood. They said India is a land belonged to Hindus, but this land was later captured by many foreigners. Okay, Muslims are not indigenous. They were all from foreigners, but today's Hindustan was under the control of Muslims. Muslims are Muslims. அப்போ அவுரங்கசீப் இருக்கார். Deccan region எல்லாம் Muslim kingdom தான். அப்போ சொல்றாங்க, his mother nurtured him and asking to create a Hind Swaraj. What's the word? This Hind Swaraj, in today's political term, it is called Hindutva. Hind Swaraj, then Hindutva marriage. Okay. So Shivaji was later, he is starting like a folk hero. He was starting his life, and he is becoming a pan-Indian hero. Folk to pan-Indian, because he was a great valor. He was remembered for his guerrilla techniques, especially after killing of 2 important various generals. He first killed Afzal Khan. He was the general of Bijaypur Sultan, Afzal Khan. And after he killed Shaista Khan, he was the general of Mughals. After defeating and killing these 2 generals, he has become an all-India figure. So this Aurangzeb, he want to crush Shivaji, so he has sent 1 lakh soldiers under the leadership of another Hindu Rajput called Raja Jai Singh. Raja Savai Jai Singh oda thalamaiyila Aurangzeb has sent 1 lakh soldiers, foot soldiers, 1 lakh soldiers So Shivaji was defeated and a treaty was made, the Treaty of Purandar. Under the Treaty of Purandar, Shivaji were asked to go during the birthday of Aurangzeb. The Treaty of Purandar says that Shivaji, you give your territories, go visit Aurangzeb. It was during his birthday, he will be in a happy mood. So you just surrender. Surrendering means what? It's a kind of suzerainty. Okay, you don't think under the guidance of Aurangzeb you can rule your territory. But when Shivaji went and he presented his gift to Aurangzeb, he didn't accept the gift and he annoyed him. So Shivaji was house arrested. And later he was house arrested in Agra, and Shivaji later escaped from the Agra fort. Okay, in the year of 1674, Shivaji escaped from the Agra fort, and from 1674 to 1680, Shivaji he made the raving Marathas ravaged the entire South India. The entire South India was under attack. So this is during this time only Shivaji was called Haindava Dharnodharan, which means protector of Hinduism. Protector of Hinduism. Because Shivaji now he has become a very popular ruler in South. He was called Chhatrapati. Chhatrapati means the conqueror. He was called Haindava Dharnodharan, which means protector of Hinduism. So this is how Shivaji escaped. Shivaji escaped from Agra in the year of 1674. That is the reason, as Shivaji escaped from Aurangzeb's control, Aurangzeb he used to call Shivaji as mountain rat. What the rat will do? You take mountain rat itself, a species was there actually. Fontana rat, it will be in the Western Ghats area. It will be looking so big. Western Ghats and all, the Fontana rat is so big. So Shivaji mocked him. Aurangzeb mocked Shivaji as a mountain rat. Okay, so that particular event happened in December. So you may get a question on Shivaji. And the last one is, there was a question asked, what was the main reason for the split in the Indian National Congress in Surat? What is the reason? What is option A, B, C or D? B. Yeah, extremist lack of faith in the capacity of the moderates to negotiate with the British government. It is not introduction of communalism. It has happened before itself. It is not in 1907. 1905 till it came. Foundation of Muslim League 1906. Muslim League ஆரம்பிச்சதுக்காகலாம் சூரத் ஸ்பிட் நடக்கல. ஏன் சம்பந்தமே இல்லாம இந்த அரவிந்தோ கோஷ் வராரு. Arvindo Ghosh inability to be elected as the president of the Indian National Congress. So we will learn about Arvindo Ghosh because he is also in news. So Sir Arvindo Ghosh would have, if many people have the habit of traveling, you would have visited Pondicherry. In Pondicherry there was an ashram called Arvindo Ashram. You may wonder what is there in this ashram. Okay, so nothing will be there because it is a tomb. Our samadhi. அங்க என்ன பானிபூரியும் ஷவர்மாவும் வச்சிருப்பானுங்க. So அங்க போனா வேணா பட் எல்லா அரவிந்தோ ஆசிரமும் போவாங்க. His ideology is so special because he is also the supporter of Brahmanism, but originally he was basically a revolutionary terrorist and extremist. Okay, so this Arvindo Ghosh, the question is, he started a newspaper called Vande Mataram. He was an Indian nationalist from Bengal. He joined the Indian national movement for independence from British colonial rule until 1910. Was one of the most influential leader. After 1910, he was arrested, which means 1908 itself he got arrested. After 1910, he was not in active politics. He left the political life and he has become a spiritual leader. Aurobindo studied for Indian civil service at King's College, Cambridge, England. After returning to India, he took up various civil service works under the Maharaja of Princely States of Baroda. Okay, this Maharaja of Princely State Baroda was one of the most empowered Raja of that time because Ambedkar also joined under the service of Baroda. Ambedkar was also a civil servant. Dr. Ambedkar was a civil servant. Okay, because Ambedkar in the Baroda civil service, he took the 4th place. In Baroda civil service, like a TNPSC, the princely state have a separate civil service. In the Baroda civil service, Ambedkar took the 4th place. He has become the DM. But the Dawali na yaru? The person who works under the collector varanu kathittu irupaan theriyuma avan Dawali. The Dawali was a high caste fellow. He didn't respect, okay, Dr. Ambedkar. Then only he felt the DM. You see, the DM is, it's a kind of ஒரு கலெக்டர்ன்றவர் ஒரு மாவட்டத்துடைய கடவுள் மாதிரி. ஆனா அவனுக்கு கீழே இருக்கக்கூடிய டவாலியே மதிக்க மாட்டான். அப்ப எந்த அளவுக்கு ஜாதி வன்மை இருக்கு பாருங்க. அப்ப இதையே மாத்தக்கூடியது என்னன்னு பாக்குறாரு, லா, சட்டம். அதுக்கப்புறம் தான் போற சட்டம் படிக்கிறதுக்கு. Originally Ambedkar was not a barrister. He was basically an economist. Political science படிச்சார் அவர். ஓகேவா? இது மாதிரிலாம் நடந்த பிறகு போங்கடான்னு சொல்லிட்டு சட்டத்தையே மாத்துற இடத்துக்கு வரணும். ஒரு சிஸ்டம் இருக்குல்ல, அந்த சிஸ்டத்தையே மாத்துறது எதால முடியும்? சட்டத்தால தான் முடியும். வரேன் அப்படின்னு சொல்லிட்டு போயிட்டு வந்தவர் தான். அதுக்கப்புறம் தான் the rest in history. Okay, so likewise this Baroda was remembered for supporting so much of, okay, civil servant. He has become increasingly involved in the nationalist politics in the Indian National Congress. Very good. He is also one of the most important fellow in Anushīlan Samiti. This was a revolutionary group in Bengal, Anushīlan Samiti. This is like a kind of secret organization, secret society. 500 plus branches are all there. The most famous branch is Anushīlan of Dhaka. So he was, a member of Anushīlan Samiti. He was arrested in the aftermath of the number of bombings linked with this organization in a public trial where he faced charges of a treason for Alipur bomb conspiracy case. ஒண்ணு இல்ல, இவருடைய தம்பி Bairendra Kumar Ghosh. His brother's name was Bairendra Kumar Ghosh. This Bairendra Kumar Ghosh was responsible for making a bomb in a village called Maniktala. So this case was called Maniktala case or Alipur bomb conspiracy case. இவனும் அண்ணன் பண்ண என்ன தம்பி பண்ண என்னன்னு சொல்லிட்டு இவர் பண்ணதுக்கு இவர் அரெஸ்ட் பண்ணி தூக்கிட்டு போயிட்டாங்க. இவரையும் ஜெயில பின்னாடி போட்டாச்சு. After in his jail only he was, later changed. Spirituality came up and he has become a leader. However, Aurobindo could only be convicted and imprisoned for writing articles against British colonial rule in India. Okay, so this is what about Aurobindo Ghosh. So thank you, my dears. Next session, another sir will come. Hope the session is useful for you. Okay, bye. அப்படியே அந்த சந்தோஷத்தோடய படிச்சிருங்க.
Right, very good afternoon. So last classல places in news ஜென்ரலா பார்த்துருந்தோம் இல்லையா? ஸோ என்னன்னா, இப்போ கரண்ட் அஃபேர்ஸ் அப்படிங்கும்போது நமக்கு ஜென்ரலா நியூஸ் பேப்பர்லாம் வாசிக்கும் போது லைக் யூர் ஆல் ஓகே வித் தமிழ், ரைட்? Okay. Right, when it comes to UPSC previous year question papers, social sector plays a very important role. I mean, for example, there were cases like cough syrup case. I mean, there were Indian manufacturers who would manufacture cough syrups, and which led to death of around 66 children in Gambia, right? So these cases always, these are in news always. For example, huge tragedy. Yeah. So we have to analyze these things. We have to get into this, get into the base of these things, and so that we'll be able to decode a few concepts which may have the potential to be asked in UPSC question paper, right? So in that case, I'm going to handle some social sector issues that may be important for you guys, right? Fine. The first topic is, I'm sorry, I don't have PPT today. Pharmacy of the world. Now, can anyone deny this fact? I mean, India is the pharmacy of the world. Can anyone deny this fact? Okay, so you accept this one. Is there any reason for this? Why is India the pharmacy of the world? Production? Yeah. Generic drugs, yes. What are generic drugs? Okay, so these are the simpler 144 pixel of something. Right? YouTube videos, 720 pixel, you have some good quality things. And these things are replicated with a bit of modification in their ingredients. Right. So US has a lot of companies who would produce drugs which are called as branded drugs. These would be costly, unaffordable to people who people from Africa or middle income countries.
So India gets into this playground and it creates some drugs by reverse engineering. You know what reverse engineering is? Yeah, you take a product, you just study how it has been made, and you replace some costly things with cheap things. Yeah. But one thing that you must know is active pharmaceutical ingredient. For example, paracetamol is an active pharmaceutical ingredient. Now, to make it into a cough, to make it into a syrup, this active pharmaceutical ingredient must be, dissolved in a solvent. Generally, this solvent, mostly glycerol, is chosen as a solvent. This API is solved in a solvent, dissolved in a solvent. Now, the issue is 66 children have died in Gambia. And the reason? 4 cough syrups that has been manufactured by Maiden Pharmaceuticals, which has its base in Haryana. Who gave permission for this pharmaceutical company to manufacture this thing? Haryana State Drug Controller, right? So, what is the reason for this? I mean, this specific drug has been banned in India. It is not allowed to be used. Especially, this is the target group for this drug is children, right? US has designated this particular drug as poison. Then who gave permission for this Indian drug manufacturer to export this to Gambia? Yeah, we don't know, but CDSCO, the Central Drug Standards Control Organization, has given permission. We will come back to this thing. I mean, how the entire drug regulation has been made in India. But first of all, the reason for deaths of 66 children, of course, the tally has increased further, but still, the reason for this is, diethylene glycol. Now, this thing, it is a colorless, odorless solvent, a liquid, right? It is, I think it's tastes like sugar, right? Sugar solution. Now, this thing is used as a solvent. You would have seen this thing, right? Shake well before use. The reason? This active pharmaceutical ingredient within this solution must be shaked well so that diethylene glycol gets mixed well, right? So this particular thing is regarded as poison in US. And not just with this thing, Uzbekistan has also, accused few medicines. Similarly, US has accused, I think, an eye drop as not suitable for human use. So what's the first? How is this regulation done in India? Do you have any idea of what statute is behind drug regulation in India? I know that deals with the other side. I mean, illegal substances, psychotropic substances. What about the drug usage, the medicines we take? What is the statute behind this? Have anyone heard about this? Drugs and Cosmetics Act. Drugs and Cosmetics Act 1940. Under this act mandates the government to create a to create a regulatory body that would oversee the manufacture, sale, import, pricing, and all these things. In such a way, CDSCO was created, which is Central Drug Standard Control Organization. Which is headed by Drugs Controller General of India. Now, the statute consists of another 2 advisory bodies, which are Drugs Technical Advisory Board and Drugs Consultative Committee. Are you fine with the abbreviation, or should I write it completely? Drugs Technical Advisory Board and Drugs Consultative Committee. Now, these 2 are advisory bodies. They would give their own recommendations whether to accept a drug or for clinical trials, right? So CDSCO is the central body that we must focus upon. It is not a statutory body because it is not backed by a statute. It just creates a mandate that the central government has to create a regulatory body, right? Fine. Now, I already told you that there's a state drugs controller. Yeah. This statute also paves way for the creation of state drugs controllers. And I think this is the issue behind the decentralized drug regulation. Because at the same time, CDSU is regulating drugs at the central level, at the national level, and state drugs controller are regulating this at the state level. And you know where the base lies? You would have heard about the Schedule 7 of the Indian Constitution. What is it? Yeah, states, right? Union list and state list and concurrent list. Now, drugs comes under, of course, concurrent list. That's why there is dual regulation, right? States regulates it at the same time. CDSU regulates it at the center, right? Now, that's the issue behind this uneven regulation. Certain drugs which are given approval by state drugs controller are not really up to the mark. Now, you would have heard about this company, Bharat Biotech, yeah, COVID vaccine creator. Now, he has also given such a recommendation that we need a centralized drug regulation in our country, right? Instead of this decentralized drugs regulation, right? So that's all about this topic. Now, sorry, NPPA, National Pharmaceutical Pricing Authority. Yeah, it comes under Ministry of Pharmaceutical, Department of Pharmaceuticals, which is under Ministry of Chemicals and Fertilizers. We have certain drugs that people really need it. They can't afford to buy these drugs at very high rates. Generally, drugs are manufactured by corporate companies, so there'll always be market demand, and these people will fix the prices higher, right? So common people wouldn't be able to afford it. So National Pharmaceutical Pricing Authority fixes prices, which is also affordable to everyone, right? So that's all. Drugs price control order is the rule, which is the certain document that gives power for NPPA, right? Fine. Now the next one. Yeah, you would have heard about Hooch tragedy. Hooch tragedy. What is Hooch tragedy? Kalacharaya. What's the reason behind Hooch tragedy? Now, in the previous topic, I forgot to tell one thing. Diethylene glycol is the main thing that you have to remember, because it is not, people can't consume it, so it is harmful for consumption. And there was a previous year question too. I think sorbitol, yeah, whether it is definitely harmful for human consumption. So what is it? Is it a toiletry, or is it a pesticide? Is it a fertilizer? So there was a question like this. So in similar fashion, diethylene glycol may also become important, right? Now, question number two, topic number two, Hooch tragedy. What is Hooch tragedy? Of course, we said it is illicit liquor, kalacharayam. What is the problem with it? We're going to learn how this kalacharayam is prepared. Thing is, alcohol, ethanol is alcohol. The thing we consume, this alcohol, is nothing but ethanol. How is this prepared? Have you heard about fermentation? We ferment sugar with yeast, right? And some fruits are also added. So this concoction is burnt. It's boiled in a huge tin, barrel or something like that. And when this fermented solution, it boils, the first thing to get vaporized is ethanol. So this ethanol is again condensed to get, vaporized ethanol is condensed to get liquid ethanol. Simple. That's the alcohol we require. No, generally, people who drink require. So what's the issue with it? Why are people dying when they consume ethanol? Ethanol is just a thing that everyone consumes. Well, not teetotalers, others who consume. Why are people dying? Ethanol, okay. Right. Thing is, these people really don't know the real chemical reaction behind this. The temperature is very high. For example, see, they'll keep the barrel like this and they'll burn. As long as it burns, it'll heat the solution so much to a level that not only ethanol gets boiled, even methanol gets boiled. Now, this is fine for human consumption, well, up to a short term, but methanol is not fine for human consumption. That's the reason why people, after consuming this, are getting health issues. People are dying, and not just this. After all this production, these people, they're adding decomposed fruit mixture, fruit juices, battery acid, which is nothing but sulfuric acid, which, of course, by hearing it, we know that these are not good for consumption. Definitely people would die if they consume it, right? So that's the reason. The central point here is methanol. It is not fine for human consumption, right? So this is also a harmful substance. Yep.
So diet having glycol, is there any limit particular to consume or we cannot?
Yeah, generally, internet says that it is harmful for humans. They don't prescribe a limit, but most of the drugs, they are using it. So definitely there may be a limit which may not be harmful, that create harm for a short period of time. But if it has been consumed for a very long time, definitely it will be harmful, right? Because most of the drugs have this solvent. Because glycerin is used, diethylene glycol is a bit cheaper than glycerol. So diethylene glycol is also used, right? Yes, it is definitely harmful, but for a long term, it is definitely harmful, right? Now, one nation, one fertilizer scheme. Have you heard about this? What is this? One nation, one fertilizer. Because there was a few questions that UPSC has asked about fertilizers. How fertilizer is being regulated, how subsidies are provided for fertilizers. So there's a need for us to know how fertilizer industry functions in our country. Before that, first of all, we have to know what one nation, one fertilizer means. Of course, this is all about branding. We have a lot of companies that manufacture fertilizers, right? Let's say there are around 15 companies, that not exactly, but just an assumption. 15 companies that manufacture fertilizers under different brand names, right? But when farmers are purchasing these fertilizers, government supports them with subsidy. Yeah. There are different types of fertilizers, urea, NPK, muriate of potash. Yeah, there are lots of fertilizers like this. In that, farmer has to pay maximum retail price. But the market price won't be equal to MRP. Market price will be higher than this. So farmers won't be able to pay more than maximum retail price. So this price gap has been paid by government in the form of subsidies. So can you imagine that 80 to 90% of the cost of fertilizer is paid by government? Yeah. So definitely it's a debt burden for the country, for the government especially, right? After food subsidy, fertilizer subsidy is the second largest debt burden for India, after food subsidy, of course, right? Because we have PDS, we have all these things in FSA, right? So if government pays so much of subsidy, then why brand these drugs at the name of the companies? Now, the government under this scheme wants the bags, the fertilizer bags, to be branded with the brand Bharat, right? Of course, there are lots of reasons for this. First of all, what they're trying to say is 2/3 of the space in the bag that carries fertilizer must have the names Bharat and Pradhan Mantri Jan Urvarak Yojana. Yeah, the scheme name must also occupy the space. 2/3 of the space must be occupied by the brand Bharat and the scheme Pradhan Mantri Jan Urvarak Yojana, right? And the remaining 1/3 space will be occupied by whatever company that prepares it, right? So this is the general idea behind one nation, one fertilizer. But why? Why is this all these things done? Is there any reason for that? Do you know any reason? You can tell me. Yeah. Branding government is it? Huh? So, so is there any reason why எதுக்கு இப்போ கம்பெனியோட பேரே நல்லா தானே இருக்கும் எதுக்கு அப்புறம் பாரத் அப்படின்னு சொல்லிட்டு 80 to 90% subsidy is given by government, fine. So in India, fertilizer industry is heavily regulated, right? But why name with Bharat? Is there any reason? Generally, we have an assumption. Certain products produced by certain companies are fine for us. We love these brands. We follow these brands. If there are certain products, usually consumers buy these products again and again. For example, let's say if there are 5 companies that produce fertilizers, group of farmers will go behind company A, the fertilizer produced by company A. Whereas B, C, D would also produce the same thing, will be with a little bit of modification. But people buy A mostly and say that the prices of A would, when there is more demand for it, obviously the prices would rise. And finally, what the news would show you is there's heavy deficit for fertilizers. There's a demand for fertilizer. People won't buy all these things because people believe in A. They won't go behind B, C, D. So, but still, government is giving subsidies for all those things, regardless of which company prepares, which company is preparing the fertilizers, right? So now what government is doing is, regardless of which company is creating it, 2/3 of space would have Indian logo, that is Bharat, and 1/3 space will be occupied whatever company that produces it. இப்போ நீங்க கேட்கலாம், இப்போ ஏன் இது கூட தெரியும் 1/3 தெரியாதான் போகுது. Yeah, fine, that's it. Now, what do you know about regulation? I mean, the fertilizer subsidy thing that is present in India. Fertilizer subsidy எப்படி கொடுக்குறாங்க? Urea. India is the largest producer of urea. Of course, we have huge number of farmers who are using urea. And there's no doubt why India produces so much of urea. But at the same time, India is also the largest importer of urea, right? So this urea is regulated in a certain way. You have any idea how it is regulated? Urea subsidy. As I said, this MRP concept is the base thing, right? Government will fix the MRP. There was a previous year question. Fertilizer prices are fixed as per the market rates. That's definitely wrong. Fertilizer prices are fixed by government. Well, for urea. For other things like muriate of potash and all of the fertilizer that I mentioned, that is market determined. For that also, government is getting in with nutrient-based subsidy scheme. That is also a subsidy scheme, right? Now, in this case, I think it's 5,600 or something per ton. That's the MRP. Whatever price that is above this will be paid by the government, right? That's all about urea subsidy. Now, what about nutrient-based subsidy? Urea has 40% of nitrogen, but which is definitely not enough for the crops to grow. It requires other nutrients like phosphorus, potash, sulfur, right? Which will be given by the other fertilizer that I mentioned. So these fertilizers are not given subsidy in this way. These fertilizer will be given as per the amount of potassium that is present in the fertilizer, the amount of phosphorus that is present in the fertilizer as per the amount of sulfur which is present in the fertilizer per kg, right? If there's certain amount of kg of potassium which is present in the entire fertilizer, the subsidy will be given as per the amount of this particular nutrient, right? So that's all about nutrient-based subsidy. Mission life. கண்டிப்பா கேள்விப்பட்டிருப்பீங்கன்னு நினைக்கிறேன். Mission life, what is it? Yeah, that's the new thing. It's much more efficient than urea. It is cheaper, I think, and it is well soluble in water. So I think it will be more efficient than the normal urea we use. Generally, this urea is considered as a reason for eutrophication, which can be prevented by nano urea, I think, right? Fine. Now, can you tell me something about mission life? Yeah. Sorry.
Life for environment.
Environment. Yeah. Life for environment. Yeah.
Prime Minister.
Yeah. 26. Actually, he launched it in 26, Glasgow. But officially, it was launched by our ministry very recently in October, right? So, Mission Life, life for environment. Our Prime Minister has announced, or by 2028, he says that 1 billion people in India will become environment conscious and environment friendly. Their behaviors will be environment friendly. 1 billion of them. And 80% of villages and urban local bodies would also be becoming environment friendly, right? Now, there's a tagline that they have given for this scheme, P3 model. Pro-planet people, they say. Fine. So this is something that was launched by Prime Minister Modi himself, in the last whatever COP he was launching. Now it was officially launched under this head, Mission Life, which is the life for environment, the same thing. There's nothing new in this. These targets may be new, and this particular tagline may be important, right? So as the Constitution is framed by the people, for the people, and of the people, this thing is also done in the same way, by the people, for the people, I mean, by the planet, for the planet, and of the planet, right? That's P3 mode. Next one is Global Hunger Index. This created a huge political fuss. Global this index, obviously, it is released by a certain group of NGOs. Who releases them? Wealth, Hunger, Life, and Concern Worldwide. Yeah. Concern Worldwide and Wealth, Hunger, Life, which is nothing but a German-based NGO. Now, they usually release Global Hunger Index as an yearly index, which would always bash India's status of malnutrition. We have done a lot of things in terms of malnutrition. We have given NFSA, National Food Security Act 2013. We have huge range of schemes, like we have ICDS, we have Supplementary Nutritional Program, we have Mission Vatsalya, Anganwadi, Poshan 2.0, yeah. So even after bringing so much of schemes, this particular index is ranking India 107 out of 121 or something, right? The previous year, we ranked at around 101. We really can't understand how this thing falls. Well, there are particular reasons that they're saying that the ranking is based upon 4 criteria. What are they? You have any idea about that? What are the 4 criterions? Sorry? Yeah. This is not much significant in terms of UPSC questions, but still, knowing these would be helpful for your mains answer writing. Right? Child wasting, stunting. Wasting refers to low weight for the height, and stunting refers to low height for the age. Right? Child mortality. And finally, undernourishment. GHI usually, I mean, the index usually allocates certain amount of weightage for all these criterions. At some years, child wasting would gain more weightage. At some years, undernourishment would gain more weightage. Depends. But unfortunately for India, whenever India tries to do something, for example, let's say in undernourishment, GHI fixes the more weightage for any other criteria, so that we usually fall in GHI. And the most, disrespectful thing that would happen to a nation is when your neighbor countries rank much better than you. South Asian nations, let's say Pakistan, Bangladesh, all these nations are ranking good. And with India being a leader of Asia Pacific and Indo-Pacific, all these things, this is a bit of, not a good thing for us. Right? So what are the schemes that we are generating? Not just Global Hunger Index, our own survey, National Family Health Survey, has also said that we're not faring good. Well, maybe in undernourishment, we may be faring good. But in terms of, and child mortality, in these 2 things also, we may be faring good. But the other 2 things, we're still facing 30% of child stunting and wasting, still. And there are many other reports who usually strengthen this fact. So there are issues related to implementation of programs, right? There are programs, there are a huge number of programs, as I said before. I'll list them out. But what about implementation? Now, there will be a lot of issues. Yeah. Now, what are the programs we have in terms of whether there are 3 heads under which most of the schemes have been tagged? One is Saksham Anganwadi. And Ocean 2.0. This deals with children who are at their preschool level and from classes 1 to 8. This deals with midday meal scheme, integrated child development services, and all these things. And the second one, Mission Vatsalya. Third one, Mission Shakti. And to eliminate hunger, we ultimately have NFSA 2013. There was a question before about NFSA 2000. This act, right? The adult female member of the family, in her name only, ration cards will be issued. There was a question, you may remember. So yeah, strengthening your idea about NFSA is very important here. Please take a look at this thing after the class, right? So yeah, here, Mission Shakti. Now, what is this related to? Women empowerment. Yeah. Now, Mission Shakti is about women empowerment. It comes from the Ministry of Women and Child Development. It has 2 branches. What are they? Sambal and Samarthya. Right. Under Sambal, security related issues are being handled. I'll list them out. One-stop center for women, women helpline, and one of the umbrella schemes of the government, Beti Bachao, Beti Padao, it is also included under this thing. Nari Adalat is also under this Sambal sub-scheme. Under Samatya, there are certain schemes like Ujwala, Swadhar Grey, Working Women Hostel, Pradhan Mantri Matru Vandana Yojana, National Creche Scheme. Right. So we can't explain the entire thing today because due to the limitation of time. Right. We'll move on to the next topic now. What do you think about suicides in India? Suicides in India. We started with diethylene alcohol, which killed 66 people. We moved on to Kalacharayam. Yeah. Exactly. How many of you belong to sociology option? Taking sociology. You have a bit more idea about suicide, right? Right. Because we have learned it in Durkheim's theory. Right. Now, as per NCRB data, they're saying that the minimum 1 lakh deaths per year. And usually, the rate of suicide is high in urban areas. Of course, the rising individualism, all these things may be the reason. And the worst thing is the rate of suicide is increasing in the last 3 years. So India has taken few measures, few initiatives to handle with this thing, which is National Suicide Prevention Strategy. Now, its goal is to reduce suicide by 10% by 2023. Well, unfortunately, 2023 has already been going on. So I don't know whether this will be successful or not. Right. See, there are 3 objectives under National Suicide Prevention Strategy. One is surveillance. Within 3 years, there must be robust surveillance facility that will be created for prevention of suicide. Secondly, psychiatric OP, outpatient. This facility would be created. This thing, surveillance, must be created within 3 years, psychiatric OP within 5 years, and finally, this thing, suicide prevention as an aim, as an objective, must be inculcated in educational curriculum within 8 years. Right? Now, the stakeholders who are involved in National Suicide Prevention Strategy are, well, we definitely have a lot of district health centers, which are headed by state centers and which are headed by national centers. And we have a center of excellence for it, NIMHANS, Bangalore. This will be the expert partner for this strategy, right? Hope we reduce this thing soon. Right. Now, the final topic for today, MG Narega. Mahatma Gandhi National Rural Employment Guarantee Scheme. This has been in news for a very long time, and you people as serious aspirants would have read it more than a dozen times. So you're going to answer me. What is the issue with Manrega? First of all, do you know that Manrega, right to work, what is this? Is it a constitutional right? Is it a fundamental right? How? Okay, that may be an assumption. Of course, அதுல இருந்து நம்ம வந்து கொஞ்சம் வெளியே வந்து ரைட் டு லைஃப்ல இது இருக்குன்னு நம்ம அசியூம் பண்ணிக்கலாம். சுப்ரீம் கோர்ட் ஜட்ஜ்மெண்ட்ஸ்ல கூட அந்த மாதிரி எடுத்துக்கிறாங்க. பட் டு பி ஃப்ராங்க், நேரடியா சொல்லணும் அப்படின்னா, ரைட் டு ஒர்க், வாட் இஸ் இட்? இஸ் இட் a fundamental right? கம் டு ஆர்டிகல் 19A, சொல்லுங்க. ரைட் டு ஸ்பீச் அண்ட் எக்ஸ்பிரஷன் அதுல கொஞ்சம் இருக்கு. பட் டஸ் இட் இன்க்ளூட் ரைட் டு ஒர்க்? In directive principles of state policy, we have something related to right to work, but that's not a fundamental right. And that's not even constitutional right. It is a statutory right. Right to work is a statutory right, which is guaranteed by MGNREG Act. Right to work. Now, we can't take this in literal sense. If we go with Supreme Court judgments, Supreme Court will see this in some other way, because they would say that this is a constitutional right. See, we need not get deep into these kind of issues, right? But at the paper, at the policy level, it is said that Manrega gives statutory right for people, for the right to work, right? We all know that in rural background, in rural areas, people are suffering from certain types of unemployment. What are they? Unemployment, disguised unemployment, seasonal unemployment. So in order to handle this, government had to bring some sort of employment scheme, which is Manrega, right? It gives the right to work. Minimum 100 days of work is guaranteed for at least one person from a household in a year, if the person wills to do work. That's important. And one more important objective of this is, come to Article 48A. What is it? What is it? 48A. Protection of environment, of course, TNPSC. In order to protect environment, now Manrega has a bit of connection with protection of environment. You know, most of the Manrega works are related with public, you know, ponds, water body maintenance, and all these things. So we can have that in under Article 48A, right? Not directly, but indirectly, right? There's this objective of creation of public assets, because we have heard that people are recruited just in paper who does or who do no productive work, right? People are being recruited. People are shown that they are, you know, the government has given report that they are working and creating some kind of productive asset. But in reality, they're not really creating assets. Right. So it must be, you know, it must be brought under surveillance. Proper report must be made, and this is very important for your, you know, main topic, because it has been asked, and there are high potential. Because in recent budget too, the amount of budget allocated was reduced a bit, right? So Manrega becomes important, and few other things that I would like to say about Manrega. Of course, the one thing which the statute guarantees, 1/3 of work must be guaranteed for women. Therefore, the Act guarantees gender equality. These people who are ready to work, they are issued employment cards, just like ration cards. And these cards are issued by none other than Gram Panchayat. What if people are not given certain work as the Act says? ஒரு நாள் வேலை தரேன்னு சொல்றாங்க. What if they're not given work? Unemployment allowance, right? Within 50 days, அவங்க வந்து register பண்ணி, people are registering to get a job under this. Within 15 days, they must be given a job in whatever sector it will be. If not, then they must be given unemployment allowance. And there are a few other minor things that are mentioned. There must be social audit. That is Gram Sabha getting into the field, watching the entire thing, whether really the work is being done or not, right? Okay, there are a few other minor things that they are paid. I mean, a minimum wage is being set by the government, and it varies upon states. States may give as per their own criteria. The wages are given as per time rate. I mean, the number of hours they are working, or piece rate basis. I mean, the amount of goods they are producing. Right. On these basis, salaries, wages are given, and the annual report for the functioning of Manrega is being produced by Central Employment Guarantee Council for the Parliament and State and Employment Guarantee Council for the states. Right? Now, all these things are guaranteed by this particular statute. We really don't know what is happening on the field. Right? There are lots of issues. Like work நடந்துச்சு அப்படின்னு சொல்லிட்டு the receipt bill எல்லாம் கொடுப்பாங்க. அந்த பில்லுல நம்ம பொதுவா ஜெனரலா இந்த கன்ஸ்ட்ரக்ஷன்ல பண்ணுவாங்க இல்லையா? There is particular work done, there are particular goods. For example, let us consider construction sector. They would give receipt to the contractor that they have bought good quality goods and all, which would cost higher. But in reality, they would have bought around, mediocre quality goods. So they are manipulating the receipts and they're getting more funds from the owner. In this case, the owner is government. They're getting more funds. There are huge amount of leakage of this fund that is being allocated. And there are very, so much amount of issues that we can discuss for very long. So that's all. There are lots of social issues that occur during these 2 months, in October and November. And so these are the 6 most important issues that I discussed. There are lots of other issues too. For example, right. So the thing is, the main idea is, whenever some kind of social issue happens, you have to dig deeper into it. அதுக்கு ஒரு political angle இருக்கும், அதுக்கு ஒரு economic angle இருக்கும், and it would have some kind of statutory angle கூட இருக்கும். அதுக்கு ஏதாவது ஒரு சட்டம் இருக்கும். For example, இப்போ mining, there will be coal mining. நமக்கு வந்து coal பயங்கரமான shortage இருக்கு அப்படின்னு சொல்லியிருப்பாங்க. There was huge amount of coal shortage in this. There was a reason. Actually, mining has been regulated. Mines and Minerals Development Act தொடர்ச்சியா இந்த மைன்ஸ் அண்ட் மினரல் செக்டார்ல இருந்து கொஸ்டின்ஸ் கேட்டுக்கிட்டே இருக்காங்க. ஒன், இப்போ சில கொஸ்டின் பேப்பர்ல நம்ம பார்க்கலாம், they would ask questions related to which are minor minerals, which are major minerals ன்னு கேட்பான். சில இடத்துல வந்துட்டு river sand அப்படிங்கிறது வந்து whether river sand is being regulated by state government or is it unregulated. சில நேரத்துல வந்துட்டு monazite sand பத்தி கேட்பாங்க. Right? All these circle into one particular point, which is nothing but mining. So these are UPSC's favorite sectors. Similarly, nuclear energy is being focused. At one stage, people, they would ask about civil nuclear agreement. At the other stage, they would ask about, again, monazite sand பத்தி கேட்கலாம். Relevance of IAEA. So இந்த மாதிரியான questions கேட்கலாம், right? These are current affairs questions, which உங்களுக்கு அதை பார்த்த உடனே current affairs பார்த்தோன்னே இதுல இருந்து வரும் அப்படின்னு சொல்ல முடியாது. But you have to dig deeper into it, right? And UPSC question is also getting a bit more complicated. So definitely we need to work, right? So all the best. Thank you.